the Gumbys actually didn't pay regular rent at all, even though there was an agreement the agreement was for $1,400, which was somewhat below market in exchange for the Gumbys kind of keeping up the maintenance on the home. But the Gumbys did not regularly pay any sort of rental, to the Badhams.
Not routinely, or?
No, not routinely.
Okay. I mean, I guess, let me clarify. Is it that there were periodic payments, they just weren't consistent? Or is it that every once in a while they just say, here's some money? I'm not quite sure I'm following.
I'll get to that. So what Mr. Badham did do was he kept a running tally, essentially, of what was owed, both on the personal loans, on the interest, on the utility payments, and on the rental. He kept basically a running tab.
Okay.
And periodically would send this to Mr. Gunby, just to kind of keep him up to date. All that is really kind of beside the point, because when we get to 2018, the parties had discussions about Mr. Gunby purchasing the property. And the parties did enter into a 2018 agreement, which is a one-page agreement that they didn't have any, well, I shouldn't say that. I don't know who prepared it. It's a one-page agreement, and it sets forth a purchase price for the property and a schedule of payments. So the agreement was in 2018, I believe it was June of 2018, and it was for a 3-year term. And it was going to be a series of $8,000 monthly payments with a balloon payment of approximately $200,000 due in June of 21. And the total, the listed price of the property in the agreement is $450,000. The principal listed price is $450,000. But then with the interest, if you add up all the payments with the interest rate, it's a total of approximately $501,000 in total payments that had to be made under this agreement. And the agreement does specify that this balloon payment date is the termination date of the agreement.
So the agreement, if the balloon payment is due in June of 21,
That's right.
Then the parties expected that the agreement would terminate either because the payment was made and ownership transfers, or because the payment wasn't made, and then there would be a question as to the entitlement of the Gunbys to remain in the house. Is that am I understanding that?
I think, yes, I think there's a dispute as to that, like what the parties thought was going to happen after the end of the agreement. I think that's why there's counterclaims.
But that was in 2021.
Yes, that was in 21.
Thank you.
Certainly, I believe it was my client's expectation that the property would be purchased by that point in time. In any event, only 2 of the installment payments were made in the correct amounts. The first 2 $8,000 payments were made, and then after that, Mr. Gunby paid in varying amounts, and then stopped paying altogether in the middle of 2019. So from June of 2019 throughout all of 2020, there were no payments made. A few additional payments were made in early 21, but the sum total of all the payments made prior to the expiration or the termination date of the agreement was approximately $114,000. So that's what was paid under the term of the agreement. It's not disputed that after the termination date of the agreement, that Mr. Gunby continued to make payments to Mr. Badham. But at the time, Mr. Gunby owed Mr. Badham over $600,000.
Just for the house or for other things?
For all of the debt.
Okay, because my understanding is that not at issue in this case, but sort of the background is that Mr. Badham alleges that he had loaned other monies.
That's right.
Personal loans, et cetera, to Mr. Gunby.
So Mr. Badham's contention would be that he's accepting these payments towards the other debt that is owed to him because the agreement has expired.
Not that that's before me, but is any of those personal loans, are they similarly documented to this agreement?
I don't believe they are documented.
Okay.
Yes. And we're not seeking them in this case.
No, I understand they're not an issue here. I just was curious.
Yes. Not documented, other than the spreadsheets that were exchanged between the parties. That reflect the running balance. After, again, some payments were made, the evidence will also show attempts by Mr. Badham to get Mr. Gunby to complete the purchase of the house under new terms. So once the agreement has expired, there are emails and proposed agreements sent between the parties to reflect new terms that the parties could agree on so that Mr. Gunby could complete the purchase. But the reality is Mr. Gunby never was able to come up with any of the funds to complete the purchase. I mean, even under his admitted the amounts that they have claimed to have made under the agreement totals only $452,000, which does not get you to the $501,000. So even another factor in the parties' relationship is that in the summer of 22, the parties entered into a business relationship together for a company, a Bahraini company in the Middle East.
Okay.
And there was an employment agreement signed between the Bahraini company and Mr. Badham. This specified a salary to be paid to Mr. Badham.
Is Mr. Gunby the owner or the principal member of the Bahraini company? Okay.
Mr. Gunby was the owner of the company. And the company is, I'll spell it for the court, but also pronounce it, Connaught, Connaught.
That sounds like a very British name.
Yeah. And both of the, Mr. Badham and Mr. Gunby are both British.
I gathered that from the communication about Mr. Gunby. I was unaware of that about Mr. Badham.
Yes. So do not be alarmed by accents.
I'll not be alarmed, more charmed,
Yeah,
right? Since
that's right.
Americans seem to love a good British accent.
Try not to fall under his spell. Yes. So a business relationship was entered into in the summer of 2022. And so what we would contend that the evidence will show is that many of the payments that were sent to Mr. Badham by Mr. Gunby beginning in late 2022 and throughout 2023 were reimbursement expenses for this Connaught company. But setting all of that aside, we never get to the purchase price of the house, nor is there ever any agreement on extending the terms of the original agreement. So fast forward a little bit to April 24, 2024. The Badhams' circumstances had changed. They were living in Europe at the time. And they desired to move back to the States so that their son, who was in middle school at the time, could begin high school in the fall of that year. Mm-hmm. So in the spring, they asked the Gumbys to please, vacate the property by the summer so that they could move back. Instead, they were not met with acquiescence. There was no agreement to vacate. There was just continued staying the property, without really an explanation other than it's unfair. There was no claim that we had the right to be here. There was no claim that we had complied with the terms. Just considering all the circumstances, we don't feel that's appropriate, and maybe you could find another place to stay for the few years while your son is in high school. And they also got an attorney letter. They also got a letter from Mr. Withers in July saying that we understand you've asked our clients to vacate, but we believe we have a right to purchase the property. And, if you file an eviction, we're going to counterclaim against you. So ultimately, they had to retain counsel, and we hired my law firm. We demanded possession. They did not vacate, and so we filed the eviction action in Fulton State last fall. And we had a hearing on the motion to compel rent, payment of rent to court so that they could remain in possession while the case was pending. And they have done that. So they have remained in possession throughout the entirety of the case. So the entirety of the Badham's son's freshman year, the Badhams had to rent a townhome in the same school district. So the son did not get the benefit of living there. So all the last school year, they rented a townhome. They're still renting in Sandy Springs, so that, ultimately when they are allowed to reenter the home, that their son can remain in the same school district. So we just plan to call Mr. Badham as a witness. He will explain the background and the circumstances that I just kind of gave an overview of. And briefly, we'll call Ms. Badham to talk about when she asked the Gunbys to move, what occurred. But that's it. And all we're asking the court for is a writ of possession and the Badham's attorney's fees for having to bring suit. I believe the rent has already been addressed by the state court.
Right, and it is being paid.
It has
I
continued.
checked as of today.
Yeah.
It's been correct.
Yes. And that will be another issue we need to address with the honor at the end, but we can't get the rent out without an order from your honor now that it's superior court. But we'll address that at the end. But yeah, so the rent is not an issue. At least the rent as far as the mortgage payment. I think the rent is not actually the fair market rent. It's actually just the mortgage payment and the utilities. So we will be ultimately asking for a modified order to reflect fair market value if they do want to appeal this case further.
Okay.
To account for that. But all we're asking for is for the Badhams to be, reunited with the home that's theirs and that they have the right to possess. And again, there are no written documents that would allow the Gunbys to stay. There's no lease and there's no valid purchase agreement. So that's all we're asking for. Thank you.
Okay. Thank you, Mr. Downs. Mr. Withers?
Good morning, Your Honor. Again,
Sir.
Knox Withers and Arnold Golden Gregory. And I obviously represent the defendants and counterclaim plaintiffs, Matthew and Kim Gunby. This is not your standard run-of-the-mill dispossessory case where the tenant has failed to pay amounts required under a lease agreement. This case isn't clean, and I don't think this case is simple. If this case were simple, if this case were clean, I don't think we'd be here. This case, instead, is messy. You've got parties who attempted to document some of their own transactions themselves without the advice of counsel. You've got other transactions they didn't document at all. You've got my clients who failed to adhere to the strict terms of the parties' agreement. And you've got the Badhams who acquiesced to inconsistent performance by my clients. Those are all factors that take this case out of the realm of the ordinary. Now, factually, I think that most of what Mr. Downs related is accurate. But again, this case is nuanced, and not everything can be categorized as black and white. I'm going to try not to repeat everything Mr. Downs said about the background, but yes, Mr. Gunby and Mr. Badham had been business acquaintances, and that relationship eventually evolved into a friendship. And again, in 2013, the Gunbys were experiencing some financial hardship. That is a fact of which the Badhams were aware due to their friendship. And as Mr. Downs said, at that time, the Badhams were living in Europe. I believe it was Spain. And the house that they owned at 6365 Coalwood Court in Sandy Springs had recently become vacant after some of Mrs. Del Rio Badham's relatives moved out. So they offered to allow the Gunbys to take up residence there, which was an opportunity for which the Gunbys were very grateful. At that time, the parties did not enter into a written lease or a rental contract. But in 2016, Mr. Badham and Mr. Gunby began discussing the possibility that the Gunbys would purchase the property. And for whatever reason, it took a couple of years for those discussions to materialize into an actual agreement. On May 5th of 2018, Mr. Badham and Mr. Gunby did enter into a written purchase and sale agreement. As Mr. Downs said, the Gunbys would purchase the property for the principal amount of $450,000. And as he said, they were to make 37 payments of $8,000 each with a $205,000 balloon payment on June 30th, 2021.
So let me just back up and make sure in terms of y'all's agreement or disagreement on the facts. So it seems like there's not a disagreement that the Gunbys moved into the house in 2013.
No disagreement.
And then as you said, for whatever reason, nothing was ever finalized or memorialized in terms of the terms of their continuing to remain there until the purchase and sale agreement was negotiated in 2018.
That's correct.
Okay, thank you.
And likewise, there is no dispute that the Gunbys failed to make all of the payments as and when due. Instead, the payments were sporadic. Sometimes they paid less than what was due. Sometimes they paid more or significantly more than what was due on a given date. Some months, as Mr. Downs pointed out, they didn't make payments at all for months. Nevertheless, the amount of money that the Gunbys paid was substantial. And despite the sporadic nature of those payments, the Badhams never sent a default notice. They never sent a notice that they were terminating the purchase and sale agreement. Even after June 30th, 2021, they never advised the Gunbys that the agreement had terminated.
What about though, and I'm sure I'm going to hear this in terms of the evidence that will be presented, but I think I understand the Badham's position to be that most of those payments that were made periodically after the purchase and sale agreement either were intended for or were unilaterally received and accounted for by Mr. Badham as payments for other things, not the house.
We dispute that.
Okay.
After June 30th, they continue to make payments and the Badhams continue to accept those payments. And we contend that in total, the Gunbys paid approximately $437,000 towards the purchase price of the property before the commencement of the dispossessory proceeding. Now, Mr. Downs mentioned $452,000, as I'm sure he will draw out on cross-examination of my client. My client did misapply a handful of payments. I think it was maybe 4 or 5 that in deposition, in discovery, my client said these were for the house, and it turned out he was mistaken on that.
Okay.
But those aside, our position is that we've paid $437,000 towards the purchase price of the house pre-litigation. Additionally, the Gunbys made significant improvements to the property. In total, they spent over $276,000 in renovations and repairs, and those improvements resulted in a significant increase in the value of the property. In April of 2024, as Mr. Downs said, the Badhams decided they wanted to move back to the United States. They demanded that the Gunbys move out, and the Gunbys refused because of the significant payments they had made to the Badhams and the valuable improvements they had made to the property with the expectation of completing the purchase. So in August of 2024, the Badhams filed this case. We asserted counterclaims, and Your Honor asked us to, identify what are the claims. We have asserted a claim for breach of contract and specific performance, and alternative claims for promissory estoppel and unjust enrichment. And we had initially asserted claims for fraud, negligent misrepresentation, intentional infliction of emotional distress, and punitive damages, which claims we have since withdrawn. But because my client's counterclaim sought equitable relief, the Gunbys moved to transfer the case to this court. And before that transfer and over objection, the state court ordered the Gunbys to pay over $60,000 into the registry, representing both the utilities and the rent that the Badhams claimed were due from November of 2022 through October of 2024. And again, or in addition, the state court ordered the Gunbys to pay $2,580 a month.
In order to maintain possession.
To cover the mortgage payment and to cover utilities. And my client, as the court noted, has done so. I would like to focus on 5 things that I think the evidence in this case is going to show. Number 1, there was never any written lease agreement or rental contract. Not in 2013 when the Gunbys moved in, not in July 2021 after the last scheduled balloon payment was due, and not at any other time. Number 2, and related, the only written contract at all between these parties is the May 5th, 2018 purchase and sale agreement. Again, it was $450,000 at 5% interest, which, as Mr. Downs noted, you add it all up, it's a shade over $501,000. And it provided that if the Badhams wanted to cancel the agreement, they had to provide written notice, and all payments made prior to the written notice of cancellation had to be refunded. And it expressly provided that no rental payments would accrue or be payable. Number 3, the Gunbys made substantial payments towards the purchase price. Again, we concede that those were sporadic, but significantly, the Gunbys made the majority of those payments after June 30th, 2021, when the final balloon payment was due. My clients made those payments with under the good faith belief that they were still entitled to purchase the property. In fact, in September of 2022, Mr. Badham expressly told Mr. Gunby in writing that, quote, the deal did not end on July 1st, 2021. In total, as I mentioned, they've paid over $437,000 towards the purchase of the property, and over $300,000 of that was after June 30th, 2021. And $65,000 of that was paid after Mr. Badham expressly told Mr. Gunby that the deal did not end on July 1st, 2021. Number 4, the Gunbys made substantial improvements to the property. When they moved in, certain portions of the house were or the property were in poor repair, and the Gunbys made improvements based on the Badhams' assurances that they should treat the house as their own, and after executing the purchase and sale agreement, that the house was theirs and they could do with it as they wished.
Are we talking about routine maintenance plus potential repair, or are we talking about remodel?
We are talking about well, I think the $276,000 was necessary. It was remodeling, what I would consider to be major capital expenditures.
So it sounds messy, right?
Yes.
In the sense, as you pointed out, that it was going to be. I guess my question, I'm trying to, are we talking about, plaster's cracking and needs to be repaired, the roof is leaking and needs to be replaced, or are we talking about the kitchen's outdated and we'd like a new one with better appliances?
Some of both.
Okay,
Thank you. Some of the repairs were absolutely necessary. You'll hear testimony that they put a new roof on the house. There was a retaining wall that collapsed and that they had to, repair. There was electrical issues. There was HVAC issues. There were plumbing issues. Others, admittedly, were discretionary. But one thing is certain. Beyond normal wear and tear and routine maintenance, the Gunbys spent a significant amount on capital improvements and renovations that no mere renter would ever spend on a property that they did not believe in good faith that they were working to purchase. And finally, as I noted, the Badhams never canceled the purchase and sale agreement. Notwithstanding that the payments were admittedly sporadic and inconsistent, the Gunbys, again, have paid $437,000 directly to the Badhams towards the purchase of the property. That amount does not include the $77,000 that the Gunbys have paid into the court's registry. And that $77,000 that's the $77,000 that covers the mortgage. That's, once you add in the utilities, it's like $92,000 or $93,000. So,
But to be clear, the mortgage belongs to the Badhams, and the money that's being paid into the registry, because it's still sitting in my registry, right? It would reimburse the Badhams potentially, but they are currently still being required to make mortgage payments on that property. Is that right?
I would assume so. I mean, Mr. Badham testified in deposition that the balance of the mortgage was between $100,000 and $200,000, I believe. So I am assuming that he has not yet paid that off. And I don't dispute. I don't think I was aware that the monies had not been taken out of the registry and paid to the Badhams. I for some reason I thought they had been getting that money from the registry.
I think there's a procedure by which you can make application to receive those funds as they're paid in, but it gets a little clunky with the clerk because as it should be, they don't like to pay out money.
Sure.
Unless it's very clear that they're supposed to pay out that money and to whom.
Right.
So yeah, as far as I'm aware, those funds are, the vast majority of them, if not all of them, are still sitting in there.
Okay.
So I do want to correct the record. They have gotten the vast majority.
Oh, okay.
It's only since the case was transferred to Superior Court that
I
the
see.
money is still.
Okay. That's the money I was talking about. I honestly disregarded the fact that the bulk of it would have been paid in the city court.
But in any event, the Badhams continued to accept all of those payments, not once sent a default notice due to a missed payment, not once issued a notice that the purchase and sale agreement was terminated, not once did they offer to refund any amounts that the Gunbys had paid to them, as you'll see is required under the contract, and not once did they offer any compensation to the Gunbys for the significant improvements that have added significant value to the property. So at the conclusion of the presentation of evidence, we believe that the court will agree that what the Badhams are seeking to do here is simply unjust. And we're going to ask the court to award the Gunbys an equitable remedy. Specifically, we're going to ask the court to find that the Badhams have breached the party's contract. And we're going to ask the court to enter an award compelling the Badhams to complete the sale of the property to my clients. And even if the court finds that the Gunbys breached the party's contract, notwithstanding the lack of any, declaration of default or termination of the agreement, but in light of the continued acceptance of the payments, but even if the court finds that my clients breached the contract, we assert that the Badhams are promissorily estopped from now declaring a breach and a termination, and that justice requires that they be compelled to complete the sale of the property. We do not believe that the court is going to find that the Gunbys were mere tenants at the property and that the Badhams are entitled to resume occupancy. However, if the court does find that the Badhams are entitled to possession, then we will ask the court to find that the Gunbys are entitled to significant compensation. The amount that the Gunbys have paid since May of 2018 far exceeds what they would have paid in rent over the same period of time. And the improvements that were made were substantial. And so if the court finds that the Badhams are entitled to resume occupying the property, then we contend that the court should order them to reimburse the Gunbys for the amounts that the Gunbys paid in excess of a reasonable rental value, as well as the value of the improvements to the property that in that scenario, the Badhams would be allowed to enjoy. So that's what we believe the evidence will show, and that's what we're going to be asking the court at the end of the trial.
Okay.
Thank you.
Thank you. Okay. Mr. Downs, you may call your first witness.
Housekeeping wise, how do you want to handle this?
You mean in terms of timing?
Yeah,
because it's noon.
Yeah.
So since we just started at 11, I was planning to at least get a little bit started and then take a shorter lunch. So I would say let's keep going until at least 12:30, find a natural stopping point, and then we'll take about a 30-minute break for lunch.
Totally fine.
Okay? Does that work for everybody? Excellent.
Yes, ma'am. Good.
Okay.
Take this.
Don't worry, Deputy. I'll swear him in. Thank you, though.
I'd like to call Keith Badham to the stand.
Mr. Badham, if you'll come up, there's a step up there, and it's a rolling chair.
I'm embarrassing myself.
Why? So be cautious. I have had people take a tumble. Before you have a seat, will you raise your right hand? Do you swear the testimony that you're about to give the court will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You may have a seat if you'll get situated up to the microphone and then state and spell your name for the court reporter.
Okay, my name is Keith Badham. It's Keith Badham.
And I meant to tell you lawyers, you haven't done it so far, but there's a sticky on that microphone that says don't touch it. Bad things happen when you touch that microphone.
This one, okay.
Yes. Yours may say the same thing, but you're free to it. Careful.
I'm not-
There's a ledge behind you and you're on a rolly chair, so.
Gosh, I'm going to slide off. I'm
That's what I'm trying to
one
avoid.
centimeter away from doom. Okay.
But you're free to adjust up to the microphone and make sure that you can be heard, particularly by the court reporter.
Okay.
Thank you. Go ahead, Mr.
Make
Downs.
sure you're captured on camera too. Here, looks like you're in there pretty good.
Mhm.
All right. All right, Mr. Badham, good morning. How are you doing?
Good morning. I'm doing great.
Okay. We're here about 6365 Colwood Court. Can you tell the court your relationship to that property?
I'm the owner of that property together with my wife. Yeah.
Okay. And how long have you owned it?
I think we purchased that property in 2006.
And you don't currently live there, correct?
No.
Did you ever live there?
Yes, we lived there from the day that we bought it, 2006, through to 2010, when my company transferred me to Australia, actually. Yeah.
And since 2010, have you ever been resided back at the property?
No, we haven't.
Okay, gotcha. And how did the defendants in the case, the Gumbys, come to live at Colwood Court?
Well, in 2013, Matthew Gunby reached out to me when we were away, living in Spain at the time, because we transferred. I moved around a lot. So he reached out to me and said that he was in some financial difficulty. And would it be possible to borrow some money? And so I discussed it with my wife and we said, sure. I think you described our relationship as sort of business acquaintances, but, it was probably a little bit more than that. I mean, we were very friendly. And so we thought that it was the right and proper thing to do to help them with some money. So we gave them some money. So that was in 2013, and then I don't know when in 2013 that started, but that started the relationship where because we hadn't seen each other in many years because we've been traveling and the Gumbys had moved back to England for a spell and what have you. So what happened then is that then I got to know a bit more about their financial difficulties. And Matthew said that he wanted to move back to America because he felt he could have more opportunity, more work opportunity there. But he didn't have credit. I think that, they'd had a house foreclosed and what have you. So he had no money, he had no financial difficulties. So what had happened is that I had the house, Colwood Court, had been used by my sister-in-law and her family for 3 years because they too had some financial difficulties after the financial crash and needed a place to recover, which they did, and they're very successful and happy now, which is good. And they just moved out, and I was going to sell it because we were not in the country, and I didn't know when my company was going to transfer me back to the US or what have you. It was not definite. And so we put it on the market, but it was absolutely the bottom of the market. It was the end of the financial crash. And we had a couple of offers, but I wasn't in a position to have a fire sale. So I said, nah, I'm not going to do that. At this time, Matthew had moved back to America and he called me and said, hey, do you still have the house at Colwood Court? do you think it would be possible if we could move in? Because we have nowhere to live and they have a large family. They have four kids. I mean, I don't think they were at home at then, but maybe, I don't know. But we want to keep the family together and your house would be great if we could move in. Again, I discussed it with my wife and we said, sure. Initially, I asked him to pay, because he offered to pay money, of course. I said, okay, well, you just cover the mortgage, and I think we'll be okay. Because honestly, the impression he gave was that he was going to get back on his feet, he was going to get a job, and then he would go buy a house and, start his life again, which is what, say, my sister-in-law had done with the house. He said that he could only afford $1,400 a month, which is less than the mortgage payment, right? So, well, we said, okay, because we thought, okay, it's going to be a short time, whatever. We didn't sign a lease. He was a friend and we were helping a friend in need. And, we're guided by our faith to help people out. And, that's just what it is. It may be, with hindsight, it may be a little bit foolish, but, we're not going to stop doing helping folks out. And in fact, we've helped probably 6 families in Atlanta with the properties that we own who have been in dire straits over the last 20 years. So he, said, okay, I can afford $1,400. I said, fine, do it $1,400. Honestly, I anticipated this would be a year, maybe a bit more. And then he proceeded not to pay for 15 months. So we were not receiving any money. I was paying the electricity bill and the water bill and the gas bill all through this time. And then they, after that, started to pay. And that's really where the whole Colwood Court story started with the Gumbys. Okay. Yeah.
Let me interrupt for just a moment and just clarify what you just said. I think I understood you to say that during that 2013 to 2018 period that the Gunbys were paying the utilities, the power and stuff, but you were paying the mortgage, or you were paying all of those things?
I was paying the mortgage. Mm-hmm. I was paying probably for the first 18 months, I was paying all the utilities in total.
Okay.
But I had asked them to transfer the utilities, absolutely, but they only transferred the gas bill for some reason.
Probably because the utility companies won't accept it without proof. Right.
Well, maybe there's something there. I don't know. But anyway, I continued to do that because our agreement was that the Gumbys would reimburse us that money. I mean, I was not expecting to be less than from this enterprise.
Understood.
Right? So through 2018, that's what happened. That they paid some money, they borrowed more money. I ended up giving Matthew over $100,000 in loans. Like I said, continued to pay the mortgage, which was more than the rent that they were supposed to pay, the utilities, and the reimbursements were sporadic and what have you. So that was really the relationship, prior to the purchase.
How did you have any sort of understanding on keeping up the property?
Yeah. In exchange for giving the Gumbys a very low rent, they agreed that they would maintain the property. Now, if anything major came up that required the insurance, because I maintain the insurance on the property, of course, I have no idea whether they ever took out renter's insurance or anything. I have no idea, but I absolutely have always maintained the homeowner's insurance. If anything happened that required insurance, then they would call me and I would contact the insurance company. They did that for the retaining wall, for example. So that was it. Yeah.
And so your testimony is that the Gumbys, for a period of time, did not make any payments. Is that right?
Yeah.
Okay.
For 15 months.
And after they did start making payments, was it regular?
No, it was sporadic again, and in various amounts, and yeah.
Forgive me, Mr. Downs.
Absolutely.
I need to interrupt you and take care of some grand jury matter real quick.
Absolutely.
Just take a second. Nah,
You're totally fine.
no problem.
I should be thanking me.
Yes, sir. It is 23rd.
That's right.
Judge Dunaway had in front of me. Lunch. It's a gorgeous day. Good time to be outside. The grand jury indictments have to be returned into open court and then given to the clerk for filing. And so that's what you just witnessed.
Ceremony. Yeah.
Right. So when you hear somebody say that they were returned in open court, this is what it means.
Awesome. I don't ever, not in the criminal world. So
And of course, none of that, Madam Court Reporter, needed to be on the record, to be clear. But please, sorry for the interruption. Please go ahead.
No problem. So with the sporadic payments in OTU, how did you keep track of all this?
I kept a spreadsheet. Which turned out to be a very big spreadsheet, and that just went on from 2013 through to 2018. And then I started another spreadsheet from 2018 when we signed the purchase agreement, or we agreed that they would try and purchase the house. Yeah.
Was Mr. Gunby aware of the spreadsheet?
Yeah.
How so?
Occasionally we would discuss it. I would email it to him. He would have it. He would review it, and yeah.
Okay. Now, at some point, did you and Mr. Gunby discuss him purchasing Colewood Court?
Yes, we did. Yeah.
All right. Tell the court about those circumstances.
Yeah. No, he said that they liked the house. They were comfortable in the house, and they have a large family, and I guess it was a good place for them to get together. I mean, they said that they would like to find some way to purchase the property, but they couldn't get a mortgage because Matthew didn't have credit, his wife didn't have credit. So could we come to some arrangement where they could buy the house? Now, that was on the basis, I'll just add, that we were in Europe, and we had stayed in Europe because for various reasons, but one of them was that our son had some health issues which we needed to take care of in Europe because we didn't have health insurance in Spain, in America, and that's a pretty hefty bill.
Yes, I think all of us Americans in the room are quite familiar with that.
Exactly. So it was much better for us to deal with that in Spain. And so we thought, okay, well, if we can get the money for Colewood and we can have a friend buy it, there's a sort of nice continuity there. And, and regarding all the sort of the missed payments and everything, I mean, that's just what Matthew's like. I mean, he is up and down and up and down, and you have to accept the friends that you have. I mean, you can't just be so rigid. So while, I in particular, not my wife, but I in particular might look a bit foolish through all these proceedings, I'm just trying to help a friend, really. And
so let me jump in, if you don't mind. What time period are we talking about when you started talking about him purchasing the house?
Yeah, probably like 2016. I think we first started to talk about that. And then, through 2017, we discussed some purchase prices. They got an appraisal on the house. And I said, well, I'm not interested in that because it's way too low. And so, eventually we agreed a purchase price, which included, in fact, consolidated all the debts and extra payments to effectively compensate us for our goodwill, right?
Can you explain what you mean by you consolidated the debt?
Well, because so in 2018, he still owed, gosh, I don't know, probably about $64,000. Plus, he'd agreed to adjust the rent on the property a little bit, and that's all documented in various emails that you've had in discovery. And but I wasn't going to sell. I didn't want to sell the house for $400,000. I mean, I didn't need to, So we came to an arrangement. I said, okay, well, let's lump all our stuff together because he's been sporadic in his payments. And I thought, okay, if he has to pay to buy a house, then surely he's going to pay everything, right? This is a one way to force some consistency on Mr. Gunby. So that's how we arrived at the number in the spreadsheet, which we'll discuss. And then we came to sign the purchase agreement, but he said that he did not want his wife to know about the extra sums. So could we just put $450,000 in the purchase agreement, and whilst the other sums were agreed and on our spreadsheet, which is in evidence, we'll take that away from the agreement, and his wife didn't need to know that.
Okay. So ultimately, you did sign an agreement for the purchase of the property, correct?
Yes, it did.
Okay. I'm going to share with you a document.
Can I ask, I assume that what you're fixing to ask him to do is identify the purchase and sale agreement and share it digitally. Do you either have a physical paper copy or can you, thank
Just
you.
for you? Yeah.
Right, or can you direct me to where in the record it already exists?
Yes, absolutely.
Thank you, sir.
Is it hard for you to see on the screen?
No, it's easy. I just I'm despite my youth,
You like
I am a
paper?
paper
I
person.
gotcha. You like the paper. It's so hard to look at documents on the screen all the time. All right. So showing you what I've marked for the court as plaintiffs 1. And ask if you recognize this document.
Yes, I do.
Okay. And what is this document?
So this was what's called, well, you can see it's titled a heads of agreement, because the idea was, honestly, that we were going to just basically agree the terms of this purchase, and then we were going to get a lawyer to do a proper agreement.
Okay, well, let me interrupt just briefly to make things maybe more efficient for us. There are, in this index that you've handed me, have you provided Mr. Withers with a copy of this index?
He's got the exhibits.
Okay. Well, I guess that's what I mean, the 12 exhibits. Is there a dispute? I mean, obviously there might be a dispute about relevance, but in terms of admissibility, it seems like most of these documents the parties would agree on, and so you don't have to ask the 3 magic questions for every single document. What are your thoughts, Mr. Withers?
Well, Your Honor, I do have some, we're going to be looking at some spreadsheets, which I would have, some objection to on the grounds that they're either hearsay or that, they're summaries of documents and that reflect amounts that presumably come from other documents.
Well, let me clarify. I absolutely don't want to jump over your right to object to a particular document. My question is merely, if we were in front of a jury before we got there, I would have made y'all agree that we agree on the admissibility of exhibits 1, 2, 3, 4, and 12. And then that way we only have to ask questions for admissibility and have an argument about certain ones. And that's really what I'm asking right now. I'll give you a chance to make your argument when that one is offered.
That's fine, Your Honor.
The question is, which ones of these can we agree on?
We can agree on 1. And as far as the spreadsheet documents, which are 2 and 3, I have no objection to the email, but I may want to interpose an objection as to the attachment to the email.
Okay.
No objection as to 5.
Not
Okay, Mr. Downs says he's not going to use number 6, so we can leave that.
And yeah, my index says deleted, so.
Oh, okay. No objection to 7, no objection to 8, no objection to 9.
10 I have is deleted as well.
Okay, no objection to 11, no objection to 12.
Okay, and the only one I was a little confused about is you said 2 and 3, but I didn't hear. So I have 2, 3, and 4 as not having an objection or not objection. I think I heard you specifically say 2 and 3, you don't object to the email, but you are going to have an objection to the spreadsheet. So we'll have that conversation when it's offered. What about 4? Does that fall into the same category as 2 and 3?
No objection to number 4.
Okay.
At least as so far as the document is what it purports to be.
Okay, well, and again, to the extent there's objections as to other matters, I'm just trying to make sure that for right now, to move us along, exhibits 1, 5, 7, 8, 9, 11, and 12, the parties are stipulating that those documents at a proper foundation could be laid for authenticity and general admissibility. And then as to 2, 3, possibly 4, the parties will raise objections as we go. Okay?
Yes, Your Honor.
Okay, so with that, you may go ahead and inquire about the substance of the ones that have already been admitted.
Let's, so I'll go through the one, since there's no objection. All right, you were saying, so.
Yes, I recognize that. I think you asked me if I recognized.
Okay. All right, and, all right. Under the terms of the agreement, what was the, what payments were the Gunby supposed to?
Well, the 37 payments at $8,000 a month, and then a balloon payment at the end of the term.
Am I correct that you refer to this as a heads of agreement, which
Not so actually, I was told that's where we sort of got
that British English versus American English, but am I correct that the idea is this is an agreement to agree and that the cannot agreement is perhaps y'all's effort to reduce that to writing?
This has got nothing to do with
Nothing to do with it. Okay.
nothing to do with Connor at all.
Okay.
So this was, you're right, this is what we sort of agreed. And the idea was that we would give this to a lawyer and then the lawyer would put these terms in a proper agreement.
I see. Thank you.
And because we're British and what have you, we didn't do that. So,
So, yeah, you never signed any other agreements?
No,
for purchase of
no,
property, right?
no.
So this is what you're left with?
Yeah.
Okay, all right. And the total payments, if you add in the installment payments and the balloon payment, that's approximately $501,000.
Yeah.
And under the agreement, when did it terminate?
It's terminated on the 30th of June, 2021.
And how many of the 8,000 installment payments did Mr. Gunby make one time?
Of the 37, I'm not going to do the math in my head, but I can tell you of the 37, he failed to make 23.
How many times did he make $8,000 payments to you on or before the due date per month?
I don't recall, honestly, but not very many. And yeah.
At some point, did he stop making payments altogether?
Yes, he stopped making payments halfway through 2019, and he didn't commence making payments until, I believe, January 2021. It might have been December 2020, but around that dimension.
And under the agreement, does it say anything about what happens if the Gunbys fail to make a payment for a certain series of consecutive months?
Yeah, in 2.4, it says that if a buyer fails to make any payment for 6 months, then the buyer is assumed to have cancelled the agreement per above. Yeah, per 2.3. That if the buyer wishes to cancel this agreement at any time and for whatever reason, no payments will be returned, no value given for any repairs or improvements which will belong to the property.
So, in 2020, You say you testified that he did not make any payments in 2020?
He did not, no.
I'm gonna hand you, show another exhibit to you. This is marked as Exhibit 2, which I know Mr. Withers has. He doesn't have an issue with the email, so let's look at the email. This appears to be an email from you to Mr. Gunby in December of 2020, is that right?
Mm-hmm.
You have to verbalize your.
Okay.
Yeah, you do have to say yes or no.
All right, yes, yes, it is.
All right. What is the purpose of this email?
Well, I'm telling him here, hey, you haven't made any payments for 20 months. Now, this was sort of par for the course, as you've heard. But now it's getting serious because we are, our property is attached to this, and all the remaining amounts of money that he owed us and what have you are all tied up in these payments. So I'm saying, hey, there's been no payments for 20 months. So the agreement's void, right? And it's due to end in June. So I'm giving him a heads up because, had he fulfilled the position by June, then yeah, I would have sold him the house. But right now, because he hadn't paid for 6 months, in fact, 20 months, then yeah, of course the agreement voided itself.
And are you attaching something to this email as well?
Yeah, I've attached the spreadsheet with all the missed payments on it and the current position and what have you, this one here, yeah.
Yeah.
So, Your Honor, at this point, I'm going to object. And I realize we're in a bench trial here, so it's a little bit different than dealing as you might with a jury trial. But, to preserve a record, I do feel the need to object to this on the grounds that this, I believe, is hearsay. It's a summary of documents or documents that contain numbers. And we don't have those documents to know, whether the numbers that are on this spreadsheet are accurate. And so I would object on the grounds of hearsay and on OCGA 24-10-1006, which is the statute that governs
Summary of voluminous documents. Right. So a couple of things. Your objection is going to be overruled. Number one, because Mr. Badham is a party. And so my understanding of the hearsay rules is that this spreadsheet can be understood to be his out-of-court statements. His testimony about those things is acceptable. And while the absence of the supporting documents might go to the credibility of the information that's being provided to the court, it is still evidence that is being offered by Mr. Badham and I think is admissible. So your objection is overruled. Go ahead, sir.
Thank you.
All right. And just, if you could just explain to the court what the format of this spreadsheet.
Okay, well, yeah, I mean, you can see there that we have our start total, which is the start, so the total, so if the first column is the total describes what the outstanding requirement is, the start total, and then you can see the monthly fee payments. Then I was still paying, even under this agreement, I was still paying power and water because they had not transferred those over to their own name. And pest control I was paying for, and then later on Ercon lease, where they requested that I replace the air conditioning system there, and I took out a lease for that. So that's the start. So the start of this says that when we began this journey for them to purchase the house, the start sum was $742,000, which was made up of the $450,000 plus interest purchase price in our little heads of agreement, plus the prior loans and goodwill payments and all the outstanding monies that Gunby owed me.
What is flex?
It's a flexibility payment. It's basically a plug that says, okay, the outstanding amounts of this, that's for, that's for rent, that's for utilities. And then we still have a gap to where we want to be. So because you've been so flexible with us over the last 5 years, then we'll introduce this to get to a number that we both like. And that's what the flex was for.
Is that synonymous with goodwill?
Yeah.
Okay, gotcha. All right, so you sent this in December 2020, correct? I believe that's when we looked at the date. What was his, Mr. Gumby's total running balance as of December 2020?
It was $670,875.42.
So by the end of the agreement that we looked at, Exhibit 1, I can put it back on. Do you recall how much total payments you had received from Mr. Gunby by that time?
I had received $114,461.
As of June 2021?
Yeah.
And did Mr. Gunby make the balloon payment of $205,522?
No, he did not.
Did he, at that point in time in June of 21, pay any of the difference in the installment payments he owed?
No, he did not.
At that point in time, did you consider the agreement to be terminated?
Yes,
And why is that?
because the agreement said that if he didn't make any payments for 6 months, the agreement was terminated. And he didn't make payments for 20 consecutively. Yeah.
Did that constitute a hardship for you that he did not make those payments over the 20 months?
Definitely, because during that time, we were still having to pay the mortgage. Like I said, I was paying all the expenses of the house, including the utilities.
After the agreement's termination date, did you continue to accept monies from Mr. Gunby?
Yes, I did,
All right. Why is that?
because he owed me money over and above the property, as you've seen here.
Did you consider that the post-termination payments that he made to you were towards the purchase of this house?
No,
Why is that?
because the agreement had terminated.
Did he ever tell you that these payments, these post-termination payments were for the purchase of the house?
No, he did not.
Did you ever discuss with Mr. Gunby that he had not complied with the terms of this agreement?
No, we didn't. Maybe we had some discussions about a house. I mean, one thing is important to note that we did at this time we were working together in the Middle East.
And that's the Connaught agreement.
Right, okay. I'm going to get confusing now. So this is before Connaught because Matthew was a partner with Ernst & Young in the Middle East, and he introduced me to some work as a consultant with EY in the Middle East.
I see.
So I've been doing that work. So we were in constant contact throughout the sort of the COVID period and what have you, and post that. So we may have had conversations. Certainly we were talking about Colwood and about his payments and what have you, which led us into, in January of, I think 22, I sent in the spreadsheet and said, hey, we're done. We need to sort something else out.
All right. Well, I'm going to show you what's marked for the court as Exhibit 3. And this is a January 22 email from you to Mr. Gunby, correct?
Yeah. Yes, it is.
And Mr. Withers, you had not objected to the email itself. Do you have the same objection for your record to the spreadsheets attached?
For the record, I have the same objection to the spreadsheet.
Okay, and my ruling is the same. Thank you, Mr. Withers.
Okay.
Mr. Downs, if you don't mind, it's 12:26, unless you're going to touch on this just briefly, this would be a natural stopping point.
I think this was a brief one.
Okay, so Exhibit 3 is admitted over objection for the reasons I stated before. Go ahead, Mr. Downs.
All right, Mr. Badham. All right, so this January 22 email, what are you discussing, or what are you proposing here?
So discussing him still trying to buy the house, but I'm saying to him, and this was a brief summary of verbal discussions, of course, but hey, let's make this happen. So if you pay X, because, we were starting to feel having to pay the mortgage and the expenses and not have any money coming. I said, listen, if you pay this money, I'll just pay off the mortgage. And then we can rejig the sales price to reflect current conditions. That's really what the answer was. That's what this is about.
Okay. And so essentially you're asking him to enter into a new agreement?
Yes.
I mean, in fact, you say, get with your attorney and see what documents are required, right?
Mm-hmm. Yes.
Did he ever transfer the $200,000 to you?
No, he did not.
I think that's all I have for that exhibit. If you want.
Okay, I have one question about that exhibit.
Sure.
I think I understand that the spreadsheet from 2 and 3 are essentially the same spreadsheet, but with different dates, right? Because more time has passed. And a moment ago, I thought Mr. Downs asked you a question about, or I think you would testify that you didn't really have any discussions with Mr. Gunby about payments that he made during that interim, that they were for the house. And that you didn't believe they were for the house.
No.
Okay. But the spreadsheet attached to 3 shows you crediting payments that he's making to you in 2021 toward the agreement. So tell me what that process was about.
The spreadsheet is a running balance of what he owed, right? So I was just I just added to that with the money that he paid.
Okay. Yeah. Okay.
Yeah.
Okay. Thank you. So it is 12:29. We're going to be in recess until 1 p.m. And I think the courtroom Sergeant, is the courtroom going to be locked?
Yes.
Okay. The courtroom will be locked, so y'all are free to leave your stuff in here, but that means you can't be in here. So
Yeah, exactly.
because the sergeant needs lunch as well is the issue. So anyway, we are in recess. You may step down, sir.
I have one bit of housekeeping.
Sure.
Is there, do we need to bring some more water in for the?
No, we have water. Normally my assistant has been out recently, but normally she's an excellent host and brings water, and I'll ask somebody in my office to step in and bring you bottles of water and stuff. Okay.
Thank you.
Thank you.
And they had gone on so long and they weren't paying any money to us at all. Once again, we were in a position where we were paying the mortgage, still paying the electricity, still paying the water, and I was no longer getting a salary from Connaught. And he was intermittently reimbursing expenses. So, our position was starting to become really difficult, which is why, we started having that discussion in Barcelona, precipitated, as I said, by people of our age, moving on. And, because I needed to get something on a level, because we were not earning we weren't getting any money from the Gumbys. They weren't paying anything towards the house at that time. And nor was I getting paid by Connaught, apart from small sums of reimbursement. But they were reimbursements. That's cash that I'd laid out. That was nothing that was coming back. So, that's it.
Mr. Withers brought up something in his opening statement about how you told Mr. Gunby that the deal did not end. Do you remember that?
Yeah. That was in an email. That was in an email that I sent to him in, I think, August 22 or something. I can't.
With you. And this is marked by Defendants 5.
So
This is a September 10th, 2022 email where you stated, I mentioned that as the deal did not end in July 1st, 2021, I was now carrying the monthly mortgage, tax, and insurance when I anticipated this would be gone.
Yeah.
What did you mean by that?
Well, I think, as we said at the deposition, that there's a context to this. I know Mr. Withers has a different view, but what I mean by this, this letter is a request for them to start paying some money towards the house because it was getting difficult for us. So what I meant by the deal did not end was that the Gumbys did not end the deal. They didn't buy the house. They didn't close on the house.
What exhibit?
Yeah, they were still there.
This is Defendants 5, Judge. I
Thank
don't
you.
think you have a hard copy of this.
Okay. No, I mean, I can see it on the screen. I just was like, I don't think I have that document here. So, okay.
Fine.
Thank you, sir.
So they were continuing to live in the house, but not contributing anything to the house. And I said, hey, okay, carry on living in the house, but you need to at least pay the expenses. Now, I didn't ask them for market rent or anything because we were in business together and, our business was, a little bit shaky. So I said, just cover the expenses again like you were doing previously. All right. And that's what this letter is about. So when I say that the deal did not end, it didn't end because Gunby didn't buy the house, not because the agreement didn't end.
Okay. All right, I know we've touched on it a lot, but tell us about when you and Mr. Gunby, or you began working with Connaught and what that is.
Right. So Matthew set up a company maybe during the time as with EY or maybe after he just left. I can't really remember. And the intention was to do similar business in the Middle East that he'd been doing with EY. And he asked me and a number of other folks if we would participate in that venture. And he offered me a position as chief operating officer for that. He said that he had capital funding for a year and that would give us enough runway to build a business. And that's logical. It's fair enough. So I started working for Connaught in the Middle East in June, I think, June 22. June 22, yeah.
All right, I'm going to share another exhibit with you. This is Plaintiffs 5, and this is your Connaught employment contract, correct?
Yes, it is. Yeah.
And it's signed June 1st, 2022.
Yes, it is.
All right, and this was for a 2-year term.
Yes.
Okay. And under this agreement, you were supposed to receive a salary.
Yes.
What was the salary?
It's about 15,000 and something Bahraini dinar, I think. No, maybe. It's in there. I can't remember, honestly. It could have been maybe $15,000. So yeah, 15, it works out to be, there you go. So 4,000 dinars.
And what's the equivalent of that in US dollars?
It's about, with all the expenses and the travel and what have you, it's about around $15,000 a month. Yeah.
In US dollars?
In US dollars. I think it's like 2.6 is the exchange rate, Bahraini dollar to a dollar. It's a very strong currency.
And what was Mr. Gumby's relationship to Connaught?
He was the owner and the chief executive.
And did you receive a regular salary from Connaught?
For the first 6 months? Yes, I did.
And then after that, what happened?
After that, I had 2 months of half salary and then no further salary.
Mr. Downs, may I ask, or Mr. Badham, so the document that you're referencing is Exhibit 5, correct? Plaintiff's Exhibit 5. And at the bottom, it says Connaught Services WLL. Is that something that is designed to indicate as an Inc. or an LLC would in the United States that this is a corporate entity?
LLC.
With similar corporate constructs and protections
Yes.
under Bahraini law versus state U.S. law?
Yes.
Okay, thank you.
And how did you receive payments from Connaught?
I received payments directly to an account with an organization called Wise. Both Matthew and I use that. It's an online bank. And it's very easy to work. You know, we were working in British pounds, we were working in US dollars, we were working in euros, Bahraini dollars, and it makes it really easy to transfer money around and switch currencies and what have you. So he paid me directly into my Wise account from his Wise account.
So when you say Matthew paid you directly, you mean Matthew personally, not from a company-wise account?
Yes.
So all the payments you received from Connaught were personally from Mr. Gunby?
Yeah, I only ever received money from Connaught from Matthew's personal, for Connaught from Matthew's personal accounts.
So let me make sure I'm following that because you correctly anticipated why I was asking that question. So the payments that were due to you from Connaught under this employment agreement, you did receive those payments.
Some, yeah.
But they were physically paid to you from a personal Wise account held by Mr. Gunby.
Yes.
Okay, thank you.
And did you get paid everything you were owed from Connaught?
No,
And
I didn't.
how much would you estimate you were still owed in salary?
About $236,000.
Is Connaught still in business?
I don't believe it is.
Did you ever ask the Gumbys to vacate Colby Court?
Yes.
And when did you do that?
Formally, I think on the when I sent him a WhatsApp message in April of, it would be maybe April 17th, I think, that I sent him a WhatsApp message. But we've been discussing the possibility of this for ever since that October email that you showed me.
What year would that be?
2024.
So in April of 24, you sent him a
Yeah.
formal notice through WhatsApp.
Yeah.
What happened when you asked them to? Well, let me ask this: why did you ask them to vacate?
Because we needed to come back to the United States. Our position had become untenable. We were receiving no money from Connaught. We still had all the expenses of Colwood. We needed to rent a property in our house in Spain. We didn't own a property there. We were just renting. And our position had just become untenable. And we were running out of money. And my wife couldn't work in Spain. She didn't have work authorization. I didn't have a job in Spain. There was no money coming in from Connaught. So we said, you know, the only way we can get ourselves right here is we need to move back to the United States. And I'd been having this discussion with Matthew since the previous October because the business wasn't generating the revenue that we anticipated it would. And we had some opportunities, we had some prospects, but nothing crazy. And I mean, it got to such an extent, honestly, that luckily I managed to find a way to put a mortgage on a previously paid off condo in Atlanta, which would then give us some breathing room. But it got to us, but that didn't kick in until April of 2024. And then it got to such a state that, you know, the last month's rent that we paid in Spain, I had to sell a watch that I'd been given from my father. And I was very embarrassed about that in order to just pay our rent. And that's really where the whole thing finished for me. We need to come back to the States, get ourselves a level. Liliana goes back to work at the hospital and we can start to get ourselves well. Our son goes to high school here, which is something that he wanted to do, and maybe go on to a college track here in America. He was born here, he was born in Atlanta. So He had this idea that he could come. Riverwood High School in our school district is a great public high school. They do the International Baccalaureate, and all those things were played into our stuff. So we had to come back really because we had no more options.
And what happened when you asked them to move on, the Gumbys to move on?
At first, Matthew said he was devastated. He'd have to think about it. He said he would have to get with Kim and see if they could work it out. Then he sent me a long email basically telling me that I was unfair, unjust, unreasonable, that, you know, it would really damage him, and, you know, absolutely no consideration for our position, you know, just for himself.
Did that response surprise you after all that's happened?
Yeah, it did. It did. I was very hurt by it, actually. I was shocked. I was shocked by it. I was hurt by it. And I continue to be like that. I mean, I pray on this every single day because it astounds me, honestly, their action. Yeah.
And they didn't vacate the property, correct?
No.
And when did you want them to vacate by?
You know, I said to Matthew in April, listen, you know, Felix starts school in August. It would be really good for us to be in before then. You know, so anytime, so around the 15th of July would be great for us. It's 2 weeks before school starts, and that would help us out a lot.
And instead of vacating, did they have an attorney send you a legal notice?
Yes, they did.
Just to make sure my notes are right, you asked them to vacate or maybe first broach the subject in April, but the time frame that you wanted them to consider vacating by was in August.
Yeah, in order for school to start in August, so late July.
Okay.
All right. And I'm showing you what's marked as Plaintiff 7. Is this a copy of the legal letter you received from Arnold Golden Gregory?
Yes, yes, it is.
And this is dated July 1st, 2024, correct?
Yeah.
And
Because if I could add, I mean, before this came, they didn't tell me from April through to actually a WhatsApp that Mrs. Gunby sent eventually. They wouldn't tell me that they weren't going to move out. And we were trying to move and get movers and pack up our stuff. And they wouldn't tell me. They wouldn't agree. They wouldn't say whether they were going to move out or not. So it was really just unnecessarily difficult. And then, of course, we end up getting this letter, which was a complete shock to me. Yeah.
and in this letter, it references kind of similar to your testimony that in April 2024, you advised the Gumbys of your request that they vacate and surrender possession on or about July 12th, 2024.
Yeah.
Which is more than 60 days notice, right?
Yes.
Oh. In this letter, it says that the Gumbys have paid over $408,000 towards the purchase price. Do you see that?
Yes, I do.
Okay. Do you agree with that?
No.
And so what did you end up having to do since they didn't vacate Coldwood Court?
Well, we had to hire you. We needed an attorney to respond. We then had to put all our goods into storage, and all our goods are still in storage in Spain. And so we've effectively been living out of a suitcase for, nearly 18 months now. Yeah, we had to rent a property close to the school, which we managed to do, and we're still in that rental property now. Yeah.
What type of rental property is it?
It's an apartment building, but we have a little townhome at the bottom. But the square footage is the same as the apartments. It's just the way the apartment building works is that the ground floor is in one of the buildings are restaurants. So obviously they have a bigger ceiling height than the apartments. So in our block, they just built effectively a little townhome. So we have an upstairs and a downstairs.
How much do you have to pay in rent on the town?
$3,666 a month.
And is that more than your mortgage payment?
Yeah, $1,400 more than my mortgage payment.
And those are different properties. You're renting a townhome versus the Colwood Court's a single family home?
Yes.
Did you look into renting single family homes?
Not really, because we had to, one, we didn't have our stuff. All our goods were still in storage in Spain. In order to rent a single family home, we would have had to bring our goods, and it takes 3 months to get things over from Europe. And we needed to be here quickly. We had to move in a few weeks because of the uncertainty that the Gumbys created around our move. So it was much easier for us just to rent in an apartment building that was quick and easy. And
Right, and I'm showing you what's marked as plaintiffs 8. You mentioned having to hire an attorney. Did you have to hire our law firm?
yes,
Okay. And did you have our law firm respond to the Gumby's attorney's letter?
yes, I did.
Okay, is this a copy of that letter?
Yes, it is.
Okay. And in this letter, you had our firm demand possession of the property, correct?
Yes.
But that still hasn't occurred. They have not returned possession, right?
No, they haven't.
So ultimately, you had to file an eviction on them?
Yes.
And are you seeking reimbursement of your legal fees for having to file the eviction?
Yes, we are.
All right. I think you may have mentioned this, but what is the amount of your mortgage payment, monthly mortgage payment on Colwood?
Currently, it's 2,300 and change.
And have you been paying the mortgage the entire time the Gumbys have lived there?
Yes, I have.
Have you ever defaulted on your mortgage payment?
No, I haven't.
And what utilities are you currently paying on the property?
I'm paying for electricity and water, plus pest control and a lease on a air conditioning system. But I guess they sort of belong to the house. Yeah.
And what,
I'm sorry, you said water,
Electricity?
power, and the lease on the air conditioning
Yeah, and pest control.
and pest control. Thank you.
so what are your monthly expenses then for carrying Colwood Court?
Okay, I'm gonna have to add that up now. So it's 2,300 and something, 451 for electricity because I'm on a budget number. So no matter how much they use, it goes up and down. $62 for water, and I don't know what they miss out a month, but then it's $100 plus or minus every 3 months for pest control.
And is that adds up to more than you're currently receiving from the court for the registry payments, correct?
Yes.
Have you been paying the property taxes on the property?
Yes.
And have you ever missed paying the property taxes?
No.
Have you been paying homeowners insurance on the property?
Yes, I have.
Do you recall what the amount of your homeowners insurance is?
I don't.
Have you researched what the fair market rental value of Colwood Court would currently be?
Yeah, it's around $5,000 a month.
What did you do to form that opinion of value?
I looked on the rental websites. Zillow has it at for 400, I think, and then Redfin has it at 5.1, and then I have a a friend who lives around the corner who is renting their house, which is a little bit smaller now, certainly doesn't have a swimming pool, and they're renting it for 5,000. So plus or minus $5,000. Yeah.
And if you were to get possession of the property back from the court, would you be looking to move your family back into Coldwood Court?
Absolutely.
You would not be looking to rent it out?
No.
You've testified about other amounts that Mr. Gunby owes you, but you're not seeking those in court today, right?
No.
You're aware that the Gumbys are claiming that even if they have to vacate the house, they should be able to recover the value of the improvements they've made to the house?
I am aware of that, yes.
Was there ever any agreement between you and Mr. Gunby concerning who was responsible for, that you would be responsible for paying them back for improvements made to the house?
No. They were responsible for maintenance, and that's it. Yeah.
Was there ever any agreement that you would reimburse them for maintenance costs?
No.
Did the Gumbys ever ask your permission to make any improvements to Coldwood Court?
No.
Are you aware of what improvements they have made?
Before the fact, I was aware of the retaining wall and the roof because they asked me about those because we wanted to get the insurance involved, my insurance involved. But that was it, nothing else.
Would you have expected Mr. Gunby to ask your permission before making improvements to the property?
Yes, I would. I would, at least to talk about it. I mean, at least to say, hey, we've got these plans and we're doing this and we're doing that. I mean, at this point, just for reference, I mean, Matthew and I were living together. I mean, we were sharing a house in Riyadh. And so we spent a lot of time together and, you know, he shared the most intimate details of his life with me, but he couldn't tell me that he was going to put a fire pit in or whatever he did, a gazebo or something. I mean, it begs belief, honestly.
Is there anything else that I haven't asked you today that you would like the court to consider?
I mean, I've sort of hinted at it, but honestly, these people, we consider them our friends, and we help them and are continuing to subsidize them since 2013. And like I said, I'm still shocked at the way that they've treated us. I'm shocked at the expectation that they have after everything that they've received from us, the kindness and generosity and support. I mean, I've hinted at that before. And I'm really, and I'm upset for our son who, you know, is having to navigate his high school years living out of a suitcase and, you know, not having the house that he thought he was going to come back to as he went into high school. Yeah. So there's an emotion there. And like I said, I pray for these people every single day. And
Thank you.
Nothing further.
Mr. Withers? Before you get started, I don't think this matters, but I did just connect something I wanted to make sure you're both aware of, right? So Mr. Withers' partner, Chesley McLeod, and I are related. Our grandmothers are sisters. I don't think that matters for anything, and I couldn't even do the flow chart of the amount of relation that we are, but because we are related, I just clicked in my head, AGG, when I saw the attorney letter that was Exhibit 6, I think, or maybe 7. And so I just wanted to make sure and put that out there so y'all are aware of it. Go ahead, Mr. Withers, if you have questions.
For you.
It's like your cousins or something.
We are, and I think it's several times removed, and but anyway, Mr. Withers, whenever you're ready and you have questions for this witness, sir.
Sure. if I may approach, Your Honor, I have
Sure.
our exhibits.
And were these intended to be the official court exhibits that you gave me, Mr. Downs? Because I treated them as my own and wrote notes on them.
No, I
Okay.
mean, you can, that's your copy.
Okay.
I've
And
got a separate copy.
I'm sure the court reporter will appreciate, and I think the rules require that within 10 days of the completion that y'all provide those documents to
Also
her.
got another.
Electronic
Standing
format.
order set of thumb.
Exactly,
Okay.
to the court reporter. Perfect. Thank you.
Good afternoon, Mr. Badham. Are you currently employed?
No,
You were last employed in approximately May of 2024, correct?
yes,
And I can't remember whether you testified as to this point or not, but you moved to the Atlanta area in 2001, is that correct?
yes.
And purchased, I'm sorry.
Yeah, that's all, yeah.
And purchased the Coalwood property in approximately 2005, right?
2006.
2006. And when you bought that property, you paid approximately $350,000 for it?
368, I think.
Okay. And the current balance on the mortgage that we've been talking about today, do you know what that is?
Yeah, it's approximately 140,000.
And once you bought the property, you lived there for about 5 years.
Yes,
And you moved out of the property in 2010.
yes,
And from 2010 through 2013, you and your wife allowed some of her relatives to live in the property.
yes.
They did not pay rent during that period.
No, they did not.
Did they have a rental agreement?
No, they did not.
And from 2010 to 2013, you visited the property on average maybe once a year, right?
Yeah,
And you tried to sell the property in 2013, correct?
that's correct.
But you do not know what the appraised value of the property was at that time, do you?
I don't recall it.
Now, you met, I believe you, or maybe you testified that you met Mr. Gunby in the early 2000s. Is that right?
Yeah, when I met Matthew through business when I moved to the US to take up a position for the UK company that I was working for that had got business in the United States.
Okay. And so you allowed the Gunbys to move into the property in 2013, right?
Yes,
And I believe you testified that Matthew, Mr. Gunby, approached you about moving into the property.
yes, he did.
But in truth, it was you that first mentioned the possibility of the Gunbys moving in, not the other way around. Isn't that correct?
No, that's not correct.
Okay. In any event, you did not enter into a written lease agreement with the Gunbys at that time.
No,
And in fact, you never entered into a written lease agreement with the Gunbys relating to Coalwood property at any point in time, did you?
no,
I believe you testified that you discussed that the Gunbys would pay $1,400 a month to live in the house?
Yeah, well, initially I wanted more than that. I wanted the cost of the mortgage, like I said. But he said he could only afford $1,400.
And the Gunbys did not make those payments consistently, did they?
Not for the first 15 months. They didn't make any payments. Oh,
You continued to allow them to live in the house.
yes, I did.
Just to
And
be clear, you're talking about the first 15 months in 2013, they didn't make any rental payments,
2013
correct?
to 2015.
Thank
Yeah.
you.
and you never sent them any default notice, did you?
No, I did not. Because they were in trouble and trying to get back on their feet. Why would I be generous and, helpful and supportive of somebody I considered a friend if I was going to hassle them every 2 minutes?
There did, as we've discussed, there came a time where you began discussing that you would sell the property to the Gunbys, correct?
Yes.
And those discussions initially began in 2016?
Yeah. Yes.
And at that time, Mrs. Gunby commissioned an appraisal of the property, correct?
Yeah, she did.
And you don't know what the appraised value was at that time, do you?
I don't know.
Okay. But in any event, you and Mr. Gunby ultimately agreed on a purchase price in the principal amount of $450,000.
Yes.
And the two of you ultimately reduced your agreement by which you would sell the property to the Gunbys into writing, correct?
Well, we have to put this into context. We agreed a sales price of 450 because that's what Mrs. Gunby would accept. But we were going to roll into our agreement all the other monies that were outstanding for him, just so we're clear on that.
Okay, and I do want to be clear, and that was on May 5th of 2018, right?
Yeah.
Okay. Your Honor, do we want to do the same exercise that we did with my exhibits, just so we can speed things along?
Indeed, yes, sir.
Okay.
Mr. Downs, have you had a chance to review the exhibits they intend to offer, and are there some that we can agree to?
Yeah, I'm fine with all of the correspondence between the parties. I do see defendants' discovery responses, and I don't really understand that one.
Okay, well, we'll leave that one open for now.
I don't understand the deposition transcripts either, because both of the witnesses are here to testify.
Well, he might want to impeach with them, and so I'm sure in an abundance of caution, he's including them in case he wishes to do so, and
So, yeah,
we'll leave that one open for now as well,
Okay, yeah.
those two.
leave that open. I don't have any issue with the other ones.
Okay, so just for record purposes, D1 has essentially already been admitted as P1. It's the same document, correct, Mr. Withers?
I'm sorry, can you repeat your question?
D1, the actual purchase and sale agreement has already been admitted as P1, right? So,
Right.
and then Mr. Downs indicated he had no objection as to D3, D4, D5, D6, D7, and D10. Is that correct, Mr. Downs?
That's good.
And so those documents, those exhibits will be admitted for use. And we're going to leave open D2, D8, and D9. So whenever you offer those, you'll need to lay a proper foundation other than just going ahead.
Sure.
Okay? Thank you, sir.
Okay. And I'm, for the benefit of Mr. Gunby, who's viewing this remotely, I am showing you, or I'm putting up on the screen what's been marked as Exhibit D1, which again has already been admitted by your counsel. So you recognize this document, of
Yes, I
course.
did. Yep.
You don't recall whether it was you or Mr. Gunby who drafted this agreement, do you?
Yeah, we drafted it together. I mean, we had various iterations of it and then this came up. Yeah.
So, but you don't remember who drafted the first iteration of this agreement, do you?
You know, I probably did. I probably drafted an iteration, but honestly, it went backwards and forwards, and this was a mutually agreed document.
And it says this document details the agreement made between the parties to the agreed sale of the above mentioned property by Keith Badham, seller, to Matthew Gunby, buyer, right?
That's what it says.
And you a minute ago, you said, well, let me strike that. It says that the sale price of the property is $450,000, right?
Yes.
But you
Plus interest.
plus interest at 5%, right? But it's your testimony now that really it was something much greater than that is really what you were expecting.
My testimony isn't any different than I've given you before. The whole purpose of doing this was to say, hey, you know, we want to roll up everything that you owe us. This is the sale price of the property. All the other stuff is there. And that is why on the spreadsheet, which you mentioned before, it says 450 plus X plus Y plus B.
Trying to understand what the agreed sales price of the property was. This document says $450,000, but you're saying that really the agreement was 700 and some odd $1,000. Is that right?
Well, the agreement was that he would settle $742,000 by the end of this term.
Okay.
But 450,000 of that was the sale of the property.
Okay. Is there anything in this agreement that talks about any other amounts owed?
No, there is not.
Okay. And it says 100% of the loan finance to be provided by Keith Badham, correct?
Correct.
But you did not actually make a loan to Mr. Gunby, did you?
No.
You just agreed to accept payments from him over time, right?
Yes.
And section 1 is entitled Loan Repayment Schedule and Deed Transfer. And it says it is proposed that the following buyer payment schedule will be as follows. And it says 37 payments at $8,000 a month commencing on June 30th, 2018, and a balloon payment of $205,522 on June 30th, correct?
Correct.
And so if we add up the 8,000 times 37 equals $296,000, right?
Sorry, what did you repeat?
Right. If we times 37 months, that equals $296,000.
If you say so.
Okay. And I'll represent to the court, that's the math. And then so if we add the $205,522 balloon payment, that brings us to a total of $501,522. I'll just represent to you, that's the math. And that number includes both the principal and the interest through June 30th of 2021, correct? I need you to answer verbally, so.
Oh, yes.
Sorry, no problem. I just, court can't take down nods.
I got that.
Okay, I'll do that. And it says within 30 days of the last payment, the deed will be transferred, right?
Yes, it does.
Now, section 2 of this agreement is entitled Conditions. And section 2.1 says the price is fixed by the seller as of the date of this agreement, right?
Yes.
And again, that price is $450,000.
Okay.
And again, just so we're crystal clear, this document says nothing about any amounts above $450,000 beyond the interest, right?
No, it doesn't.
Section 2.2 says buyer will cover the cost of all wear and tear repairs necessary during the life of this agreement, including maintenance. All utilities will be transferred to the buyer's account. Do you see that?
Yes, I do.
And you understood wear and tear to mean maintenance, right?
Well, it says including maintenance.
Right, and that's what you understood wear and tear to mean as well, right?
I understood it to mean the necessary work that one is required to upkeep a single family home.
You did not understand it to mean capital improvements though, right?
Probably not.
You've been a renter for many years, correct?
I have.
And in all the time you've been renting residences for the last 15 years as a tenant, you've never paid to have an HVAC system installed in any of your residences, have you?
No.
And you've never paid to have a water heater installed, have you?
No.
And you've never paid to put a new roof on any of the residences you've rented, have you?
No.
And you've never done major repairs to those residences out of your own pocket, have you?
No.
Section 2.3 says if buyer wishes to cancel this agreement at any time and for whatever reason, no payments will be returned nor value given for any repairs or improvements which will belong to the property. Do you see that?
Yes, I do.
And so you understood that in addition to repairs, that the Gunbys might be doing some improvements to the property.
Yeah,
Okay.
but if I can clarify that, I already told them, listen, If you want to paint the walls, be more comfortable. If you want to redo the garden, be more comfortable.
Right. And
That's what I had in my head.
right.
for
And
that.
obviously, once you put the paint on the wall, you can't take that with you, right? If they move out, of course, the paint's going to belong to the property, right?
I guess.
And the gardening is going to belong to the property, right?
Well, you could remove plants if you wanted to move it. I mean, I don't want to be, flippant, but what I'm telling you is that that's what I understood it would be. If they were going to make, things other than repairing leaky roofs or dealing with the plumbing, then it would be in that sort of dimension and that sort of context.
So when you said any improvements will belong to the property, you meant paint on the walls and plants in the garden.
What I meant was, do what you need to do to make yourself, more comfortable within reason. I mean, really, I didn't have anything specific in my head at all.
It says, section 2.4 says, if buyer fails to make any payment for 6 months, then the buyer is assumed to have canceled the agreement per section 2.3 above. Do you see that?
Yes, I do.
And section 2.5 says any taxes or fees associated with the agreed transaction are the responsibility of the buyer, excluding the federal and state income taxes of the seller. Property taxes and insurance will remain the responsibility of the seller during the term of this agreement. Do you see that?
Yes, I do.
And your counsel was asking you about whether you were continuing to make, paying the property taxes and the insurance. Do you recall him asking you that?
I do.
And of course, you expected to make those because that's what you'd put in this agreement, right?
Well, I would make them irrespective of this agreement, but yes.
And so you never expected the Gunbys to pay any property taxes or insurance, did you?
No, I did not.
Okay.
Well, not homeowners insurance, but I absolutely would have expected them to have renters insurance, and I don't know whether they had that or not because I never asked.
Okay. Section 2.6 says, if the seller wishes to cancel this agreement, notice must be provided in writing. All payments made by the buyer prior to the notice of cancellation will be due back to the buyer within 90 days of such written notice. Do you see that?
I do.
Section 2.7 says during the term of this agreement, the buyer will have the right to occupy the property as a private residence, and no rental payments will accrue or be payable. Do you see that?
I do.
And Mr. Gunby signed this document as the buyer,
Yes, he did.
and you signed it as the seller.
Yes, I did.
As you sit here today, you don't know how much the Gunbys have paid towards the $450,000 purchase price principal, do you?
Yes, I do. They paid $114,416.
Bear with me 1 second.
Is that, while you're looking that up, is that reflected on the spreadsheets
It is.
minus the utilities payments that you were also making?
No, they're listed separately
Right.
on the spreadsheet. So you'll see that during the term of the agreement, between May, whatever the date is here, May 18th, through to June 2021, you'll see that they paid $114,416. The utilities are separate.
Right.
They're over and above that.
That's what I was clarifying, is that your 114,416
Okay.
is just for the payment, the contract payment, not including the utilities amounts. Okay, thank you. Go ahead, Mr. Withers. Sorry for the interruption.
Sure, just a second. Okay, and that's the amount that they paid, that $114,000. That's what they had paid through June 30th, 2021, right?
Yes.
Okay. So I want to direct your attention, if you'll look at Exhibit D2. You recognize this document.
I can't see it. Yeah.
Oh, I'm sorry. Let me put that up. There we go. And it's also in your binder there. You recognize this document, correct?
Yes.
These are the Gunby's responses to your discovery requests in this case, correct? Do you acknowledge that?
Yes.
And you've read these documents, this document, correct?
I think so.
And you were asked about this document in your deposition. Do you recall that?
I don't recall, but if you say so.
Okay. This is a true and accurate copy of the discovery responses that you received, correct?
This is the one I'm going to object to. I mean, maybe this is proper, but not for this witness, not his discovery.
I think they're admissible because they're part of the case. I think that I'm going to interpret your concern or objection to be one of materiality to this particular witness's testimony. Can you?
Sure, I'm going to ask him, this documents a number of payments that my clients made that I think he will agree that he received. And I just want to go through look at the payments and confirm that he received those. He testified about them in his deposition. These are questions that he propounded in this case to my client. My client provided verified interrogatory responses to these, to his discovery requests.
So let me say this way, with or without reference to these interrogatory responses, or I don't know if they're, looks like RPDs and interrogatories. Basically what you, as I understand what you intend to do with them is, Mr. Gunby says he made this payment. Did he make this payment? Mr. Gunby says he made this payment. Did he make this payment? Is that roughly
That's essentially
accurate?
it. I'm going to ask about some of the improvements to the property as well.
Okay, Mr. Downs?
Yeah, I mean, I think you can do the same thing by just reading from the interrogatory responses instead of admitting them. I mean, it's, the interrogatories themselves are hearsay under the law.
Sure.
Without the foundational documents. And these are.
Well, except to the extent that they're admissions by the parties.
Yeah, and if he's testified about this previously, then he can talk about that. But this witness to put into evidence their client's payment history, I'm not sure is proper.
Well, I think that I don't know if this is actually part of your record in the docket, because depending on 5.2, y'all usually just file certificates saying we filed an answer, we served this, we did this. So to the extent that the substance is here, I think it is potentially helpful to the court. I agree with some of Mr. Downs' concerns, but to the extent that you're basically using it as somewhat of documentation of this is what Mr. Gunby has said, do you agree or disagree? I think it gets us to the point faster, and so I'm going to allow it.
Okay, thank you.
Could we just allow the relevant portions of the interrogatories?
That's fine.
Sure. I mean, in truth, it's similar to, in my opinion, to a deposition, right? That if you ask him, Mr. Gunby said he made a payment on this date, and he agrees that Mr. Gunby said that, or that Mr. Gunby in fact did make that payment, there's really not any reason to reference the discovery responses. Similar to, unless they say something different than their deposition, there's no reason to introduce. So,
well, I would also say, Your Honor, I mean, there were, we're not talking about 3 or 4 payments. We're talking about tens of payments.
okay.
And, same thing with, so, I mean, I could certainly go through each one and ask him about each line item payment. I just want to avoid
No, I'm
that.
not asking you to do that. I think we'll know better in a moment what portions of this D2, which is just to my grabbing whole 25 plus pages. Yes.
Right.
And so I think we'll know in a moment which parts you're actually referencing.
Yes,
and I think Mr. Downs' point is a valid one. So what I'm going to say is I'm conditionally admitting D2 to the extent that you're going to reference particular aspects of it, and I will admit those aspects of it.
Thank you.
Okay, thank you.
So, Mr. Badham, if you'll turn to interrogatory number 8, which is on page 4.
Are you putting it on the screen or do I have to do it in the book?
Oh, I'm sorry. I'm going to do my best to try and multitask here. Okay. So, showing you interrogatory number 8 on page 4, and in discovery, you asked for each of the 37 payments at $8,000 per month, commencing on June 30th, 2018, as required by the May 5th, 2018 purchase and sale agreement. Attached to the answer is Exhibit A. Please state the following, and then it goes on. And in response to this interrogatory response, the Gunbys listed a number of payments, correct?
Yes.
And those payments total $452,166, which I will scroll down. It's at the bottom of the second page. Do you see that?
I do.
And I'm gonna, let me just object to the extent that that's what the payments actually total. Because this is, again, hearsay, and there's a lot of conversions here with euros and Great British pounds. So I'm objecting to that's the number.
Okay.
Okay, well, one thing that would be helpful to me, Mr. Withers, just to make sure, is that page 4 and 5, right?
Yes, ma'am.
Of this D2, the table that straddles both of those pages, is Mr. Gunby's responses to discovery indicating the payments that his records indicated he had made, correct?
Correct.
And your point is between July of 2018 and April of 2024, Mr. Gunby alleges that he made payments totaling $452,166. Is that right?
That's correct. And I have added those up myself to confirm that that's what those numbers add up to.
Okay, well, let's hope you went to math school better than I did, because I went to law school for a reason. But I have a calculator, and if I need to do the math, I can.
Yes, ma'am. Okay. Regardless of whether you contend that certain payments were toward the purchase price or for the repayment of other debts, between May 5th of 2018 and April of 2024, you acknowledge that you did receive $452,166 from the Gunbys, correct?
I received these payments, yes.
Now, but you contend that some of these payments were for things other than the purchase price of the property, right?
Yes.
But you don't know which of those payments you allege are for items other than the purchase price.
But you asked me before, so as you pointed out, the purchase price of the property was 450,000 plus interest. So it comes to like 501. Yeah.
Mm-hmm.
But during the term of the agreement, he only paid $114,416 during the term of the agreement.
Right.
Okay. So I'm not disputing that those, possibly because Mr. Gunby himself said that these payments were for the property, prior loans and expenses in previous documents.
Okay.
Right. So what I will tell you is that then the sum. So do you want me to describe what these are for or not? Are you going to ask more questions?
Hang on. Sorry, Mr. Withers. I have one quick question. Is there any agreement, because I think that's what Mr. Badham was trying to get to. Is there any agreement that if you stop counting at some point in 2021, that number adds up to $114,416?
If you stop counting on June 30th, 2021, that's what that number comes up to.
Okay.
Okay. But my question, Mr. Badham, was you don't, regardless of timing, okay, as far as these payments, well, let's just put it this way. It's your contention that every payment he made to you after June 30th, 2021 had no relationship to the property whatsoever. Is that your position?
Yes.
Okay.
I think so, yeah.
Okay.
Now, yeah. Yeah.
I realize it's your position now. I understand that. Now, you contend that the purchase agreement was void in 2020 due to the Gunby's failure to make payments that were proposed in the agreement, correct?
Yes.
No, just for the record, object. He didn't say 2020. It's 2021.
Okay.
No, I'm sorry, but
Why don't you rephrase, just so the
Well,
record's clear?
okay, so the record is clear. You said in an email.
You mean after the?
No,
Hang on. Hang on. I can't follow, and I know the court reporter can't follow when y'all talk over each other. That's okay. Rephrase your question, Mr. Withers.
Right. Do you contend, well, let me ask you this. It is your position that the purchase agreement was void in 2020, not 2021, but in 2020, due to the Gunby's failure to make payments under the proposed agreement, correct?
Yes, because they didn't pay for 6 consecutive months.
Okay.
And the agreement canceled by its own terms.
Okay, so then at least by your own testimony, some of that $114,000, let me see. So, well, I would draw that. And after 2021, or excuse me, in 2021, again, after you contend that the purchase agreement was void, you accepted a $9,000 payment in January of 2021, correct? And I'll scroll down here. Yeah, January of 2021, right?
Are you asking me a question?
Yes, my
Yes, I did.
question was, in 2021, after you contend that the purchase agreement was void, you accepted a payment of $9,000 in January of 2021, right?
Yes, I did.
And a payment of $9,500 in February of 2021, correct?
I did.
And a payment of $9,500 in March of 2021.
Yes, I did.
And you acknowledge that those payments were towards the purchase price of the property, right?
The property, prior loans and expenses, yeah.
I'm sorry?
Property, prior loans and expenses, as Mr. Gunby has highlighted.
I'm going to ask you to flip to Exhibit 7 in your binder there. You recall giving your deposition in this case, correct? And trying to,
What page are we talking about?
I'll get there.
7 is the name.
I'm sorry.
I've got 7.
I'm sorry, 8. Exhibit
Oh,
8 in your binder there.
Okay.
And at the deposition, you were placed under oath, correct?
Yes.
And you swore to tell the truth, correct?
Yes.
Okay. Now, I'm going to point your attention to page 65 of your deposition. And I'll pull it up here.
Are you talking about the pages in the boxes or the
The
pages are the numbers on the bottom?
Nope, the page is in the boxes.
Okay, 65, right.
So this will be on page 17 of the transcript.
Got it.
Tell me when you're there.
Yeah, I've got it.
Okay. If you look at line 9, I asked you about the January payment of $9,000, correct?
Yep.
And in line 11, I asked you about the February payment, correct?
Yep.
And in line 13, I asked you about the $9,500 payment in March, right?
Yep.
And then in line 15, I said those were toward the purchase price of the property, right? And your answer was yes,
Yeah.
correct? And then I followed up, I said, even though you contend that the agreement was void back in 2020, correct? So it is true that you accepted payments towards the purchase price of the property after you contend that the purchase agreement was void, correct?
I've never disputed that.
Okay, thank you.
I've never
Because just a
disputed.
minute ago, you said, well, it was for the purchase price and other debts, and that's not what you said.
Well,
No,
okay, but.
let me finish my question,
Sorry.
please. Are you changing your testimony now from what you said in your deposition?
No, I'm not.
Okay, thank you.
Can you please clarify?
Sure,
He's absolutely allowed to.
Right.
go ahead.
So at the beginning, when we discussed this and you saw the spreadsheet, then you saw that there was a number there that included the price of the property and the roll up of everything that we wanted to just tie off, and the Gumbys would settle their debts and we could go away separately and be friends. So when you ask me how much did they pay to the property, then, you know, it's in that context that I say, yes, they paid to the property. And I'm happy to say that they paid $114,416 to the property, if that's what you want. Now, the reason I accepted the payment too is they were friends. I still want him to buy the house. When I told him the agreement was void, I also said, hey, it's going to run out in June 21. That says, hey, get your act together, pay all the money, and we can solve the problem. Right? And you can own the house.
So you,
I don't think one is disallows the other.
okay, so you accepted payments of at least $28,000 towards the house after you considered the purchase agreement to have been void, right? And then you received payments from the Gundys after June 30th of 2021, right?
I did.
But you contend that none of those payments were towards the purchase price of the house.
No.
And just so the record is clear, no, you don't believe they were towards the purchase price of the house, or no, you don't agree with my question?
I don't believe that they were the purchase price of the house.
Okay. You contend that all of those payments were for amounts that he owed you for things other than the house?
Yeah, well, if you do the calculation,
Just
yeah,
yes or no? Was every payment that he made after June 30th, 2021 towards something other than the house?
yes.
Okay. But you don't know how much he owed you other than towards the purchase price of the property, do you, at that time?
He owed me $742,000, and then whatever the line item, whatever the total was in the spreadsheet, at whatever date you want to pick.
Okay, I'm going to show you your deposition again at page 59. Okay, if we look at page 59, I asked you, well, we start at the top. I said, you did receive payments from the Gumbys after June 30th, 2021. You said you did. And I said, at least some of those payments were the purchase price of the property. You say they were not for the property anymore. They were for his debt. He owed me money. I said, okay, how much did he owe you as of June 30th, 2021? You say you would need some more information to calculate that, to tell you exactly what that was. So my question again is, do you know how much money he owed you other than toward the purchase price of the property as of June 30th, 2021?
$241,000.
Okay, where does that number come from?
Right, that comes from the prior loans, so the money that he owed me before 2018.
Okay,
Right? Some adjustments for rent that we agreed, they're discussed in some of the emails that you've got in discovery, the outstanding utilities, and the flex payment.
okay, so as of,
So you can arrive at that number, just to make it clear, you can arrive at that number by deducting 501,000 or whatever it is from the 742.
okay, so it's your testimony that as of June 30th, 2021, he owed you $241,000.
No, that's not my testimony. I am saying to you that I've said here that he owed me money. Then I couldn't have broken it down.
Okay. And I'm asking you, you just gave me the number $241,000?
Yeah.
So is that the amount that he owed you on June 30th of 2021?
Yes, he did.
Okay, do you know how much money he paid you after June 30th, 2021?
245,000 up until Connell.
Okay, so I'm not 100% sure I'm following all this, but you're saying that whatever he owed you after
Right.
June 30th, hold on, let me finish the question. You said that as of June 30th, 2021, he owed you $241,000, correct?
Yes.
And you,
Well, actually, not true, because he actually, at June 30th, he owed me the balloon payment. He owned the money for the house because it didn't end until, June 30th, right?
how much did he owe you as of, for things other than the property as of June 30th, 2021?
241,000.
And you said that after June 30th, 2021, he paid you $245,000?
Yes.
Okay, thank you.
Between then and I think March 22, I think.
And I'll just represent to you that at least according to my client's discovery responses, and I'm sure your counsel will cross-examine Mr. Gunby on this, I will represent to you that at least according to this, and you said you received all these payments, my client paid you $337,705 after June 30th, 2021. In any event, you never rejected a single payment from the Gunbys after June 30th, 2021, did you?
So, sorry, you're saying that of all the money that I received after June 30th, that adds up to 337.
Yes, but my question to you was, you never rejected a single payment from the Gunbys after June 30th of 2021.
Well, I wouldn't, because he owed me the money.
And you never sent a written notice to Mr. Gunby to the effect that you considered all of his payments after June 30th, 2021 to be toward debts aside from the purchase price of the property. You never notified him of that, did you?
Because the agreement had terminated.
And Mr. Gunby did express a continuing interest after June 30th, 2021 to still purchase the property, correct?
We were still talking about that, yeah.
And when they moved into the property in 2013, you don't recall when the last time you were at the property before that date was, do you?
Between 2013.
When the Gunbys moved, before the Gunbys moved into the property in 2013, you don't know when the last time you were at the property before that was, do you?
No.
And you don't recall when you visited the property at all between 2010 and 2013, do you?
No, I don't really.
Okay. And you didn't make an inspection of the property at any point between the time that you agreed to allow the Gunbys to live there and the date they actually moved in?
No, I didn't. But my brother-in-law is an architect, and I trusted him to tell me what was up with the property.
So you
if
have
there was
no-
anything wrong with it.
So you have no personal knowledge of the condition of the property at the time the Gunbys moved in, do you?
Honestly, I can't recall. I can't recall that. But in terms of when I last saw it, I can't remember when I last went there. I mean, that's a long time ago.
I just want to be clear. You can't say for sure exactly what the condition of the house was at the time the Gunbys moved in, right?
No, all I can tell you is that the people that were living there a few months before the Gambys moved in had no issue with anything in the house.
So the answer is no, you don't have personal knowledge of the condition of the property at the time the Gunbys moved in.
I don't have knowledge because I've seen it, but I have personal knowledge because I was told.
Okay. I think we'll move on. You have no idea whether the pool mechanical system was functioning properly at that time, do you?
No.
You have no personal knowledge as to whether the HVAC system in the basement was functioning properly, do you?
No.
you're aware that the rear patio did not have, the rear patio is elevated, right?
Yes,
And you're aware that it did not have a fence or a guardrail, correct?
it did not.
At least at some, notwithstanding that the language of the May 5th, 2018 purchase and sale agreement expressly references the word improvements, you at least later learned that they had made improvements to the property, correct?
In April 24, yes.
Okay. I'm going to ask you now to turn to interrogatory number 15 in Exhibit D2.
Can you tell me what, found it by accident, page 8.
Yes, Your Honor. Now, interrogatory number 15 asked the Gunbys to list all the improvements they made to the property, right?
Yes,
And in response, the Gunbys listed about 40 different repairs or renovations they made to the property, correct?
yes, they did.
Including the amounts of those repairs and renovations, right?
Yeah. I mean, to be honest, they split up jobs into component parts to make more, but yeah.
In any event, you have no basis to dispute that they made all of the improvements listed on in response to this interrogatory, correct?
I haven't seen these things, so
Right.
I don't know whether they made them or not.
Okay, so you don't have a basis to dispute these improvements.
No,
Okay, and you have no basis to dispute that the amounts that they claim they paid for those repairs and improvements, correct?
no.
Okay. Now, Mr. Gunby assisted you in locating some employment opportunities, correct?
He made some introductions, yes.
For example, to Ernst & Young in March of 2017, right?
Yes,
Which resulted in you obtaining a consulting contract in the Middle East, right?
yes,
And you were doing projects for Ernst & Young through 2020 or 2021, right?
yes,
And you were paid for that consulting work, right?
yes, I was by UI.
And you made more than $250,000 on those contracts, right?
Possibly.
He later offered you direct employment with his company, Connaught Services, right?
Yes, he did.
Which you started working in 2022, correct?
Yes.
You were the chief operating officer,
Mm-hmm.
and you held that position until 2024, right?
Yes.
And between 2017 and 2024, other than some rental income and your corporate pension, every other source of income you had was somehow derived through Mr. Gunby, right?
It was derived through his introduction in the same way that you're here now because of your relationship with the BABG and Arnold Golden Gregory. I mean, that's how it's called networking. I mean, that's what happens.
Right. Well, and some of that was because you were working directly for his company, right?
From 20 to June 22, yeah.
All right. So, and your counsel is asking you about these wise transfers, and just, I guess, so the trial record is clear. Wise is a cash transfer application or something like that, kind of like Venmo.
It's an online bank.
Okay.
It's an online bank.
Right. And I just wanted to make sure that whoever's reading this, because before this case, I had never heard of Wise.
Yeah.
So,
And for the court reporter's benefit, it's spelled like the word, W-I-S-E.
thank you.
And
And
you might find references to TransferWise, which is what it was originally, and then it changed its name to Wise.
right. And the payments that were made through Wise, that even the payments from Connaught were made through Wise.
Yes.
Did you ever have a bank account in Bahrain?
No, I did not.
Okay. So that would explain why the payments were made through Wise, right?
Well, not necessarily. I mean, it was just easier.
Okay. I mean, you paid taxes on all those payments, right?
No, there is no tax in Bahrain.
Might need to consider moving to Bahrain.
You should.
At the time you secured those consulting contracts, the Gunbys were behind in payments to you, correct?
I'm sorry, at the time he secured,
The consulting contracts.
thank you, with EY?
Yes, ma'am.
Okay.
Correct?
Possibly. Yeah, I'm sure. I don't know. I would have to look at the spreadsheets, but can't remember that far back.
During the time you worked for Mr. Gunby at Connaught, he was also behind on the house payments then, right?
He wasn't making any house payments.
So then he was
Making
behind.
any house payments. So he wasn't behind. He just wasn't making any house payments because he didn't need to make a house payment because, the agreement had terminated. As far as I was concerned, he was still living there and not paying me any money.
Other than the consulting contracts and working at Connaught, did you have any other earned income between 2014 and 2024?
2014.
I'm just gonna object on the relevance.
Yeah, I can't, honestly, man, I can't remember.
I'm gonna let him answer.
You never sent a notice of default to them
No, I didn't.
because you were dependent upon Mr. Gunby for brokering those contracts and for employment at Connaught, and you didn't want to take any action that might interfere with the income stream that he was helping you acquire, right?
Wrong.
You contend that between 2013 and 2016, you made 16 loans to the Gunbys, correct?
Yes,
Okay. And those loans totaled $106,000.
yes.
And there's no written loan document for any of those loans, is there?
No,
And there's no promissory note that Mr. Gunby signed for those loans, is there?
no,
And there's no written agreement regarding any payment terms for those loans, is there?
no.
And you said, I believe you said that Mr. Gunby didn't tell Mrs. Gunby about the loans, right?
That's what he told me.
Okay, so you're just relying on what he said. You have actually no knowledge as to whether or not she knew about them.
I don't have a relationship with Mrs. Gunby, and she wasn't involved in the terms of the deal, so.
Does he have your exhibits up there?
No, there's no part,
Okay,
but here's one if you want.
well, yeah, let me do that. I'm sorry, may I approach?
Absolutely, and you don't need to ask, it's just us.
Okay, I would like you to turn, Plaintiffs Exhibit 2, if you would. And this is the spreadsheet that was admitted over objection. You created this spreadsheet, right?
Yeah.
So, and you said this reflects I believe you testified this reflected all the outstanding amounts?
Yeah, this is where I kept track of the utility payments and HVAC leases and pest control and everything that was there between us.
Right. And so you said Mr. Downs asked you about the flex, and you said it was a plug, correct?
Yeah,
And you said you just introduced that as a number to get you where the parties wanted to be?
Matthew introduced that.
Okay. Of this, so the starting number on this is $742,000.
Yep.
How much of that is flex?
Around 100.
So where
Maybe
can
91 or something.
where can we go? What document can we look at that shows all the other amounts other than that 91 that's a plug?
That would be on the spreadsheet that ran through from 2013 to 2018.
Okay, but Is that?
You have that.
Have we looked at it today in trial?
No.
Okay, so we're just going off that we just have a $742,000 starting number, right?
Yes.
With no documentation as to where that number comes from or what is included in that.
I mean, we don't have documentation for anything. This is an agreement between friends. That's the thing, isn't it?
Right, but you're asking.
So yes, we have the spreadsheet that came before where I tracked the utility payments, their rent, their loans, etc. before 2018. And then I created another spreadsheet to do the same moving forward from 2018.
You're saying that as of the beginning of this document, which looks like either June or July of 2018, that my client owed you $742,000, correct?
Yes.
And I want to know, where is the documentation for any of the numbers that make up that we've seen today?
You haven't seen it today.
Okay. And all these numbers in this spreadsheet, do you have any documents that back those up, such as, I mean, the utilities that you've listed here? Are there documents that I can look at to confirm that those numbers are accurate?
I'm afraid you can't go back to 2018 anymore. But you can go back as long as Georgia Power will allow you to go back, as long as Atlanta City will allow you to go back, and you would find that they match properly.
Okay. But have you done that? Did you print out those documents?
I didn't print them out when I produced the spreadsheet because I put those numbers in every month when I got the bill.
Hang on, let me clarify something, because you just used the word when I produced the spreadsheet. You mean when you created the spreadsheet?
Yeah, well, when I was managing the spreadsheet.
Forgive me, the reason I'm making that distinction is as opposed to when you produced it to the other side in discovery.
Well, in that sense, created the spreadsheet.
Thank you. Okay.
So what would happen? I would get the Georgia Power bill every month, as I'm sure you do. And then I would take that number and I would put it in the spreadsheet. And then I would pay the bill.
Okay, so there is some document out there, or there was at some point, that, let's just take, for example, the utility, $495 on the July 18th column here. There's a document somewhere that would have said $495 for utility CRDR, whatever that is.
Yeah.
Okay.
Well, what does it say?
It says
Utility CR, no, there's a separate line item for, I can't see it in front of me, but there's a separate line item for electricity and water, isn't there?
Well, okay, what is utility?
Just tell me, just show it to me so I can see.
I just gave it to you.
And if I can, maybe save us some trouble, right? So I just have general walking around knowledge that if I needed to prove that I paid my power bill in 2013, it would take a great deal of effort, but it probably could be done either through Georgia Power or through my bank.
Sure.
And that your point is that had he wanted to, he could have provided those documents rather than just his testimony?
My point, and this goes to the objection that I had to this document, is that, he's saying that that my clients owe him the amounts that are on this spreadsheet.
Right.
And I'm saying, show me the documents that show that this number is accurate.
Right. And so the reason I interrupted is to say, I understand your point that the absence of documents, both from a practical perspective, an argumentative perspective, and a rules of evidence, if the jury was here, I would instruct them perspective, that if there are documents that would be better evidence, then that goes to the weight and credibility of this witness's testimony.
Right.
So you don't have to keep proving that he could have gotten those documents, because I'm fully confident that he could have. It probably would have been a giant hassle, but might have been worth it. Who knows?
Right.
Go ahead.
I mean,
They're just not available.
right. And simply, Your Honor, and I'll move on after this. My point is, if you're going to say that my client owes you all this money that is based on all of these figures, it would be fair and reasonable for me to expect to verify, instead of just taking on faith that all these numbers are accurate. It would be fair for me to want to look at that, to confirm that what he says my client owes is accurate.
True, but not for nothing. For the better part of 5 or 6 years, your client never said, "Is that really right? Could you send me a copy of the bill?"
I understand.
And he could have done that too. So
Right.
that's how we all got where we are right now.
That's my point, Your Honor. Thank you. Okay, now,
You were asking me about these line items. So,
right,
so the utility CRDR is, honestly, is not apparent, it's some, as I recall, it's 6 years ago, I can't tell you exactly what it is. It's some work that was done on the house that Matthew agreed to pay for. Then, and that finishes, I think there are 3 entries on that from July to October. And then I don't think you'll find another entry under that column for as long as the thing exists. So, and then the electricity and water are quite clear, and they're, you know, they came directly off the bills. But you can't get September 2018 Georgia Power bill from Georgia Power because I tried.
of the 16 loans that you made, 2 of those loans were actually to the Gunby's sons, correct?
They were for the Gumbys to start a business, the Gumbys' sons to start a business.
Right. And those total $10,000.
Yes.
And you have not sued the Gunby's sons in this case, correct?
No, I have not.
And some of the loans were for business expenses, right?
When? Prior to 2018, they weren't at all. Apart from the seed money for the ballet business. And other than the valet business, I didn't lend Matthew money for business. I always gave him personal loans. What he used it for was up to him.
Okay. It's your testimony that none of the $106,000 in loans that you said you made were for business expenses, right?
No, because they were prior to 2018.
Okay.
And he was not borrowing. All these loans came in the early days of the relationship. I mean, 2013, 2014, 15, maybe 16, I don't know, but definitely not much later than that. Now, I did give him some personal loans in 2023, but they're not included in that number.
I'm sorry, you made some 4 personal loans to cover business expenses in 2023, right?
Yeah,
Okay.
Mr. Withers, forgive me.
sorry.
Can you clarify what, y'all have so much more context about
Sure.
depositions, et cetera, that I don't have. What do you mean when you say, I mean, he says he made personal loans, right? Why is it relevant that those personal loans were used for business expenses, and what business were the expenses for, and why is that relevant to my consideration?
Right, because I believe some of these loans, all this $742,000 that he says is owed. My point is that, a not insubstantial amount of that are not personal loans. I mean, for example, he said he made $106,000 in loans to the Gunbys, but he just said that he made that at least of that 10,000 was to the Gunby sons.
Right.
Okay.
But and I understand that, but my specific question is, you were asking him about some of the personal loans were for business expenses. And I'm asking, what business was it? And does it matter that he knew that it was going to be used for that purpose?
Right. That's a fair, I understand your question. And I'll withdraw it, and I'll circle back a different way.
Thank you, sir.
That'll make it easier. you claim that you effectively loaned Matthew Gunby's company, Connaught Services, $296,348,000 in foregone salary and unpaid expense reimbursements, right?
Yes.
But you have not sued Mr. Gunby's company, Connaught Services, have you?
No, I have not.
Okay. But you contend that Mr. Gunby is personally liable to repay those loans those effective loans that you made to Connaught Services, right?
I think what I said was that he has an obligation to settle his debts. And since our relationship in 2013, he hasn't been very good at doing that. So I would like him to settle those debts, right? Now, maybe the deferred salary, right? I'll be very upfront and open. The deferred salary was my choice, right?
Okay.
But I was paying expenses and the salaries of staff when Matthew wasn't even in the country. And I expect those to be reimbursed. And I think there's some honor that needs to go there. But am I going to chase him for it? No, I'm not.
Okay, but my question is, you know, the $296,000, those are amounts that Connaught owes you, right?
Yes.
But you contend that Mr. Gunby is personally responsible to repay those loans to you, correct?
Your Honor, I mean, we're not seeking money.
Yeah, we're not asking for any.
Sorry, there's an objection pending, so you gotta let your lawyer make the objection for you. Go
sorry.
ahead,
Just
sir.
in the interest of speeding things along, we're not seeking money, whether Mr. Gumby's personally liable, I don't see the relevance.
Okay, the
I
relevant.
think I understand Mr. Wither's point. Whether it proves ultimately to be relevant to the court's decision-making is an open question, but I see the point he's trying to make, and so I'm gonna let him try to make it. So keep going.
And the point I'm trying to make, Your Honor,
So overruled. Go ahead.
the point I'm trying to make is that when we get down to the end of this case, we're talking about math problems here, at least in some extent, when we talk
Is
about.
this a question?
No.
It's not. Well, here, I'll tell you, you can stop selling because I've already bought, right? I overruled his objection and said you could continue with that line of questioning. So go ahead.
Of that $106,000 in loans that we talked about, the 16 loans, how much, you can't tell the court how much Mr. Gunby has repaid of that, can you?
I think he repaid it's on the spreadsheet. I think he repaid everything apart from maybe 30, 40,000.
So it's your testimony then that the total amount that he owes you still in outstanding loans is, or at least for those loans, is $30,000 or $40,000?
No.
What is the outstanding balance of
Okay.
the loans, of those 16 loans that you made?
Right. I can't tell you accurately,
Okay.
but if I can explain, can I explain?
Yes,
And
sir.
just clarify this. So, as I've stated previously, that the $742,000 that we started with in 2018 was designed to put together everything that was outstanding for us.
Plus
Including
the
the
cost of the
house.
house.
Yeah.
Okay.
So going back before then is pointless because we've agreed that that's the starting number. And that number was agreed between me and Matthew.
Okay, well, it's on a spreadsheet that you created, right?
Okay, that Matthew had every month and never objected to.
Okay, well,
And it may become a dispute, but so far, Mr. Badham has testified multiple times that this was an agreement he had with Mr. Gunby. And I'll hear from Mr. Gunby whether or not he agrees.
now, in October of 2023, the Gunbys were still behind on payments towards purchase of the property, right?
Okay, no, they weren't.
Okay.
They were behind on payments for expenses. and utility bills. They weren't giving me a penny, even though I was paying the mortgage and all the expenses of the house.
Okay. Turn to exhibit, and I'll put it up here, D3. You recognize this document.
Yes, I do.
This is an October 16th, 2023 email from you to Mr. Gunby.
Yep.
And it concerned a new proposed agreement for the Gunby's purchase of the Colwood property.
Yep.
And you wrote that you were attaching a new draft sales agreement.
Yes.
And you wrote, I settled at the price at the median, I settled the price at the median Zillow price
Yeah.
at the weekend, which will certainly give you value for the improvements you have made.
Mm-hmm.
So at least as of October of 2023, you recognized that the Gunbys had made improvements to the property, right?
Only the roof and the retaining wall. I knew nothing of anything else.
And you certainly recognized that those improvements had added value to the property, right?
No.
Well, what you said was, which will certainly give you value for the improvements that you have made.
Right. So you spend money on the property, you'll get some value for that.
You said if this
Right?
doesn't,
Because I could have not settled on the median Zillow price. I could have settled on the highest Zillow price.
Okay.
But I was giving them an option, to say, if we do this, then if you're going to have some, say, if that's the median Zillow price, then the range was probably, what did I say, 750, whatever it was. So the range was probably 690 to 850, right? So if you buy a house at 750, but you can argue that it's already worth 850, you've got some value, yeah?
you said if this doesn't work, you can move on to a rental agreement with a right of first refusal or an option to purchase for 3 years, right?
Yes.
So at the time you sent this, the Gunbys were not on a rental agreement, were
No,
they?
they were not.
And you never provided a rental agreement, did you?
Nope.
And and I believe this was previously marked as well, but by your counsel, but I'm going to, if you take a look at Exhibit D4, which is the draft, the October 14th, 2023 heads of agreement. And again, you prepared this document, right?
I did.
And it provides for a purchase price of $764,000, right? And this is the
I'm sorry,
number.
is that a yes?
Yes, it is.
Thank you.
Sorry. I'm forgetting my yeses.
That's okay.
And you got this number from Zillow, right?
I got that number what?
From Zillow.
Yes.
And I guess, so the record is clear. I think maybe Your Honor may have asked it when he was on direct, but Zillow is a website that lists homes for sale and also provides what it considers to be the market value of houses, even if they're not on the market, right?
Yeah, it's a range.
I think they call it a Zestimate,
Yes, Your Honor.
but I'm very familiar with Zillow.
Yes. And I'm sure the court is, but I don't know who else might be reading this transcript.
Absolutely understand, Mr. Withers.
So, okay, so that as of the date of this document, Zillow had presumably listed the value of the Colwood property as $764,000,
Is that a yes? Thank you.
which, and you understood that to be in the middle of the range of the fair market value of the property, right?
Yes.
Out of curiosity, do you know what the value of the home is according to Zillow today, or the Zestimate today?
No, I did.
Okay, well, I'll represent to you that at least as of 2 days ago, it was $820,900. But in any event, in 2018, the purchase and sale agreement that we looked at, Exhibit D1, the parties agreed on a purchase price of $450,000 for the property, right?
Yes.
So would you agree that between 2018 and 2023, the property increased in value from $450,000 to $764,000?
Yes.
And you have no idea one way or the other whether any of that increased value was due to the improvements that the Gunbys made at the property, do you?
No.
The parties never executed this agreement, Exhibit D4, did they?
No.
Now, I believe you testified earlier, and please correct me if I'm wrong, because I just didn't write it down, but I think you said that from October of 2023 through April of 2024, you had some discussions with Mr. Gunby about the possibility that you needed to sell the Colwood property. Do you recall that?
Okay, so what I said was, and this is the reason for this, is that the business wasn't doing very well. Like I said, I wasn't getting paid. The reimbursements were coming sparsely, sporadically. And so we were talking as friends at this point about, hey, I've got some problems here, right? Because I'm running out of money. I can't carry on subsidizing your family in Colwood Court. I'm going to have to make some decisions. I'm going to either have to put some debt into a condo that I have in Midtown, but that's really hard because I don't have I can't produce US tax returns, which would get you a mortgage. Or I'm going to have to sell it. Now, I said, if I sell the condo, then I'm going to have to sell the house because I can't leave you in the house for free, right? And me having to sell another property is just not right.
So at least as early as October of 2023, you knew there was a possibility that you might need to ask the Gunbys to move out of the property, right?
Yes, and I was very upfront with Matthew about that.
You didn't tell him at that time you needed him to move out, did you?
No, I didn't.
And then you met with Mr. Gunby at the Colwood property on April 12th of 2024, right?
Yes.
And you told him you needed to sign some documents at that time, right?
Well, because I managed to find an asset-backed loan to take out a mortgage on the previously paid off condo that would use the rent, because we rent that. So they would use the rental income to pay the mortgage, to originate the mortgage.
Right. And you needed Mr. Gunby to witness your signature, right?
Yeah, well, I didn't need Matthew to witness my signature. What they wanted me to sign the document in my main residence, which has always been listed as Colwood Court.
Sorry, you said.
So I asked Matthew to do that.
Well, you told him you needed him to witness. The reason you came to the property is because you needed him to witness your signature, right?
Oh, okay. I could have asked, somebody else to come to the property. It was the property that needed to witness the signature, not the person. But Matthew was in the property and he was my friend. And I said, can you witness? And he said, yes.
I apologize. When was this?
April 2024.
Okay, I thought there had been testimony earlier that Mr. Badham hadn't been to that property and hadn't seen it and had no knowledge of its condition.
That was in 2013.
Thank you for the clarification. I appreciate it.
Okay, well, this is new information that you didn't share during your.
I think I did.
In your deposition?
I think I shared it with you before.
No, I'm sorry. The point about that, the reason you went to the property was because they wanted you to sign a document while you were physically located in your main residence.
Is that a yes?
Yeah, that's a yes. Yeah,
Okay.
that's what they asked me to do because it's just the nature of the rules, I guess.
Okay. Anyway, you saw Mrs. Gunby at the house that day.
Yes, I did.
And you had a conversation with her.
Yeah.
And she told you she was thinking about replacing the kitchen.
Yes.
And you didn't say anything to her about the fact that you would need to move back into the property and that she would need to move out.
Well, one, it wasn't decided then. And two, Matthew had requested, since he started borrowing money from us, that she was not to be told about things like that.
When you first approached them about moving out, you said it would be just for 3 years, right?
No, I didn't say that. I said, our son needs to go to high school for 3 years. and then possibly we'll move back to Europe. And then, you know, whatever the price is for the house, then maybe you can have the right of first refusal. I mean, that was it. These are conversations amongst friends who are trying to make this thing palatable.
So is it your testimony that you did not tell them that, hey, we'll just move in for 3 years and then after my son graduates high school, we'll move out and you can move back in?
No, I didn't say that.
Okay.
And not so concretely. We said, you know, he's got to be in school for 3 years. Maybe we'll move back to Europe. And that's what it was, because who knows what happens in a year, let alone 3 years.
The reason that you wanted to move back was because your son wanted to lessen the intensity of his tennis regimen, right?
Okay, that was one reason. That was one reason. The other reason was that we had no money, and that was more pressing.
At no point in time, again, I think we've established this, but at no point did you ever send a default notice, right?
No,
Never, up until this lawsuit or till April of 2024, never demanded that they vacate the property, right?
up until we asked them to leave in
Right.
April.
Through all the missed payments and the unpaid loans, right? And never was there before, well, I guess, for the initiation of this lawsuit or this dispossessory proceeding, never demanded that they vacate the property. And there was never any written document terminating the purchase and sale agreement, right?
No.
If you'll look at Exhibit 5.
Are you putting it on the screen or do you want me to?
Oh, I'm
put something
sorry.
here?
Okay. So Your Honor, we already admitted this one.
I believe that D5 was on the list of things that Mr. Downs did not object to, but I don't know that it's been offered by anyone yet.
It is actually,
Is it P something?
It may,
Okay.
I just wanted, my question is, do I need to authenticate?
Better to have it in twice than to not have it in at all. Mr. Downs has indicated that he thinks it was already admitted, but either way, Mr. Downs has already indicated he has no objection to your admission of D5.
That was my question. Okay, thank you. So this, again, this is an email that you sent to Mr. Gunby on December 30th of 2020, right?
Yes.
And you said in the second line, you said there have been no payments for 20 months and the agreement, technically void at the moment, is due to end in June 2021. Do you see that?
Yes.
And to be clear, you continue to accept the payments from the Gunbys toward the purchase price of the house after you sent this email, right?
Yes.
And in fact, you did not treat the purchase and sale agreement as having been terminated, correct?
Well, I think both things are different. I assume that I guess what I had in my head, and bear in mind, I'm not a lawyer and, you know, I'm not a commercial real estate investor. And I wanted Matthew to buy the house and to complete the purchase.
Thank you.
So, right, yeah.
If we look at Exhibit D6, I believe this was previously admitted. We look at the initial email in this chain, which is is on page 2 of this document. You see where you wrote, "Good morning, you better have this." You said you wanted to catch up the Coalwood position.
Yep.
So with the payments you made to me in August, the current state is, and then it goes on. Do you see that?
Yep.
So this is in September of 2022, right?
Yep.
And Mr. Gunby had made payments to you toward the Coalwood position as recently as August of 2022, right?
He paid for some utilities, yeah.
How much did he pay in utilities?
I think 15,000.
And that was the amount, what was the amount of the utilities owed at that time?
Probably 40,000.
Yeah, but we don't have any documents that show that, right?
You have my spreadsheet.
Right. Okay, so then you said, Mr. Gunby responded to you on the next day on September 10th, 2022, right? Let me go back to this $15,000 payment. You said it was for utilities. Did Mr. Gunby tell you that it was for utilities? Or is that just how you elected to apply it?
No, I think he said I've sent you. I think he sent me some sort of WhatsApp saying I'm sending you money for the utilities or the house costs or something like that.
What was it, the utilities or was it the house cost?
Yeah, but the house costs, the house expenses. I mean, that's what it means.
So you testified that it was for utilities. I'm trying to.
Okay, what are the costs of the house? So, no, he didn't say it's for the electricity, it's for the water, it's for the pest control. He said it's for the cost because all he's paying me for now is expenses. All I'm asking for is, hey, pay me the expenses of the house because I'm paying all your bills.
Okay, so if Mr. Gunby testifies that all these payments that he made after June 30th, 2021, that he thought he was paying towards the $450,000 purchase price, you obviously disagree with that.
Yeah.
Okay. Then on September 10th, 2022, you responded back to Mr. Gunby. This is at the kind of on the bottom, well, kind of right in the middle of the first page of Exhibit D6. And you wrote,
I can't see it.
sorry, it's in the binder there in front of you.
Where is it in the binder?
Exhibit D6. But in any event, I'll put it on the screen for you. Okay. So in the second paragraph of your September 10th, 2022 email, you wrote, I misunderstood you about the catch up for Colwood. I mentioned that as the deal did not end in July 21st, 2021, I was still carrying the monthly mortgage, tax, and insurance when I anticipated this would be gone. This represents $2,172 per month. Utility bills run around $600 a month. In addition to this is my rationale for the numbers. Do you see that?
Yes, I do.
So again, in September of 2022, you have expressly told Mr. Gunby that the May 5th, 2018 purchase agreement did not end on July 1st, 2021. That's what you said, right?
No, that's not what I said.
That is, okay, what you said was,
So let me save you some trouble. I don't think he's saying that he didn't say the words that are on that page, that he didn't send that email.
Yeah.
Feel free to have a conversation with him about what.
sure. You came up with an explanation earlier today about what it was that you meant by that, right?
Yes.
And that is not what you said during your deposition, was it?
In relation to this, I think it is. You know.
Okay. You testified that the rental value of the property is $5,000 a month?
Possibly.
Possibly. Okay. And that's what you got from Zillow, right?
Well, yeah, part of that, yeah. Zillow and other sites, and I took a ballpark. Yeah.
Okay.
Ultimately, it's going to be whatever somebody would pay. But that's what similar properties are going for.
Do you have any documentation that shows where you got that number, or would we just have to look at Zillow?
You just have to look at Zillow.
Section, if we go back to Exhibit D1, section 2.6 says, if the seller wishes to cancel this agreement, notice must be provided in writing. All payments made by the buyer prior to the notice of cancellation will be due back to the buyer within 90 days of such written notice. Do you see that?
I do.
And you contend that the purchase and sale agreement terminated by its own terms before June 30th, 2021, because the Gunbys had failed to make certain payments, right?
Yeah, they hadn't made 20 payments.
But you later told Mr. Gunby in writing that the agreement did not terminate, right?
No, I didn't say that at all.
That's not what it says.
Okay.
So I can read and I see what it says, and it appears clear to me that the parties have different understandings of what those words meant,
Right.
but the words are there.
Right.
The termination isn't there in
Right.
the email.
I want to go back to your deposition. Bear with me, I'm having mouse troubles here. Okay, I understand that we have a difference of interpretation as to what you meant when you said the agreement didn't end, but I just want to go look at your testimony in deposition. And you see on page 144,
Yeah.
it says, I said, you never canceled the PSA, correct? And you said, well, the PSA canceled. The PSA canceled itself because he didn't make any payments under the PSA. He didn't make the right number of payments. Yeah. And I said, yeah. Then you later stated that it did not terminate in 2021, right? Your answer was yeah, correct?
Yeah.
Okay.
I saw that. And
So-
I would like you to show me where I stated that.
That's,
Because I think you mischaracterized what I was saying about the end of deal sentence.
I'm just reading the questions. Then
I mean, it's very clear. It says that I stated that it did not terminate, and I don't think I did state that at all. And in my head,
later,
we're carrying on a discussion about the end of deal.
Mr. Withers, can you direct me to the page that you're reading
Yes.
from in the depot?
I'm sorry, it's page 144.
I think you said it, I just didn't get there fast enough.
No, I'm sorry, 144.
Go ahead, Mr. Withers.
Yeah, I just want to make sure that I'm reading our conversation correctly. And I said, and this is on line 8, then later you stated that it did not terminate in 2021, right? And your answer was yeah.
Yeah, but
Thank you.
remember, at this point, you were shouting very loudly. You were swinging the agreement around your head like you were going to lasso a steer. And, you know, I don't think I ever said that. And in my head, we're still talking about the email where I say the deal didn't end. And that's what the discussion is about. And I think you conflated the two things. And I think you mischaracterized deliberately what I said in order to get your little gotcha moment. Right? I mean, that's it.
All right.
Hang on, I apologize, Mr. Withers, but did you say page 141?
144.
Thank you, because I'm rereading 141 and it's not there. Thank
It's on
you.
144.
Thank you, sir. Mr. Withers, sorry for the interruption. Go ahead.
No problem. I'm sorry. Mr. Badham, is it your testimony I was yelling at you during your deposition
Absolutely.
and I was swinging the agreement around like I was roping a steer?
Don't you remember that?
No.
Oh. There was no video of that deposition, but it was quite funny.
Sometimes I wonder if we were at the same deposition. In any event, you never refunded any of the payments the Gunbys made, did you?
No,
And you've never reimbursed the Gunbys for any of the improvements that they made to the property, have you?
no.
And if this court rules that you and your wife are entitled to resume occupying the property you would, of course, enjoy the benefits of those improvements, right?
As they've enjoyed the benefit of living in a subsidized house for the last 13 years.
So if you could just answer the question, that would be great.
But we would live there, yes.
And you would enjoy the benefits of all the improvements they've made to the
I
house.
don't know, because I don't know what the improvements are in the main.
You might not enjoy them. Right? So
Right.
keep going.
Fair enough. You would have the ability to use the improvements, whether you enjoyed them or not, you'd have the ability to use them, right?
That's got to be true.
If the court rules that you and your wife are entitled to resume occupying the property, but that you have to refund payments that the Gunbys made towards the purchase price, you believe you're in a financial position to be able to do that, correct?
Yes.
Objective form.
I feel like I'm going to sustain the objection primarily because the parties' respective financial positions isn't relevant to the court's decision. I can enter a judgment for $1 billion, and whether they can pay it or not really doesn't matter.
Okay, fair enough. Your Honor, that's all the questions I have at this time.
Okay. I have a couple of questions, and typically when I do a bench trial, what my typical practice is I'll ask a few questions, and then to the extent those questions messed up y'all's examinations, you're free to follow up or any other follow-up that you wish. But in this case, I think what I'm going to do is ask a few questions, and I'll throw it over to y'all, and then we'll probably take a quick break before we move on to the next witness.
Can I retake my position there, or do you?
Oh, no, absolutely. Go
stay
ahead.
here? Thank
Feel
you.
free to have a seat. And I don't have many questions. I do think one thing, Mr. Badham, that I am a little confused about, and I asked you right before we broke for lunch about the fact that your spreadsheet continues to credit payments that are being made for Mr. Gunby against this total $742,000 debt. Is that fair?
On its face.
Okay.
Yes, yeah.
And is it accurate that the reason you were doing that, it seems to me from your testimony that you were treating this as a global sum that was owed to you, of which the house was a part.
Yeah, at the start it was, yeah.
Okay.
And then I just didn't, it's full of formulas. So then I was using it to track the payments for utilities. Then I was using it to track the expense payments. Then I was using it to track the loan repayments, things like that. But the formulas just recalculate as if the whole sum is there.
Right. Okay. And you mentioned when you were working with Connaught, I heard you testify there were salary forbearances. You might have used a different phrase.
Deferred.
Thank you. Deferred salary payments or deferred reimbursement for payment advances that you made to keep the business interests going. Is that accurate?
Yeah. That's
And were those, I guess I'm a little confused as to how it seems from some of the emails, well, it seems from your spreadsheet and also from some of Mr. Gunby's emails that both of you were treating some of those monthly payments coming from Connaught as crediting against other things besides your work for Connaught.
I wasn't.
Okay.
So they were very clearly for Connaught.
But the reason I'm confused is you credited them
No, they're
on
not.
that spreadsheet. They're on.
Didn't.
No, you didn't.
No, those
Okay.
payments are not on the spreadsheet.
I see. Okay.
Right. Only honestly through 24, 23, 22, 23, 24, the only payments that are on the only things that are on the spreadsheet are utility costs. And if you made some payments towards utilities or something, then I would put those on. And then post the, so I mean, that's really what it was. But the Connaught numbers are not on that spreadsheet.
Okay. And then the next question, I think it might be the only other question I have for you, but on Defense 4, which is the new proposed agreement that you communicated in October of 23, you start off with a dollar figure of $764,000, and then there's discussion of a down payment. Can you help me understand how it was that you came to that dollar figure and what you were or were not accounting for the prior payments that had been made under the old agreement?
Right. I wasn't accounting for any prior payments.
Okay.
Not at all.
Okay.
And I arrived at that number, one, the sales price, because it came from Zillow.
Right, sure.
And then two, Matthew and I were trying to generate business. And if I'd have said to him, you know, you need to pay $12,000 a month, he wouldn't have been able to do it. So, but I wanted the costs of the house covered because I was being choked with the covering their costs for 2 years without their participation.
And hang on,
Yeah.
forgive me for interrupting you, but to go back to a disagreement you and Mr. Withers had a moment ago, here, when you're saying costs, you mean the cost to maintain the property.
No, that's so
Minimum
having
wage.
there is the mortgage,
Right, the minimum-
utilities, everything that I was outlaying.
That's what I was clarifying, is that what you mean when you say that is, in this agreement, you were hoping to at least cover the
At
cost
least
of
cover the cost.
maintaining.
And then,
We can't talk over each other either. I
Sorry.
apologize, because she'll get mad at us. She can't take it down.
it's all right, I get excited.
That's okay. So, but just in this one context, what you mean when you just said costs was you were hoping out of this agreement to at least get a payment that would cover the outlays you were making.
Costs, yeah,
Okay, okay.
that's right. And then with the balloon payments at the end, you know, we would hope, right? And we both hoped that the business would, you know, be in such a place where that would be facilitated. You know, that was the idea, but that would allow, you know, the payment schedule, the $70,000, because I needed that to live, and what have you, would have paid something, but he didn't have the money for that either. So, you know, I mean, it was moot, really. I mean, we were trying our best, but we were not being so successful.
Last question. You were asked, and it's a really minor point, you were asked about some improvements that the Gunbys indicate they made to the property. And I think you were asked about like a hot water heater and maybe a few other things you said you didn't know about.
No, the heater I did.
Okay.
The reason I knew about the heater, the HVAC and the water heater, is that at first they didn't tell me they wanted to do this.
Right, and that was the HVAC was really what I was getting
Right,
to.
so the HVAC.
Okay.
So, and the HVAC and the water heater together, really.
Okay.
So just like all the other work that they did there,
Mm-hmm.
apart from the roof and the retaining wall, they never told me about it. They didn't mention it. They went and picked a water heater and a HVAC system. But actually, I might be right. I think they said we would like to replace the HVAC. I think they may have said that to me.
Well, let me interrupt. The reason I'm asking the question is because some of the utilities you list historically throughout your agreement include this aircon lease thing, and I'm not sure I understand what that is.
Okay, so I'll explain. So what happened was they wanted to replace the aircon. Now, I would just replace the aircon with what was there before. They wanted a bigger system, I guess. I'm not really familiar with it.
And also, sorry, brief interruption, just to make sure we're not having a confusion because of British English and American English. When you say aircon, just a moment ago, you were referring to HVAC. Those are the same things to you, right? Because they're the same
They're
things to me.
absolutely the same thing to me.
Okay, making sure.
So just anything that provides hot and cold air and water,
right?
Right. So that's what we're talking about. So they wanted a much bigger system, but Matthew said, "I can't afford to buy it. I need to lease it." The providing the willing, reliable, I think it was, are willing to lease this, but they won't lease to me
Because he's a renter.
He's a renter. He doesn't own the property. So I contacted Reliable. I organized the building permit. And bear in mind, you know, nothing else they did was permitted. But I organized the building permit for the HVAC, and then they did the work.
Okay.
And that was under a lease, which I had to pay for, and I continue to pay for that.
Okay.
Now, the initial agreement when that came was that the Gumbys were going to pay for it.
Sure.
But they never did that either. So, and, you know, that stays with the house. So I guess, you know, whatever.
Okay.
Yeah, so now I only really think about the electricity and water and things like that as
Okay.
something that they should reimburse for.
Okay, thank you, sir. I appreciate that. Those were all of my questions. Mr. Downs, did you have redirect or any follow-up on those questions?
I don't, Judge. I don't think I have anything.
Okay, any follow-up on my questions, Mr. Withers?
No, Your Honor.
Okay. So, Mr. Badham, you are free to step down. It is 3:26. I'm going to take a break until 3:45, and then we'll come back and keep on plugging along, okay?
Okay.
Thank you.
Thanks.
You can leave those up there. Oh, I don't,
Okay, you don't need it back.
Yeah, he might want it for another witness.
Okay, got it.
Sorry, I snuck back in. I'm a couple of minutes early anyway, so.
No. You're allowed to do whatever you want.
I was speaking at a panel for women lawyers, and always there's discussion about work-life balance, which of course now we refer to as, apparently I'm told, work-life integration. It sounds like HR speak, but I made the comment, because it was about women leadership and all the women on the panel were judges. And I was like, well, here's something. If you aspire to be a judge, here's a really good reason. At the end of the day, it's really easy to balance your obligations because you control everybody else's schedule. So.
Yeah. That's right. It's so funny with the like the Zoom layout, like I was saying, everyone can see everybody. I was telling them before that before Zoom, my aunt was a judge here, Judge Downs.
Oh, I love Judge Downs.
Yeah, and during one of her trials, that was on TV. My grandma called in and made the clerk or the bailiff move the water bottle because it was blocking my aunt.
So true story. My mother, a lawyer's whatever, but once Zoom happened, she was like, I want to see you in the courtroom. And so similarly, she wanted to watch Zoom. So I gave her the Zoom and my sister got it all set up on the computer. And she called me when it was over and she said, oh, sweetie, you sound so smart. Also, you need to get your roots done. Thanks, Mom. That's what moms are for, right?
That's what they know.
That's right. That's what moms are for. Oh, goodness. But yes, Judge Downs actually, I've told her this, Judge Downs gave me my first, smackdown summary judgment motion. I was a civil defense attorney and I filed a summary judgment motion that I thought really had some merit, but it's always close. And we walked into the courtroom and she was like, yep, you get summary judgment. I mean, I walked out like I was the second coming. It was awesome. I was very excited. It was a good day for a young associate.
That's my aunt. Yeah.
Oh, okay.
Yeah, it was a really good day for a young associate. So
you take the wins when you can get it. Yeah.
Exactly. Okay, so we are back on the record, Madam Court Reporter. And Mr. Downs, you may call your next witness.
One question, Your Honor.
Yes, sir.
Quick, I believe the court reporter, I don't know if she addressed it with you, but we had a question about the exhibits. And I believe your ruling on Exhibit 2 was that you were going to admit it for limited purposes. So
it was, what I said, I think, was conditionally admitted. It's now fully admitted, except it's not the whole exhibit. It's the portions of the exhibit that you referenced. And then to the extent you need the cover page and the signature page to make it complete, et cetera. That was my ruling.
And that's fine. My understanding was that we didn't, to the extent it was, I misunderstood you, as to the stuff that was not disputed, are those in evidence now? Do I need to formally move to have those put in evidence? Or it's kind of my understanding that if it wasn't objected to and we started discussing it, that's in evidence.
So the only ones that I'm aware of that were an open issue, right, were D2, which we're discussing now, and then D8 and 9. Right. D8 was Mr. Badham's deposition, and you've directed me to testimony that you believe impeaches his prior testimony, and right. And that's in. And then as to the discovery responses, the response to interrogatory number 8, which is multiple pages. And then there was one other interrogatory, and I don't remember which one it was. 15. Yes, thank you, which also is an answer that spans multiple pages. Those were the ones that I had written down. And those were the ones that, to my understanding, are admitted. because we've discussed them and I allowed them. But the rest of them, unless you call my attention to a different portion of, I don't intend to consider in my deliberations.
That's fine. And just so the record is clear, to the extent, you know, I move to admit all of the exhibits that I use subject to the court's, you know, statement that on 2 and 8, I will only consider these portions.
That's correct.
Thank you.
Yes, sir. But otherwise, your exhibits are admitted
Thank you.
with the limitations I've just outlined. Yes, sir.
Yeah, the only thing I would ask is, or query about is his deposition transcript. I mean, I understand Mr. Withers impeached him with specific pages, but the whole document is admitted into evidence?
No, what I just said is he's directed me to portions of it that he believed impeached Mr. Badham's testimony.
Those portions.
And I'm going to consider those portions.
Okay.
And that's what I believe to have been admitted, not the deposition in its entirety and not the interrogatory and request for production responses in their entirety.
Yes, Your Honor, that's my understanding as well.
Okay, and technically, because Ms. Badham has not taken the stand, her deposition isn't yet in evidence at all.
Understood.
Okay. Mr. Downs, did that address your concern, sir?
Yes.
And Mr. Withers as well?
Yes, ma'am.
Okay, you may call your next witness.
Without further ado, I'll call Ms. Badham.
Okay. You're fine, Deputy. Come on up, Ms. Badham, and I'll give you the same instruction. Please be cautious about when you sit down. Get situated at the microphone and make sure to keep your chair away from that ledge, okay? Once you get sat, well, before you get sat down, will you raise your right hand? Do you swear the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, thank you, ma'am. Now, if you will get situated and scoot up to the microphone, and then if you will start by stating and spelling your name for the record, okay?
Okay. My name is Liliana, Liliana, Del Rio, Delrio, Badham, so hyphen Badham.
Okay, thank you. I'm sorry, Mr. Downs, you
Yeah,
may
no worries.
proceed.
All right, Ms. Del Rio Badham, good afternoon. Just a few questions for you. You personally reached out to the Gumbys about vacating Cold Court, correct?
I did.
Okay, and you recall when that was?
It was in May of 2024.
And how did you reach out to them?
I first I called Kim, well, Yvette, so we know her by Kim, using WhatsApp. And I asked her for her email address, which she gave me, and then I sent her an email.
Show you the email that you're referencing?
Yes.
Is what's marked as plaintiff's 11. This is the email that you sent to Ms. Gunby?
Yes, because I had first recorded a message, I remember now, and then I sent her this email.
Okay. And what was the purpose of sending this email?
The purpose was that, well, I was getting really stressed that we didn't receive any news from Matthew about when they were going to move out of the house. And we were, like Keith explained before, not only were we paying our rent in Spain and paying all the expenses and the mortgage of the house in Colwood Court, we were also paying tuition for our son to be in an international school. So I found it pressing to come to the US where I could go back to the hospital and get employed again, and Felix could go to school tuition free because we were entitled to, that school district, having been there, and having had that address as our address for so many years. And I needed the house in time for Felix to start school. And Matthew had gone back and forth saying that, yeah, I'm going to talk to Kim about it. And I said to Keith, okay, I'm really tired of this because this is very stressful. Because he had instructed us the whole time of our friendship, well, during this time when we loaned them money and let them use the house, and then, they lived there and then tried to buy it. one thing had been strictly cautioned about was talking to Kim about any money matters because she was very anxious about money and she could get sick. And anyway, so at this point, I just said to Keith, if Matthew doesn't say anything to you about when they're going to leave the house by a certain date, and I can't remember what date I told him, I'm going to just write to Kim and tell her what's going on. And so I remember that it was like we were in Barcelona. I had a little girls' trip to Sevilla with my friends, and the date came when I was sitting with my friends, and I said, okay, I've got to write this email because the date is today. And I wrote her this message, which was to inform her that, maybe you're not aware of what's going on, but we really need to get back to the US so that Felix can start school, and we need the house. And, it's been a long time. You've enjoyed the house for 11 years. All your grown sons, because when they moved into the house, they didn't have any minors. They were all, I think maybe one was 17, but everybody else was grown men. You enjoyed the house with your boys for this time. They all now have jobs. They've gone on to get married. So is it fair for us to move back to our home that we're paying for, was the subtext, and Felix can enjoy it and finish high school. And so this is what I wanted to say with this message. I thought that it was a very nice letter. I expected her to call me back or reach out to me, which is what, if I got a letter like this, I would have reached out and tried to clarify what it meant, but I just got radio silence.
So you never received a response to this email?
No. I then started to call her daily to see if she would talk to me on the phone about this, and she didn't pick up the phone. She did, I think at week 2 or 3 after this, she sent me a very short WhatsApp saying, we will not move out of our home. I can look at stuff that's being rented in the area so that Felix can go to school. I'll be happy to help you with that. And that was it.
What year of school was Felix starting?
He was supposed to start 10th grade.
And he's in 11th grade now?
He's in 11th grade now.
Okay. Was there anything that you heard in Mr. Badham's testimony? Was there anything that he testified about that he got wrong?
There was one thing when Mr. Withers asked about, have you ever done any work to a property that you've rented? And I could remember several, but in particular, in 2018, we moved into a very old apartment in the middle of Bordeaux, France, and it was a rental, and it didn't have much of a kitchen. There was nothing there. It was just basically a space. And I said, we need a kitchen. And we went to IKEA and ordered a kitchen and put it in. We knew we weren't going to get reimbursed for it, but I sort of divided the cost of the kitchen by 4 years that we were going to live there and said, okay, our rent is X instead of this. And now we have a kitchen. And we knew we were going to leave it there. We weren't going to get any money back, but just what made our life comfortable. And
getting back real quick to this email on Plaintiffs 11, it looks like you specifically gave Ms. Gunby a date of July 15th to vacate by?
yes, I wanted to be fair and also to abide by the law. And when I was writing this email, I assumed that she didn't really know what was going on. So I wanted to give her the proper 60 days notice. So I said, hey, I know that Keith has been talking about this with Matthew, but maybe she didn't know. So I wanted, take the 60 days from today. Because I need you to be out by July 15th so that we can get beds in there and get Felix to school. So that was the purpose of that.
Is there anything else I haven't asked you that you feel like you need to tell the court today?
I feel like this is very unfortunate, and that's the only last thing I'm going to say is that, we thought we were doing all these questions about, it seems that everything gets deconstructed, and the story is that we always thought they were our friends and that they were honorable people. And even throughout, I mean, I guess it's kind of like the story of the frog in the water, that you're in the water and the temperature starts to rise slowly and you don't realize until, gosh, I'm getting cooked here, I got to jump out. And that's when we had spent all our savings. We were paying rental in a house in Spain. We were paying all the expenses in a house in Atlanta. We had no income, and they were happily enjoying a vacation apartment that they rent in the middle of Barcelona, but never paying us any money. And I thought, well, this is untenable. We can't sustain this anymore. I have to go get a job in Atlanta. I have to put my son in school, and I want to go live in the house that I am paying for. And they need to understand that we've done, I mean, they've lived a beautiful 11 years in this house. They've enjoyed wonderful times there. All their kids got together after they were living separately in different apartments when they didn't have a home. And, they came together and enjoyed all that life, the termination of their youth, their marriages, whatever. Now, isn't it fair that we go now back to our house? And what I expected was for them to say, Liliana and Keith, thank you for having helped us for this time. I didn't expect a letter from a lawyer. And that's all I have to say. But we've been living, because we're still living it. We've paid $50,000 worth of rent in the apartment we're living in today. I owe $10,000 worth of storage in Spain, and I have to pay you. So I just want to burst into tears, but I don't want to embarrass myself. And that's all I have to say.
Thank you. Mr. Withers?
Good afternoon, Ms. Del Rio, Badham. The kitchen that you mentioned in the apartment is that Bordeaux, France?
In France, yes.
I mean, it's obviously in France, it's not in the United States. It's tradition in Europe that people typically take their kitchens with them when they move out, right?
No, I've lived in several apartments in Spain, France, and I've never put in a kitchen. That was the only one time.
But a lot of properties are rented without kitchens, right?
I was never in one. That was the first time.
And you said that, in that when you bought the kitchen from IKEA, for that apartment, you were not under a contract to purchase that apartment, were you?
I was not.
Okay.
I was paying rent.
Right. Okay. And you said, that throughout this time, the Gunbys weren't paying you anything. That's not exactly true. I mean, they paid $452,000.
They have paid money in bits. We've been desperate, and because they were our friends, and I can't believe we did that, we've been so many long periods where they didn't pay us anything, and we've had to max out our credit cards, do all kinds of, arrangements to cover our life. And meanwhile, later, and I had a couple of arguments with my husband about this. Is Facebook, I learned that they all traveled to Europe with their boys and their wives for a family reunion, that they bought a brand new car, that they did all these things. They were never missing a payment in their apartment in Barcelona. And then we learned they were making renovations in 2020. In 2020, we did not receive one mortgage payment or one utility. Well, it's easy to make renovations and spend all your money putting gazebos up when you don't have to pay rent or mortgage. They were doing it with our money.
So they did pay you the $452,000, right?
Well, divide that by 11 years of rent, and then maybe it's a small rent that they paid for living in a beautiful house with a pool and with 3 bedrooms and a gorgeous fireplace. So, nobody gets to live for free. I don't know that anybody gets to live for free anywhere. We didn't.
Sorry, my question was, they paid you $452,000, correct?
They paid a small amount of money to live in a house where they never worried about a bill. They never worried about getting their lights turned off. They never worried about, I wonder if the water is paid, or if my house is going to be filled full of bugs because pest control hasn't been paid. So I think they paid barely what they needed to pay to live there for 11 years.
And that amount, that bare amount that they paid was in the neighborhood of how much?
It was in the neighborhood of what my husband who has the numbers here, has told you.
You would agree as well that there was no written lease agreement between the parties, correct?
We were friends, so we basically borrowed the house from us. And Kim was under the impression they were paying rent, but from the moment they moved into the house.
Forgive me for interrupting. I understand where you're going. So this is not a natural process, people testifying, because it's not how people talk, right? So I understand. But it would be very helpful for me, for Mr. Withers, and for the court reporter, when you get asked a yes or no question, you are absolutely entitled to explain your answer.
Okay.
But it would be very helpful if you could start with a yes or no, if that's a possible answer you can give.
Okay.
And then explain.
All right.
And so just for the record, Mr. Withers, if you will please re-ask your question.
I will. Honestly, I can't remember what the question was. Madam Court Reporter, can you read back the question?
Yes.
Oh, I remember the question. Never mind. The question was, there was never any written lease agreement between the parties, was there?
No.
Okay. In Exhibit 11, that your Plaintiffs Exhibit 11 that we just looked at, you wrote, "We always thought you would end up purchasing the Colwood house, but throughout the years, the agreement remained a lease." But violated the rule, sorry.
Don't worry about it.
But there was no lease agreement, right? No written lease agreement.
There was no written lease agreement. I was referring to a decency agreement that you don't get to live in someone's house for free, and they were aware of that.
Okay. You were aware of the agreement between your husband and Mr. Gunby by which your husband agreed to sell the property to the Gunbys, right?
Yes, I was.
You did not participate in those negotiations, though, did you?
I did not.
And you didn't receive notices of the payments that Mr. Gunby made towards the purchase of the property, did you?
Every time he sent a payment, Keith showed me the running chart. And where they were in payments.
But he didn't tell you about each and every one of those payments, did he?
Everything that was in the spreadsheet, yes. And I saw the spreadsheet.
The way you know about the payments is because just of what Mr. Badham told you, right?
And showing me the spreadsheet, yes.
Okay.
A spreadsheet that Matthew agreed was right.
Okay. You didn't have a conversation with Matthew about the spreadsheets, did you?
No, but I saw his emails.
Okay. You never had any discussions directly with Mr. or Mrs. Gunby about the amounts that they allegedly owed, did you?
No, we weren't allowed to talk to Mrs. Gunby about anything pertaining to this deal or any monies that were exchanged.
What about Mr. Gunby? Did you have any discussions with him?
No.
You were aware of the consulting contracts that Mr. Gunby had secured for your husband in the Middle East, right?
I was aware that he told him when Keith was looking for a job, he said, "Why are you going to go look for a job? I have something for you. Why don't you come with me to the Middle East and do some consulting work?"
You didn't have any discussions with Mr. or Mrs. Gunby about those contracts, did you?
No.
And you were aware of your husband's employment with Mr. Gunby's company, Connaught Services, right?
I was.
Okay. Didn't have any discussions with Mr. or Mrs. Gunby about that employment, did you?
No, we weren't allowed to tell Mrs. Gunby anything that had to do with business.
That's what your husband told you?
Yes. And I knew for a fact it was true.
How did you know for a fact that it was true?
Because in 2016, when I came to the US to celebrate my 50th birthday, sorry.
Age yourself, ma'am. Don't do that.
Sorry. My 50th birthday, Kim organized a party for me in the house. Well, that was one instance. She organized a party. Keith asked her to do it, and all my friends were invited, and we had a surprise party for me. They had a surprise party for me in the house. And she told one of her friends, and I sent her, as a thank you for organizing everything, I sent her a little message. It was a WhatsApp message. Thank you. It was so nice. It was lovely. And she told her friend Lynn, who told me that, Kim doesn't feel that you appreciated enough what she did for you. And I thought, at that point, they had been living in our house for 2 years without paying any money. And I thought that's why she was doing a party, because she was so happy that, that she was living there for free. Another similar thing was the year before, in 2015, we went out to dinner because I visited Atlanta, and she told me, she was telling me about this new lake house they were buying, and they hadn't paid us one payment for rent, for utilities, for anything. And she told us that she was talking happily about how they were purchasing this new lake house and how fun it was going to be. And I called Keith. It's like, how are they buying a lake house? I thought they couldn't afford to pay us rent. So Keith told me, well, it's because she doesn't really know that that's happening. But still, if they're buying a lake house, and then Matthew explained something like, oh, no, we're not really buying a lake house. It's just some friends who are letting us use their lake house, and Kim wants to buy it, but I don't think we're going to be able to afford it, blah, blah, blah. So there were so many signals. She traveled to Spain while we were there, and she never called me. She never said, come on, let's go have a glass of wine. She avoided me. All these renovations, they only called us to tell us about air conditioning or roof or boring things. She never once said, Liliana, guess what? I'm building a gazebo. Let me show you pictures. Or I'm in Barcelona. Let's meet for a drink. It was like this was so secret and sneaky that they didn't want us to know what they were doing in the house. So the whole thing feels like a big betrayal and deceit.
Thank you. Do you remember what my question was?
I remember that you asked, did Mrs. Gunby, how did I know that she didn't know anything? She didn't know because she said, you wouldn't be bragging about buying a lake house when you owe $50,000 in rent to somebody.
Thank you. And specifically, my question was about the business relationship between Matthew and Keith, and the contracts and Connaught services in 2018 and after, right? So am I correct? All the events that you've just discussed, those were back in 2015 and 16, right?
Which events?
All the stuff that you just described.
The lake house and my birthday they were living in the house, but it was prior to 2018, yes.
You were aware of the personal loans that your husband made to Mr. Gunby, correct?
Yes.
I just I've let it go a little bit, but I'm just going to object. I mean, this is all outside the scope of direct. I mean, it was very limited direct and pretty broad range.
That's fine. I can call her as a witness on mine if you like.
Okay. I mean, I'm willing to let you have a little bit, but he is right. It is outside the scope, but I also don't think it's worth our time to make you recall her again.
Right. I just have a handful of more questions.
Sure.
It won't take very long. You testified at your deposition that in the summer of 2020, you suggested to your husband that he should declare the Gunbys in default of the May 5th, 2018 purchase and sale agreement.
Yes.
Correct? And you suggested to your husband that he should terminate the purchase and sale agreement, correct?
Yes.
And your husband disagreed with you, correct?
Yes.
And so even so, before April of 2024, you never suggested to your husband that you should seek to evict the Gunbys from the property, did you?
I did. I said we should ask them to leave and give us back our house. But it was 2020, which was the pandemic, and Keith said, well, you know, they're never going to get a house in the middle of the pandemic. Matthew's in the Middle East. What's Kim going to do? How is she going to move? And, you know, blah, blah, blah. And we always considered them friends still, even despite all of these things.
Okay. You didn't want to throw them out of the house, correct?
No, we're not my friends. Why would you want to throw out your friends?
And you never saw any written communication that your husband sent to Mr. Gunby advising Mr. Gunby that the May 5th, 2018 purchase and sale agreement was terminated, did you?
I'm sorry, repeat the question. I don't understand.
Never saw any written communication from your husband to Mr. Gunby advising Mr. Gunby that the May 5th, 2018 purchase and sale agreement was terminated?
No, but we did talk about that's finished. That agreement is finished because they didn't comply with the terms.
I understand. I'm not talking about conversations that you had with your husband, I'm talking about conversations between your husband and Mr. Gunby. Did you ever see any of those communications regarding the termination of the purchase and sale agreement?
No.
Okay, that's all the questions.
Thank you. Anything else for this witness, Mr. Downs?
No.
Okay, thank you, ma'am. You may step down.
Yeah.
Mr. Downs, do you have any additional witnesses or evidence to offer?
The only thing I would offer is my evidence on attorney's fees.
Okay. I feel like if the parties are amenable to that, that the issue for me is going to be entitlement, not amount, because y'all can, if I say, I think you're entitled to attorney's fees, if you can do it quickly, we can go ahead and do it right now. Otherwise, you can submit it on paper later if you wish.
It's up to you. It's up to you, Your Honor.
Go ahead then. If you'll just take a moment, you're welcome to state in your place.
Okay. All right.
I mean, unless Mr. Withers wants to make you get on the witness stand and swear and he wants to cross-examine you.
I may have some cross-examination questions, but
That's fair.
I'll.
So he does want me to get up there.
No, but I'm saying you can stand in your place here.
Right. Both of you are officers of the court, and as Manley Brown likes to say, you can state in your place. Go ahead, sir.
All right. Sure. This came with a shared file. I'm not sure you're able to access it. All right. Well, good afternoon, Judge. My name is William Downs. I'm an attorney licensed to practice law in the state of Georgia. I've been licensed to practice since 2006. Practice primarily in the areas of civil litigation, landlord-tenant disputes. For this case, I started out at an hourly rate of $375 back when this case started in 24. This year in 25, the rate increased to $395. And I have supervised various staff throughout the course of this litigation whose billable rates are lower than that. $375 to $395 is a fair and reasonable rate for attorneys who practice in this area in Atlanta, Georgia. Our firm has a total of 163.6 hours, and this is just invoiced hours. This was invoiced as of, I believe, October 9th. So 163.6 hours. The total billable amount was $57,763. Total billable expenses were $3,425.28. And I'm happy to mark this. I did not mark this as an exhibit, but I'm happy to. I've got an extra copy. I can mark this as an exhibit for the court. But all of the work that we did on the case was reasonable and necessary to prosecute this case. It encompassed, pre-suit demand, filing suit, motion to compel rent hearing, limited discovery, exchanging written discovery, conducting depositions, dealing with the motion to transfer, and then preparing for trial here today.
And you said the total amount of cost was $3,425.28 up
That's right.
to October 9th.
October 9th, the total billables amount
$7,000 and
$763. And then I would just, I didn't know how to estimate for trial prep purposes or, how many days of trial we would be proceeding. But again, my rate is $395 for this case. I would estimate 10 hours per day of trial.
Okay.
Yeah.
Okay. Thank you, sir. did you have questions, Mr. Withers, for Mr. Downs regarding his attorney's fees? And hang on, did we feel he's going to provide me with a copy of the. Thank you, sir. And this is, it looks like a printout from probably whatever your internal billing system is, a series of printouts.
That's right. The first page is a summary, and then all the invoices, all the actual invoices are attached.
Okay, and these have been provided to you, Mr. Withers?
Just now.
Excellent.
Well, I thought our office said they provided them yesterday, but.
That's fine.
And what do you want to designate these, Mr. Downs? Plaintiffs?
We're plaintiffs, in the notebook, I believe it start with plaintiffs 12, is that right?
Your last one was 12, so this would be 13? Okay. Okay, Mr. Withers.
I do P11 for the last, I could be.
Oh, he may not have offered, he may not have specifically asked a witness, but he offered D1 through 12, and I admitted all of them with certain exceptions that we discussed on the record.
Okay, thank you.
Mr. Withers, questions?
Yeah, not many, because I've been in that position before and it's not any fun. And by that position, I mean being cross-examined on your invoices.
Yep.
Have you, are these time entries here, is this for everything that you've done in the case?
That's right, yes.
Okay. So these are for the fees that you've incurred in prosecuting the Badham's claims, correct?
Prosecuting Badham's claims and anticipating your question, defending your counterclaims.
Okay. And how much have you broken this $57,000 down into what is attributable to prosecuting the Badham's claims and what is attributable to defending against the Gunby's counterclaims?
No, I have not done that calculation. The time entries reflect what the work was done for.
Okay. That's all the questions that I have, Your Honor.
Okay. Do you want to redirect yourself, Mr. Downs, on any of those questions?
I think I will not.
Okay. Thank you. Do you have any other evidence to offer on behalf of the Badhams?
No, plan for us.
Okay, thank you, sir. Mr. Withers.
Yes, at this time, Your Honor, I am going to make a motion for a directed verdict.
Okay. Briefly walk me through the
I will.
basis of your motion, sir.
Your Honor, as an initial matter, I don't think the plaintiffs can prevail on their dispossessory complaint because there's no landlord-tenant relationship between the parties. Testimony is that there was never a lease between the parties. There was never any written rental contract between the parties. The only payments the Gunbys ever made with respect to the property were toward the purchase price. OCGA 44-7-1A provides that the relationship of landlord-tenant is created when the owner of real estate grants to another person who accepts such grant the right simply to possess and enjoy the use of such real estate either for a fixed time or at the will of the grantor. Here, the Badhams did far more than grant the Gunbys the right to simply possess and enjoy the use of the property. Rather, the parties entered into a purchase and sale agreement, and that the Badhams never terminated that agreement. I understand that there is, argument, and you've only heard half the evidence, that the agreement terminated, but the fact remains that, there was certainly never any written notice of termination.
So here's my one question I have. I think acknowledge, as you correctly pointed out, I've not heard all of the evidence. But if the court were to determine that the purchase and sale agreement ended by its own terms, regardless of what anybody thought about it, then what is the status of the Badhams relative to the Gunbys if it's not landlord-tenant in common, at sufferance, as holdovers, in whatever way you want to call it?
I think, and that's a good question, and I think that it would be equivalent, and I'm not sure what the legal term is, but, essentially, as the purchase and sale agreement says, it's going to be owner financed. So if we look at it in the context of a a mortgage, essentially, then, if I don't pay my mortgage, that doesn't make me a tenant of my mortgage company. The mortgage company has to go through certain procedures to foreclose. And then once they have established that, then they can move to evict me as a tenant at sufferance. But I don't believe that happened in this case. And I would argue that, that again, I'm not sure what the legal term is for that,
But your position is that as an owner, right, a financer, one who holds a mortgage, whatever we're going to call it, that they have different legal remedies than a landlord does, and that if they wanted to exercise remedies, they would have to have done it under the agreement.
Right.
Or as owner financiers.
They would foreclose, and which didn't happen here. And then I think you could probably do a dispossessory, but it's, obviously it's our position that the purchase and sale agreement never terminated in the first place because of what, testimony that you'll hear. But I don't believe that there was a landlord-tenant relationship. And further, the Georgia Supreme Court has held that where there is a sale or contract of sale of title, the relation of landlord and tenant does not exist, but it exists only when the use of land, either for a specified time or at will is granted. Now, I want to ask you to keep a straight face here, but that is Allred versus Harris, 75 Georgia 687 from 1885.
Okay.
However, it is still good law. And in May versus May, 165 Georgia Appeals 461, 1983, the Court of Appeals relied on the Allred case in distinguishing the relationship in that case from the relationship in Allred, noting that Allred involved an agreement between the parties purporting to convey title. This necessarily negated the existence of a landlord-tenant relationship.
How do we reconcile that, though, acknowledging that it's perhaps good law and was not negatively referenced by the Court of Appeals more recently, although I think I was still in elementary school when that happened. How do you reconcile that, though, with the fact that there is no security deed, there is no warranty deed, there is nothing other than this purported agreement between the parties that would grant any secured interests to the Gunbys? How do you reconcile the case law you've just cited to me where they're talking about title with the fact that the only title we have is a deed that says the house belongs to the Badhams?
Well, the agreement itself says that within 30 days after, or 60 days, I don't have it in front of me, title will be conveyed.
It's 30 days after the loan payment, yes.
So there is talk about conveying title. Whether you enter into a security deed doesn't change the nature of whether it was a purchase and sale contract as opposed to a lease. You don't have to have, I would argue, I cannot imagine a professional lending company entering into an agreement without doing a security deed. But I am aware of no provision under Georgia law that says that an agreement to convey title to property must be accompanied by a security deed. So that would be my response to the court's question.
Okay, thank you.
The Georgia statutory scheme for dispossessory actions under 44-179 et sec, which is the statutory scheme under which the plaintiffs have brought this action, it only applies to landlord-tenant relationships. And because there is no landlord-tenant relationship in this case, I contend that the plaintiff's complaint necessarily fails as a matter of law. Additionally, the allegations in this case are set forth in the dispossessory complaint, which they filed in the state court of Fulton County before the court was transferred to this case. They allege that the tenant fails to pay the rent, which is now due. Tenant holds the premises over and beyond the term for which they were rented or leased to the tenant. Plaintiff demands possession and past due rent of $97,460 since November of 2022, plus utilities. They demanded $150 a day, interest at the rate of 7% per annum, and then, of course, the attorney's fees. I would argue that they have failed to establish that the Gunbys failed to pay the rent that is now past due. Mr. Badham testified that the parties did not enter into a written lease agreement for the property. Section 2.7 of the purchase and sale agreement expressly states that during the term of this agreement, the buyer will have the right to occupy the property as a private residence and no rental payments will accrue or be payable. Mr. Badham also told Mr. Gunby in writing, and again, I know the parties just have different interpretations of this, that the agreement did not end on July 1st, 2021, and he continued to accept payments. And finally, the plaintiffs have put forth, I would contend, no evidence as to the amount of rent that is actually due, which according to their dispossessory complaint was $97,460. Mr. Badham testified that he contends that some of the payments the Gunbys made were for debts other than amounts owed under the purchase and sale agreement. So I don't think there's any evidence in the record as to the amount owed under a lease agreement that never existed. And the plaintiffs cannot prevail if they cannot demonstrate the amount of alleged rent that the defendants allegedly owed.
Well, I know there wasn't a written lease agreement, but didn't the lease agreement functionally exist between 2013 and 2018? And I know there wasn't a written agreement, but the parties were operating under some agreement for the Gunbys to have possession.
Right.
And pay something.
Okay, let's assume for the sake of argument that there was an agreement for the payment of rent in.
Because otherwise legally they'd be squatters, right? And there would be a whole different set of remedies that would be available to the Badhams, correct?
Well, I'm sorry. I want to make sure I answer the court's question. Are we talking about between 2013 and 2016?
Yes. Well,
18?
Yes. Because you mentioned there was never a lease agreement. And I agree there's an open question we've got to find an answer to starting in 18 and really more importantly after 21. But when you said there was never one, my question was, but wasn't there de facto a lease agreement or rental agreement or a tenant at sufferance or something happening between 13 and 18?
I think as I stand here, I would agree that it was either at will or I don't know if at sufferance is the correct term because it was certainly with the Badham's approval. But you know, at least as to that period of time, you know, there was a discussion, I believe the testimony from Mr. Badham was that there's a discussion that he wanted X amount and Mr. Gunby said, I can only pay $1,400 a month. And so, you know, at least during that period, if we limit it to that period, perhaps based on the evidence you have today, maybe it was $1,400 per month during that period. However, there is, you know, I can't remember what the statute of limitations is on a oral contract. I think it's 4 years. It's certainly no more than
4 if it's not written and it's 6 if it's written.
Right. So there can be nothing owed for that period. The statute of limitations on anything that happened before May 5th of 2018 is barred by the statute of limitations.
Right. And I didn't mean to imply otherwise, except that, for lack of a better way to frame it, if this was a dispute between two corporations in a commercial context, this would definitely be a course of dealing type analysis. And so to my way of thinking, the nature of the relationship prior to the purchase and sale agreement is relevant to a consideration of what is the status of the parties and what remedies and rights flow to each party. Not that it's outcome determinative or dispositive, but I think it's informative. So that's why I wanted the answer.
I understand. And that's a fair point. I would simply argue that whatever the relationship was from 2013 to 2018 ended when the parties materially changed the nature of their relationship as set forth in the May 5th, 2018 purchase and sale agreement. So the third thing is they asked the court to compel the Gunbys to pay $150 a day, which comes out to approximately $4,500 a month. Yet before this case was transferred to this court, in its November 1st, 2024 order, the state court of Fulton County ordered the Gunbys to pay $2,580 a month into the court's registry while this case remains pending.
Right, but wasn't that because the court was concerned from a fairness and equity perspective of covering the specific expenses, not the value, but the expenses associated with the house?
I would agree that in fairness, this was a situation where the state court said, I want you to both draft proposed orders. Mm-hmm. She rejected my proposed order. She accepted Mr. Downs' proposed order. Mm-hmm. I can't speak to what Mr. Downs meant when he put those numbers in there, but I do think it is a fair assumption to interpret that that's the court was trying to cover certain costs. I think I can't make a good faith argument to the contrary, although what I can say is what the statute says is that if you're going to compel them to have, you pay rent into the registry of the court. Mm-hmm. If that is what if the court felt like, if the state court felt like the rent, assuming a landlord-tenant relationship existed, should be a different amount, presumably the court would have indicated as much, but it didn't.
Well, just to be clear, I don't know if because I generally ask for orders in Word format and I will edit them. Sometimes I say, this is all good, I'm signing it. So I don't know if Mr. Downs put this in here and it was just adopted by the court, but there are 2 footnotes here that specifically say the amount and specifically say that the amount is being added based on a citation to McDonald Georgia Commerce Center because plaintiffs are being forced to satisfy a mortgage and that receiving rental payments contributes to accomplishing justice. So I think I agree with you that it's not just positive of the status of the parties, but the amount that was intended to be paid, I think, was directly, at least to my understanding, was intended to cover the costs associated with maintaining the property while the litigation was ongoing and while the Gunbys continued to possess the property.
Right. Understood, Your Honor. And my point is simply that in asking for $150 a day, which comes out to approximately $4,500 a month, number one, the rent that the state court ordered them to pay has no discernible relationship to $150 a day that the plaintiffs contend is due.
Let me help me understand why you're talking about how much they might be entitled to, and here's why. Because on a DV, all I care about is have they satisfied the elements of a dispossession, and I understand your argument about they're not really a landlord-tenant. So, but the amount that they'd be entitled to get, unless it is a demonstration of they're not tenants, I don't know that it's relevant to my consideration now. Although certainly, if we get past DV, it would make sense for you to make the argument that I shouldn't include that in the damages because that's not part of the relationship.
The relevance is, it's only relevant to the notion, not only do you have to prove that there was a landlord-tenant relationship, but if you are seeking rent, which they are, it's in their complaint, you have to prove your damages with a reasonable degree of certainty. If you can't do that, that's an element of a claim.
Isn't there a zestimate in the record, right? Didn't Mr. Badham testify that he looked at Redfin and he looked at Zillow and that there was a range and he picked the midpoint and it was somewhere around 5,000?
He did.
Okay.
And I don't believe that, I realize there's case law that says, generally a party can, he doesn't have to be an expert as to testify to the value of his or her own property. You can offer that testimony, and it doesn't have to require expert witness testimony. But, here, we're relying on hearsay as to what the reasonable value of that is.
Sure, but there's at least I don't think there's case law that says it, but there's at least a pretty good argument that the rule on market publications and generally available commercial information, that Zillow and places like that are all readily available to us have become what was intended to be captured by whenever that rule was adopted back in the 70s. But
And I'm not personally familiar with that statute. I'll take the court's word for it, but I certainly don't know that Zillow and Redfin are authoritative on the issue is where I would leave that point.
I understand. Okay.
The dispossessory complaint expressly says that the defendant is also notified that the defendant shall owe attorney's fees under 13-111 if the principal amount is not paid within 10 days of service. 13-111 expressly provides for the recovery of attorney's fees, quote, if such note or other evidence of indebtedness provides for attorney's fees in some specified percent of the principal and interest owing thereon, or if such note or other evidence of indebtedness provides for the payment of reasonable attorney's fees without specifying any specific percent. And then it provides, the formula. But here, of course, there is no lease or other evidence of indebtedness that provides for the recovery of attorney's fees. And therefore, I believe that section 13-111 is entirely inapplicable. And as to, Mr. Downs filed an amended complaint that asserted a
13-611.
13-611.
Right.
I understand that the court has not heard all of the evidence in this case yet, but, I don't believe there's concrete evidence. There might be speculation, but there's no evidence that the Gunbys have acted in bad faith, that they have been stubbornly litigious, or that they have put the Badhams to unnecessary and trouble expense, as alleged in the first amended and restated dispossessory complaint. I think in understanding that there's still evidence to be heard, there is at a minimum a bona fide dispute as to whether the Badhams are entitled to prevail on their claims. Again, we contend, and I realize this is not in evidence yet, but the Gunbys have paid over $437,000 towards the purchase of the property. That excludes the more than $77,000 they've paid into the registry of the court to cover the Badhams' mortgage payments over the last 3 years. And when I say 3 years, that's because the initial $60,000 goes back to 22.
Quick question.
Yes, ma'am.
13-611, though, to the extent that, we're in agreement that 13-611 is not about stubborn litigiousness. It's about bad faith in the underlying transaction, correct?
In the underlying transaction.
And that would be sort of the ongoing relationship from 2013 to now until we get to litigation, right?
Yes, ma'am.
Okay. But 9-15-14 would be the analysis of whether there'd been stubborn litigiousness, et cetera, correct?
Well, no. Okay. So
I'm sorry. I didn't say that very well. I understand that one of the defenses to a 13-611 claim is that there's a bona fide controversy.
Yes, ma'am.
And that the Gunbys, no doubt, are going to argue that they believe they had a legal right to possession of the property and to purchase the property. And therefore, there's a bona fide controversy. I understand that. I was just making sure, and again, I did not phrase it well a moment ago, that we're talking about 9-15-14 is a different assessment. And that is included in the amended complaint, although albeit, I guess, potentially prematurely, because,
I don't think I did include that.
I don't think there is one, but I'm happy to be corrected if I'm mistaken. I don't.
Okay. I had written it in my notes. It's entirely possible that I was wrong. Okay. So just ignore me then.
Sure. Okay. So in short, Your Honor, my motion for directed verdict is premised on two arguments. One, no landlord-tenant relationship between the parties. And second, I believe that the plaintiffs have failed to prove multiple elements of their claim, even assuming that a landlord-tenant relationship existed, which we contend there does not. So therefore, we respectfully request or submit that the Gunbys are entitled to judgment, a directed verdict on the plaintiff's claims. Thank you.
Okay, thank you. Mr. Downs?
Need a response to that? Would you like to hear a response?
I would like a brief response, please. And I'll make it easy for you. I would like for you to focus on Mr. Withers' argument regarding the nature of the requirement, the element of being a landlord-tenant relationship, because I believe that if that's established, right, if there's facts from which I could find that, then the other matters he has brought up would not be outcome determinative otherwise. Does that make sense?
Sure.
Okay.
Yeah, I mean, they came into possession voluntarily, right? The Gunbys, Badham's allowed them to be in possession, right? OCGA 4476, tenancy of will, when no time is specified for the termination of a tenancy, the law construes it to be a tenancy at will, right? So they've always been tenants at will. They had a right to purchase agreement for a minute, to occupy the property, but I don't know that necessarily changed their status as tenants at will.
So is that because in the context of a mortgage, right? The owner is still the owner who is in possession of the property usually, right? And the thing that's being foreclosed is the security deed.
Yeah, security interest.
We don't have it here. And
this is really a lease purchase.
Right, but more, that's my point is, even under its own terms, however it's phrased, at the end of the day, is it fair to characterize this as a lease purchase because the deed never changed hands, which is emblematic of a traditional mortgage?
I think that's right. I think that's right, Joe. So I will retract that and say I think this is more like a lease purchase. Mm-hmm. So during the 3-year period of the term, they had a right to be there. After that, we kind of get back into a tenant at will situation, right? Okay. You no longer have the right to be there once the agreement is terminated, right? You're only there with the permission of the owner. And so I would just cite the court to Morris versus Bird, which is a little more recent than 1885. It's a 2005 case, 275 Georgia App 293. And it's essentially what we have here. In that case, the tenants had a lease purchase to buy the property, made payments, in this case, made payments under the lease purchase, but didn't make all the payments. Didn't comply with the option terms to purchase the property, but stayed in the property after the term. Continued to make the payments after they stayed in the property. It's in that case, there's a dispossessory that was filed, it doesn't say anything about there's no landlord-tenant relationship because you have a security interest in the property, but it does defeat the tenant's claim for any sort of unjust enrichment, claims, because anytime that you had the right to be there, but your expectation was that you could only be there so long as you comply with the terms. And once you don't comply with the terms, now you're a month-to-month tenant. And you can be dispossessed with a 60 days notice. I mean, the fact that they were allowed to stay in the property for another several years my client shouldn't be penalized for that. If anything, that was charitable on my client's part. But it doesn't change the status of a landlord-tenant relationship. I mean, otherwise I don't really understand Mr. Withers' argument about that they're somehow owners of the property. They were never conveyed a deed like a normal mortgage and security interest would be. They never asked for a deed. They were never conveyed a deed, and they never operated as owners of the property. So I don't really get it. I mean, it's a dispossessory case. I mean, how else are we supposed to file this thing? I don't know.
You'd be surprised the number of times I've dealt with ejectment actions recently.
I mean, they're not intruders.
Right. They're not intruders, and they're not, there's not a There's not a security deed to foreclose on.
Yeah, it's permission of the landlord. It's
Right.
permission of the owner. That's all, that's what we're doing here. So, we gave them, their tenancy of will, we terminated the tenancy of will, and you set forward a prima facie case for eviction.
Okay, thank you, sir. Mr. Withers, any response?
Just briefly, what was that kid's name?
275 Georgia App 293.
293. Got everything but the page.
I would just disagree with the notion that this is a lease purchase agreement. It wasn't. There's no lease. But in any event, I just reiterate that I do not believe that they have established the existence of a landlord-tenant relationship, and in the absence of that relationship, I don't believe that a dispossessory is the proper method. Maybe an action and ejectment is, but that's not what how they chose to pursue this case. I would say, I'll close with, understanding that the court has only heard one side of the story and is therefore only at this point allowed to rely upon the evidence before the court at this time. I believe that the evidence at this time that fails to show the existence of that landlord-tenant relationship.
Okay.
Thank you, Your Honor.
Thank you. I am going to deny the motion for directed verdict. I mentioned before Mr. Downs started talking that I didn't think that the other elements of a dispossessory action were going to be outcome determinative for a DV, and that what I mostly wanted to hear was to address the status of a tenant-landlord relationship. And I think that for purposes of a DV, obviously there is a dispute about the import and effect of the purchase and sale agreement. But for now, I think that it survives the DV, and that there is evidence from which the court could find that a tenancy at will relationship existed, and therefore a dispossession is an appropriate remedy. So there you go. Okay, so now it's almost 5 o'clock. The question is, I expect, because just based on the amount of time that it took for Mr. Badham's testimony, I expect Mr. Gunby's will take some time. But I didn't know if we were also going to hear from Ms. Gunby, or if you had other witnesses that we might fill some time with, or, if we want to, how much longer do you think we have to go for your case and counterclaim, your defense and counterclaim?
Right. I would say the court, at this time, I only intend to call Mr. Gunby.
Okay.
If I feel that Mrs. Gunby's testimony is necessary, then I would reserve the right to call her.
Mm-hmm.
Those are the only witnesses that I intend to call. I would note Mr. Gunby is in either Saudi Arabia or Bahrain.
I was wondering about the time difference. It must be the middle of the night wherever he is.
Getting close to midnight, if not already a little after. Given the amount of time and that he is the last witness, the only witness, at least at this time, that I intend to call. And if I do call Mrs. Gunby, it will be like Mrs. Del Rio Badham, very short.
Okay.
So my respectful suggestion to the court would be that we adjourn for the day so that Mr. Gunby can go to bed and resume tomorrow.
Okay. What are your thoughts on that, Mr. Downs?
I'm fine with however the court prefers.
Yeah. As much as I would love to go ahead and get started, it doesn't make a whole lot of sense to just try and get, 30 more minutes of testimony in. And so I think what we will do is adjourn here in a moment, resume in the morning. I don't have any meetings tomorrow morning, so would like for us to start promptly at 9 o'clock, which hopefully should be easy for Mr. Gunby to do because it'll be mid-afternoon for him at that point. But I will be here and we'll have another Zoom set up. I don't know if we've provided you with the link for that, but if Mr. Freehoff has not set it up yet, he'll make sure that he does so that Mr. Gunby has it.
And so to be clear, it is not the same link.
It will not be the same Zoom link. We create a new one each day. I don't know why, but that's just how we do it.
That's fine. I don't have it yet, although I have a bunch of emails that haven't gone through today.
Okay, Mr. Freehoff, if you could please, if you have not already created the Zoom link for tomorrow, if you could go ahead and create it and email it to the party so they have it and can provide it to Mr. Gunby as soon as possible.
Yes, Judge, I'm doing it right now.
Thank you so much.
And I don't know if you want this on the record or not. I just want to get a little bit of clarification as far as procedure for tomorrow. Your Honor said that you might have letter briefs. I don't recall the exact.
Sure. Madam Court Reporter, I think we are adjourned for the day, though. It's 4:54 and we're going to be done for the day. So thank you very much.
You're welcome. Go on the record.
Okay, and so we are off the record. Yeah, I mean, I don't always do it, but what I typically do when I'm sitting as the fact finder is I ask the parties, instead of making a closing argument like they would to a jury, to write me something that outlines their argument about their position. And then what I also ask is a proposed verdict or judgment. And by that, I don't just mean like you would for a jury trial, here's the questions we need you to answer, but your suggested answers to those questions, whether it's dollar amounts or whether it's a finding in favor of one or the other on a particular thing. I mean, just based on the half of the case that I've heard yet, and having not heard anything about the counterclaim, right? I mean, clearly what the court has to figure out is whether or not the Badhams are entitled to a dispossessory. In other words, which one of these parties is entitled to possession of the house? And then whoever is entitled to possession of the house, what of the others' claims and substantial financial interest and or contribution that have been made. And so, I mean, that's still the problem that's the baby I have to split. So that's what I will be looking for in terms of resolving the issues. And so what I expect I will do is hear from Mr. Gunby tomorrow. Ms. Gunby, if she testifies, anything else from Mr. Downs, if there is any rebuttal. And then we can play it by ear, but I expect that what I will do is say, hey, I'm going to send you all home now, please, in the next 4 or 5 days. Like, now, I don't want to wait too long because I want it to stay fresh with my notes. Tell me, write me a 4 or 5 page, whatever, saying this is my closing argument, and send me a proposed verdict, proposed judgment. And then what I do from there is, now, if I grant a writ of possession to the Badhams, that will be entered as a separate document. I mean, I'll enter a verdict that says I think they're entitled to a writ of possession, and then I would issue a separate writ. But in terms of the final judgment, I typically would I would enter a verdict, I would enter the writ, and then I would ask for whoever I was ruling in favor of to prepare a final judgment for the court to enter, because obviously the deadlines for y'all to do things other than the writ run from the judgment. So does that make more sense?
It does.
Okay.
And because I think I understand, I just want to make sure I'm going to have a much more free evening tonight than I.
Yes, you do not need to prepare a closing argument tonight. What I am expecting instead is for you, and to be clear, if the law is helpful and that's what you'd be arguing, then make legal arguments, but I don't need you to write me a brief, right? I mean, I really do want it to be a closing argument. I just would like for it to be in writing instead of verbally.
Okay.
Okay,
Sounds good.
thank you.
All right.
And
Thank you,
Judge,
Judge.
how did you say you're related to Chesley?
So Chesley's grandmother, Thelma Lou McLeod,
Okay.
is my grandmother, Margie Nell Harrell's sister. They both grew up as Margie and Thelma Simmons,
Okay.
and they are sisters. Although his grandmother has passed on, my grandmother just turned 100.
So
I know.
the only thing I learned from Trust and Estates class in law school that I remember is that makes you guys second cousins.
Oh, there we go. Well, Judge Padgett, who's now on the Court of Appeals, his actual discussion with jurors actually explains, because, one of the questions we ask is, are any of you related within the second matter of
Consanguinity.
Right, of consanguinity to the DA, if it's a criminal case. And he actually explains to the jurors what the levels are. And I'm like, I don't even understand it. I wouldn't even try to explain.
I get so confused with that stuff. Yeah.
So are you from, I grew up in Hazelhurst.
Right. So my grandmother moved away to the big city of Macon.
Ah, gotcha.
So I'm from Macon.
Gotcha. Okay,
But,
great.
yeah.
All right.
But I might actually, this case just happens to be on my docket. It's not one that would have gone to the business court, but see you guys more in the future because I'm going to be one of the business court judges now.
Oh, okay.
Okay, great.
Yeah, so-
I've never filed anything.
Well, a lot of times not the metro, I mean, just the metro one here, not the state one. The difference that's interesting about the metro is that consent is not required.
Okay, yeah.
Right, so if I, and I've done that recently, said, I think this case should be in the business court, and I'll say, hey, lawyers, do you think we should send this to the business court? And they say, yeah, this is a good fit, and it goes over there. And now the funny part is when I get over there, I might get back a couple of cases that I sent over there saying, I don't want to handle these, send them to the business court, so.
Right.
Gotcha.
Thank you all for your time. I will see you tomorrow morning at 9 a.m.
Yeah.
Thank you, Judge.
Thank
Thank
you.
you.
Okay. So, Madam Court Reporter, we are going to go on the record day 2 of the trial of Keith Badham and Liliana Del Rio Badham versus Matthew and Devette Gunby, case number 25 CV 009445. I'll note for the record that all the parties are here in the courtroom, and I don't believe there were. I think where we left off was whether there were any preliminary matters we needed to take up before the defense called its first witness. Mr. Withers?
No, Your Honor, no preliminary matters.
Okay. So, Mr. Withers, if the defense would like to call its first witness?
Yes, Your Honor, we call Matthew Gunby.
Okay. Mr. Gunby, will you please raise your right hand? Do you swear the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, sir. You may lower your hand. Go ahead, Mr. Withers.
All right. Good morning, Mr. Gunby. Let's start out telling the court a little bit about yourself. Tell the court, what do you do for a living?
I am a management consultant with a background in finance and accounting.
Okay, and who do you currently work for?
I work for myself with my own business.
And where is that business based?
Currently, I'm working in Saudi Arabia with a client here, where I've been for the last few months.
And just what time is it where you are right now, just to kind of get a sense?
It's 4:20 in the afternoon.
Tell the court about your educational background, if you would.
Yes, I went to Southampton University in the United Kingdom, where I obtained a Bachelor of Science Joint Honours in Economics and Politics, and went through secondary school education in the UK as well. From a professional career perspective, I'm a qualified chartered accountant in the Institute of Chartered Accountants in England and Wales. I am also a CPA in the state of Georgia.
And have you ever worked as an accountant?
Yes, I was a partner with PricewaterhouseCoopers, based in Atlanta until 2008, and then subsequently I was a partner with Ernst & Young here in the Middle East.
And so, kind of given your background and the fact that this case involves a lot of spreadsheets and numbers and so forth, do you feel like you have a competent understanding of financial documents, ledgers, spreadsheets, documents of that nature?
Yes, I do.
Okay. And you are obviously married. How long have you been married?
We've been married for 40 years this year.
And how many children do you have?
We have 4 sons.
And how old are they?
We have twins who are 33. Let me get that right, 33. A son who's 31, and we have another son who's 29.
And how long, well, let me ask this. How did you come to the United States, or when did you come to the United States?
We moved to the United States in 1992. I transferred with what was then Coopers & Lybrand from the UK over to the Atlanta office of Coopers & Lybrand, which subsequently became PwC in 1999, following our merger with PW. So my intention was to move back to London after 2 years, but we ended up falling in love with Atlanta, and we still there, and I made partner in 99, and stayed with the firm there.
And where do you currently reside?
My residence is both here in Bahrain and obviously back in Atlanta.
And in Atlanta, it's at 6365 Colwood Court, correct?
Yes.
Tell the court how you came to meet and become friends with Mr. Badham.
Yes, Keith and I met in, I think it was either late 2001 or I think early 2002. It was not long after the Twin Towers attack, and Keith had moved over. And I think the first time we met actually was a British American business group lunch meeting. I think the British ambassador was there, and I think Keith's boss was there, and we'd met at that point. So that was sort of our first meeting. And so we've known each other for, I guess, 24 years. I think once we'd met at that, we developed a sort of a business relationship, and with all of these things, we also started to develop a social relationship as well. And I think really over the next sort of 4 or 5 years, I think we became very good friends. We played a lot of golf together. We went on golf trips together. We worked on opportunities between Keith's firm and PwC, and attended some conferences together. So yeah, I think sort of we really got to be, I think, pretty good friends through that period of time, as well as looking at sort of business opportunities together with our respective firms. And I think probably if I can just go on to say, maybe I'd like to sort of take this opportunity if it would be okay. I think, you know, other than a sort of a gap from 2008 when I transferred back to the UK, where we had a brief spell, well, a period until probably 2013, where we sort of somewhat lost touch. Keith went to take up a position in Australia. I was back in the UK, and we'd lost touch then. I was really pleased that we reconnected in 2013, and you know, I think the relationship that we then developed over the next, let's say, 10 or 11 years became, I think, very close. And I think anyone who knows me and who I speak to would tell you that I would have said Keith was my best friend. I mean, I trusted him more than I would have trusted anybody else. I think we had a very supportive relationship. I think we had a very adaptive relationship. I think we were sort of adapting to many things as they were coming along, and I think it was very much a sort of as I feel, a sort of a really close friendship, and we helped each other, supported each other, and adapted to many different situations over that 11-year period.
You first moved into the Colwood Court property in 2013, correct?
That's right.
Tell the court the circumstances under which you and Mrs. Gunby came to live there.
Yes, I mean, I had moved back to PwC in the UK in 2008, which in hindsight probably wasn't the best move because it was just after the financial crisis. So in 2010, I took a package from PwC, and then I decided that I would look at an opportunity with another English gentleman to start a business together, which we did. That went well for 2 or 3 years, but by 2013, it wasn't going well. And having put a lot of my money into it, he put a lot of his money into it, we ended up in a pretty difficult financial situation. The business was really sort of split between London and the US. So I was sort of moving backwards and forwards during that time from London to Atlanta. But obviously my family was in Atlanta, stayed in Atlanta. And so when I came back in 2013, things were pretty difficult. Yeah.
Okay, so yeah, go ahead.
No, you go ahead. Sorry. No, please.
I was going to say, okay, so we were in 2013 and you're having some, financial difficulties due to the troubles with that business. So tell the court how does, how we get from there to you moving into the Coalwood property.
Yeah, so we had a small townhouse in Roswell. And, at that time, our sons were probably 2013. They would have been sort of mid to late teens. I got the years right. No, actually, they'd have been sort of in late teens, 20-ish. So we were staying there because that was the property that we owned. I had, as mentioned, had some of these financial difficulties. We were living in the house, our house, and I don't remember exactly how the connection was made. I think it may have been through a mutual friend of ours, but we became aware that Keith and Liliana were selling their house. Somehow that connection was made, and Keith and Liliana, understanding our situation, offered the use of their property for us to stay and get back on our feet. And I think the one thing I would like to say from what I heard yesterday was, I didn't pick up the phone or call Keith and say, hey, I hear you've got a property that's vacant. Would you, could we come and live there, please? I think it was, that's not the way that it works. I didn't even actually know that Keith was selling his property at that time. So I think it was a sort of a connection through, as I say, a friend of ours that it sort of came together.
At the time that you moved into the property, did you enter into a lease agreement?
No, we did not.
Well, what discussions, if any, were there regarding, payment for living at the house?
I mean, there were discussions. So just to characterize the situation, and we will forever be grateful to Keith and Liliana for what they did for us. Absolutely. As you heard yesterday, that Keith advanced money to us to help us. He allowed us to stay in their property at that time so we could get back on our feet. We discussed some business opportunity relating to a valet business that my sons had. But in terms of, I would say at that point, it was, as Keith may have said yesterday, we were friends. And so he very generously said, look, stay in the property until you get back on your feet. We talked about a sort of a rental amount and how we might cover some utilities. But obviously, we were at that point pretty down, and it took some time for us to sort of get back on our feet. And we achieved that because of the help that Keith and Liliana gave us.
What about, so just to kind of circle back, what specific were there about the amount of rent or other expenses that you were going to provide, as best you recall?
I mean, certainly we discussed the $1,400 a month. That was absolutely, definitely discussed. I think at that time the utilities were still all in Keith's name, and I think we would have discussed that we would try to make payments against those utilities. I think they were in his name and he was paying them. Excuse me. But there was no sort of formal arrangement going on. I mean,
sure. And just because of the lag in Zoom, if I start to ask another question and you start to talk again, I'm going to stop because I want to make sure you get a chance to say. cut me off if you need to. Tell me, describe the condition, the physical condition of the property at the time that you and Mrs. Badham took up residence there.
Mrs. Gunby, I think you mean, but
I'm sorry. Excuse me.
yeah, I mean, the property was, I would say it was pretty run down. I mean, there were quite a few things that were wrong with the property. There were issues with some of the electrics. There were issues with the HVAC. I heard Mr. Keith say yesterday that, I think his brother-in-law was an architect, which I didn't know, but I know I discussed with Keith over the years that I think his brother-in-law, he said, was a bit of a Mr. Fix-It. And there were quite a few things that were sort of defective, if you like, which included the area down at the bottom of the yard where Keith, I think, had spent quite a lot of money putting in a watering system, which had gone into disrepair. So the sort of back end of the yard was in a bit of a state. The roof was not in good shape. The basement was half finished, with wires dangling all over the place. The HVAC had big silver tubes with holes in them, so that wasn't really working properly. The AC on the second floor didn't work, so we had to go and buy some window units to make that work. So I think my impression at the time was that it had lacked some maintenance, it had lacked some investment, and there were some things that were certainly not up to code in terms of, let's say, the electricity.
At the time you moved in, what instructions, if any, did the Badhams give you regarding, how you should treat the property, what you could do with the property, et cetera?
Yeah, I mean, I think at that time what Keith had said to me was, sort of treat it as home, if you like. Don't feel there's any pressure, treat it as home. If you need to do a few things in the house to make it more comfortable, please, go ahead and do that. But I think his main message was, very supportive in terms of, let us help you get back on your feet. And I think he was accommodating in terms of whatever that meant, in terms of the property.
Was there an understanding as to how long you would occupy it? Because did he say they would be coming back in X number of years or anything like that?
No, I mean, we didn't have a fixed timeline. I think from our perspective, we were grateful to stay there and to be able to get that, get back on our feet. Keith was at that time living, I think, in Spain. I think he was in Spain at that point. He said to me many times that he liked living in Spain. He liked the European life. And I think he felt America wasn't the place that he wanted to be, or to bring his sort of family up. And so his intention was to stay in Europe. So that was what I understood his sort of personal objectives were.
Tell the court about, how the discussions came about regarding your the possibility that you might purchase the property.
Yeah, I mean, I think there are, if I may take sort of this opportunity, Knox, I mean, I think there are sort of 4 very clear sort of milestones or timelines that occurred in this sort of whole period of time. I mean, there was obviously the time that we moved in. There was then a meeting that Keith and I had in Valencia in December 2016. So I think, that December 2016 was a very sort of important moment, and we could get on and talk about that in due course. I think the next sort of important milestone was when we signed the purchase and sale agreement in May of 2018. And then, of course, the final sort of milestone, which was the sort of April 2024. So to come to your sort of question, the decision really, when we got to December 2016, I think Keith and I agreed that we needed to talk about, what the future was going to look like. We've been in the house for a while. So I went to Valencia to meet with him, and we talked, excuse me, we talked about at that time the potential of buying the house. I mean, we had a very wide-ranging conversation. I think it's worth saying at that point, and I'll sort of just dip into the financial side of this for a moment. At that point, I still owed Keith approximately $79,000 relating to the rent payments, the $1,400 rent payments, as well as the utilities that had run up over the period from sort of 2013 to December 2016. And there was also an amount of approximately $40,000 that I still owed him from some of the loans that he'd given us. So I went to Spain in 2016, knowing that I still owed Keith around about $119,000. But I went with the intention to talk about, we talked about the future. Keith obviously was thinking about the property. At that point, I didn't need to make a decision to buy the property. I mean, we could have looked at other properties, but we were in the property. We liked the property. Keith wasn't sure, I think, at that time what he wanted to do, but it felt, given our friendship, it felt like a good idea for us to look at buying the property. So we discussed that. At the same time, we discussed some career opportunities for Keith. He said to me that he hadn't been in serious work for 2 or 3 years, and he would be keen to get back into some sort of employment or some work. So we talked about the Middle East and what I was doing in the Middle East. I suggested to him at that time that there might be opportunities to get him involved in some projects and contracts in the Middle East, which I think sort of suited him. I think having had the career, and for me, that was Keith was a very experienced CEO, and I could see there being quite a bit of opportunity for that. So I think again it sort of it was very much a here were two friends who were talking about some mutually beneficial arrangements that might suit both of us going forward. I don't think either of us had to go down that course, but that's what we chose to do. So yes, in 2016, that's when we sort of really sort of committed to the course that sort of brought us to where we are now, if you like.
So do you have any idea what the value of the property was in that time when these discussions were ongoing?
Yeah, we'd had an appraisal done, and the appraisal came in at around $395,000. I think it was more or less around that time. So yes, we knew what the property was worth.
Okay.
When was that?
When was that, Mr. Gunby?
I think it was around that time. It was late 2016, whether it was November or December. I recall it was at that time.
Okay. I'm going to share my screen so that we can share documents.
Yeah.
You able to see this document that I've put up on the screen?
Yes, I am.
Okay, this is Exhibit D1, which was admitted yesterday. This is, would you agree that this is the purchase and sale agreement that you and Mr. Badham executed?
Yes, I would agree.
And I will say, this is somewhat of an unnatural way of having this kind of conversation, but if at any point you need me to zoom in or to scroll down, or you need more time to look at something, will you just let me know?
I will, but I can read it fine.
So what was the principal, the sale price that you and Mr. Badham agreed on?
The sale price we agreed on was $450,000.
Okay, and you testified that a moment ago that sometime within, a year or 2 years prior to that, you had commissioned an appraisal and it was $395,000. How did you then arrive at a purchase price of $450,000?
We arrived at that because we felt it was reasonable to apply an uplift to what the market valuation was. And as I mentioned earlier, we had 79,000 approximately of costs and these rents that at that time in 2016, December 2. Again, I need to point out the $450,000 was a number that we discussed in the December 2016 period. And we said, well, let's put the purchase price of the property at $450,000. We know the market value was $395,000, but also at that time, as I just mentioned, we also knew that we still owed Keith and Liliana in that region of $79,000. So, we rolled that into the $450,000.
And just
Mr. Withers, I'm sorry to interrupt. I think I misheard Mr. Gunby a moment ago. I thought I heard it 319,000, but then your question said 390,000. So I want to make sure I heard that correctly.
I don't want to, Mr. Gunby, for the court's clarification, can you please say again what the appraisal that you got said, what the value was?
395.
Thank you, sir. Thank you, Mr. Withers.
Thank you. And this document that we're looking at, who drafted the initial version of this document?
The initial version was drafted by Keith.
And does this agreement, as far as you are concerned, contain all of the agreements that all of the terms that you and Mr. Badham agreed on, or were there other terms that aren't reflected here?
No, this agreement contains the terms relating to the purchase of the property.
And you obviously heard Mr. Badham testify yesterday that at the time you entered into this agreement, you actually owed significantly more than $450,000, but that you didn't want any of that put in this agreement because you didn't want Mrs. Gunby to know about your debts. Is that an accurate statement?
No, I don't believe that's an accurate statement. I mean, Mrs. Gunby, Kim, knew that we owed the Badhams money.
Is there anything in this agreement relating to personal loans that the Badhams made to you other than, well, I'll just leave it at that. Is there anything in this agreement relating to personal loans that the Badhams owed you?
No.
You mentioned that, I believe, well, how much did it, as far as the personal loans go, at this time, how much did you still owe Mr. Badham?
In 2018?
Yes, sir.
So in 2018, when we got to this point, we would have owed Mr. Badham the $79,000 that I just referred to. And then we had, at that time also, we agreed that we would make a, what I would call a flex payment, which was something we agreed when we met in Valencia in 2018. Sorry, I beg your pardon, 2016. So we owed for that, and we also owed for the utilities relating to the for the period up to May 2018.
Okay, so I think earlier you went through $79,000 for rent and utilities. I think you said $40,000 in personal loans. So, and I believe you said that, so at a certain point in time, it was about $119,000 that you owed Mr. Badham. Is that at a different?
So let me just clarify. So aside from the purchase and sale agreement, there were the prior loans of approximately $40,000. There was the flex adjustment of $50,000 that I agreed because I was wanting to recognize the fact that prior to that time we had benefited from the arrangement that the Badhams had supported us with. We also, as of that time in May 2018, owed roughly $35,000 relating to the utilities and, let's say, the rent. So that the $1,400 in the utilities was around $34,000 because that ran from that sort of, if you like, the December 2016 timeframe. Because again, bear in mind the $79,000 that had been incurred prior to December 2016 had been adjusted through the $450,000 purchase and sale agreement. So the total at that time, if I exclude the purchase and sale agreement, the total would have been approximately if I'm doing my math right, $124,000.
Right. I'm sorry, go ahead.
No, I mean, if when I'm going through the numbers, if counsel or anyone would like me to, or the judge would like me to repeat them, I can do that in case anyone wants to write them down.
Thank you. Section 1 says it is proposed that the following buyer payment schedule will be as follows. And then it's got, as we talked about yesterday, 37 payments of $8,000 per month commencing on June 30th, 2021. And then we have the $205,522 to be paid by June 30th, 2021. So if we add all that up, where does that get us as far as a sum?
Well, for the purposes of this agreement, so yes, the total amount was the 450 plus the interest calculation. So I believe it was 501,522, something in that range. I'm not sure I've got the exact number, but it was in that range.
So that includes principal and interest.
Oh, that's right. Yes.
Section 2 is entitled Conditions.
Mm-hmm.
And section 2.2 says buyer will cover cost of all repairs necessary during the life of the agreement, including maintenance. All utilities will be transferred to the buyer's account. Do you see that?
Yes, I do.
What did you understand wear and tear repairs and maintenance to include? What was your understanding?
Well, for me, my understanding is, when you refer to repairs and maintenance, I would take that to mean making sure that the property is in livable condition, that if things break, we repair them. If we need to maintain certain things, then we do that. So so I would attribute that to sort of the wear and tear, if you like, on a property.
As far as the utilities go, so it says that you were to transfer them into your own name. Were you able to transfer any of the utilities into your name?
I believe we transferred the gas into our name. I think we did talk about transferring the water into our name. I'm not sure why that didn't happen going back. But I do recall Keith saying, and I actually think he may have said it to my wife, but when we talked about the transfer, that he felt it would help his credit to maintain some of the utility bills in his name. And I'm not sure if sort of if that's a British thing, because I know when you live in the UK, if you like often get asked for utility bills to sort of demonstrate proof of residence, as well as some credits and other things. So I don't remember exactly why, but I do remember that specifically we talked about there was the utility account that he'd want to stay in his name.
Section 2.3 of the agreement says if buyer wishes to cancel this agreement at any time and for whatever reason, no payments will be returned, nor value given for any repairs or improvements which will belong to the property. Now, you heard Mr. Badham testify yesterday that, when talking about improvements, that was referring to painting the walls and, planting shrubbery and flowers in the yard. What did you understand improvements to mean?
Well, so let me say that I know we'll go through this a bit later. We spent around $276,000 covering maintenance and repairs and improvements to the property. Just to break that down, we spend $128,000 on what I consider to be repairs and maintenance. So, for example, when a retaining wall falls down, I consider that to be a repair and maintenance. If equipment doesn't work in the pool house, I consider that to be repair and maintenance. If I look at some of the work that was done in terms of, let's say, the upstairs bathroom, where we put in the new bathroom, that's an improvement. So I think for me, if things are broken, whether it's the AC, the electricity, walls falling down, trees falling over, that for me is repairs and maintenance.
Section 2.7 says, during the term of the agreement, the buyer will have the right to occupy the property as a private residence, and no rental payments will accrue or be payable. What did you understand this language to essentially mean?
Well, what it means to me is that we're not in a lease, so we're not in a rental agreement. Now,
Under the purchase and sale agreement, you were to make payments of 37 payments of $8,000 each. Did you make all of those payments?
no, I did not.
And did you make the balloon payment of $205,522 on or before June 30th, 2021?
No, I did not.
And tell the court why you didn't.
So the reason I didn't at the time was there were other cash flow impacts that were occurring, particularly in the early 2019 to sort of mid 2000 and late 2020 period. At that time, Keith and I were working daily together in Riyadh. We started a project there in early 2019. We were day to day with each other. There was work that had to be done on the house, and we talked about that at the time. His builder was involved with that as well. And then we hit COVID in early 2000 and early 2020, and at that time, everybody. A lot of people were losing their jobs, including family members and so on. So I think Keith and I were fortunate enough that we were both working, but there were some impacts to the cash flow at that time.
But did you make any payments towards the purchase price of the property?
Sorry, in which period, Knox?
Well, let's say during the period between May 5th of 2018 and June 30th of 2021.
Yes.
And did you make any payments toward the purchase price of the property after June 30th of 2021?
Yes.
Okay. As of today, how much do you contend that you have paid toward the purchase price of the principal, or towards the purchase price of the house?
$437,000.
I'm sorry, 400 and how many thousand?
$437,000.
Thank you. Okay. I'm gonna go back. And show you, there we go, what has been marked as Exhibit D2. This was admitted, I don't know if the word is provisionally or conditionally, or portions of this were admitted yesterday. Do you recall the testimony regarding this yesterday?
I'm sorry, you blipped there, Knox. Can you say that again?
This is the Exhibit D2, which was introduced to some extent yesterday, is your discovery.
Okay.
You recall the testimony yesterday regarding these discovery responses?
Yes.
Okay. I'm going to go down to the portion of these discovery responses that we spoke about yesterday. This is your response to interrogatory number 8, which asks about the payments that you made. And this spans pages 4 and 5 of your discovery responses. If you, again, because this goes on to both pages, if you need me to move back and forth between the pages, just let me know and I'll be glad to do that. So these payments that are listed here in response to interrogatory number 8, did you in fact make all of those payments to the Badhams or to Mr. Badham?
Yes, I did.
And it reflects here at the end, and I represented to the court yesterday that I double checked it, and the total, well, what is the total as you calculated here?
The total on here is 452,166.
Okay, so if the total that's listed here is $452,166, why is it that you say you've only paid approximately $437,000 towards the purchase of the property?
Because it was pointed out to me in deposition that, in fact, I had included some payments in this list that related to the business, which I'm sure we'll talk about in time. So if you look at the line item starting, I guess, February and March 2023, you'll see there's a total column there of 6,000. It's gone. Where is it? 6,992.
Oh, yes.
Yep. And that's a net number that includes the payments just off to the left and down. You'll see there's, if you go to the 222.23 Knox, you'll see there's a payment of 9,500 euros.
Yes.
And on 3/2/24, there's a payment of $10,000. And there's a payment on February 13th of 936, and another payment on February 4th of 2,000. Now those numbers don't add up to the 6,992 because at this point in time I was just picking up the payment information. So when, as I say, it was pointed out to me in deposition that these numbers actually related to the business. So so I should not have included the 6,992, which, as I say, was a net number. And there were two earlier payments pointed out to me also. I can just see them on my screen. I think there was one of 1,241, which I can just see, and I think there's one above that as well, if I'm right. The 2,775. So I had included those, and that was a mistake on my part, and partly caused because I was paying Keith through the Wise banking transfer system, both for the business payments as well as for the personal payments.
Now, did you make any payments towards the purchase price of the property from May of 2019 to January of 2021?
May of 2019
Right.
to I believe that was the gap that I was referring to earlier.
Okay.
And so, yes, the answer to your question is no.
To the best of your knowledge, other than the 3 or 4 or 5, I don't know how many there were, but payments that you erroneously included in response to interrogatory number 8, other than those, to the best of your knowledge, are there any other payments on this list that you believe were for items other than towards the purchase price of the property?
No. And just to clarify, so in the Wise system, I would normally in the payment reference, I would, if it was a business related payment, I would write Connaught payment or something in the Wise document.
Do you know, and I think Mr. Badham testified about this yesterday, but do you know how much you paid toward the purchase price of the property before June 30th of 2021?
Or June 30th,
Before
2020. Oh, yes, sorry. I believe that was 114,000.
Now, did Mr. Badham ever send you any kind of default notice when you failed to pay amounts that you were scheduled to pay under the agreement?
No.
Aside from shortly before this lawsuit began, did he ever tell you that he wanted you to move out of the house due to missed payments?
No.
Around June 30th, 2021, when you didn't make the $205,522 balloon payment, Did he ever send you notice at that time that he considered the purchase and sale agreement to have been terminated?
No.
Did you continue to make payments toward the purchase price of the property after June 30th of 2021?
Yes.
And other than the ones that, again, you identified that you erroneously included on in your discovery responses, was it what was it your intention that all those payments were going toward?
For me, they were going towards the purchase and sale agreement because that was the only, that was the only formal agreement we had, and that was the agreement we wanted to get executed as quickly as possible. So for me, when I was making these payments, that's where I believed what they were being applied to, what they would relate to.
And the erroneously included payments that you just mentioned, I haven't added those up, but if we take that out of the 452,166, is that how we get to approximately $437,000?
Yeah, that's correct.
If you didn't make the balloon payment on June 30th of 2021, I mean, tell the court why then did you continue to make payments toward the purchase price of the property?
I continued to make the payments because I believe that both Keith and myself understood that the agreement was still, if you like, in force, and he had not given me any notice of termination. And when I made the fairly large payments, which I believe are, again, not on my screen, but if you look at the large payments that were made in early 2022, there were payments there that you can see September. Sorry, let me sit back a bit. So if you see late 2021 and early 2022, there were some very, very large payments that were made. So, at that point, I completely, I 100% believed that the purchase and sale agreement was still in force, and I'd not received any notice from Keith otherwise. I mean, I would also say in the period between when the payments weren't being made, between February, January 2019 and in 2020, as I said to you earlier, Keith and I were together, many, many, many days out of that period. And, not once did he that I recall, write to me and say this was a problem, or that the agreement was terminated. So my understanding was that I was making these payments in good faith on the understanding that the contract was still effectively in force.
You heard Mr. Badham testify yesterday that he believes that you have only paid $114,000 of this $437,000. Only $114,000 was towards the purchase price of the property. Do you recall? Mr.
Yes.
Testify that?
Yep.
Do you agree with that?
I don't, because it's mathematically impossible.
Well,
And let me, sorry, I beg your pardon.
I said just explain to the court why that's not possible.
Because the only thing that the payments could apply to would be the utilities, the other costs, the other loans. If you add up all of those costs and utilities and everything else from the period of December 2016, and remember that the period prior to 2016 was rolled into the purchase price, if you add up The 35,000 that was the utilities and rent from 2016 until we signed the purchase agreement in May 2018. If you then take the utilities from May 2018 through to April 2024, you would arrive at approximately $37,000 of utilities. We then have the outstanding loans of 40,000, and then we have the flex adjustment of 50,000. If you add those numbers up, you come to approximately $161,000. So from an arithmetic perspective, if I've got $437,000 of payments, even if all of those went to those other costs or other items, you can't possibly arrive at 114,000. So just to do the arithmetic for you, if I take 437 and I deduct 161, I would end up, I wish I could do the arithmetic actually, but I would end up around 270,000, I think. So, you know, and many of those numbers are derived from the records that Keith kept. He would have those records. So I frankly don't understand how you can come to the answer of 114,000 was the only thing that was paid towards the purchase and sale agreement. It's not, as I said, the numbers don't add up.
Okay, and just, I was trying to write this down as you were speaking. So can you just?
Do you want me to give it to you again?
I just want to know, I wrote down 35,000, 37,000, 40,000, and 50,000. First,
So let me repeat it for the court. As
Sure.
I said, I think it's important that people get these numbers. So the utilities from May 2008, sorry, the utilities from December 2016 to May 2018. Remember, I told you there are 4 very important milestones here. So from December 2016 to May 2018, there was approximately $35,000 of utilities and rent, okay? Because we hadn't entered into the purchase and sale agreement at that point. We then have the utilities that ran from May 2018, after we executed the purchase and sale agreement, through to April 2024, which is when the final payment was made. And that total was approximately, and these are, I'm going to say approximately, $37,000. Okay. We then have the outstanding loans of approximately $40,000. And then we have the flex adjustment that I agreed to of $50,000. And if you add those up, they should be around $161,000. So what I'm saying is that I made $437,000 of payments, and this is the total of the costs. So I'm not aware of any other things that I should be paying for out of that $437,000. So for me, $114,000 is not a number that can be arrived at.
Okay, and just so we're clear, are you, you've just gone through a mathematical exercise based on the testimony that Mr. Badham gave.
Yeah.
But, as far as you said, if you take 162,000 out of the 437,000, that leaves you with whatever that number is. But do you agree or disagree that the $437,000 that you paid actually was intended to include that $161,000 or $162,000 that you just did the math on?
No, I mean, for me, as I just said to you, the priority was to execute against the purchase and sale agreement. And again, if you look at the size of the numbers and when we're talking about 40,000 40,000. I mean, if you just look at the numbers, those are not the size of payments that are going towards utilities. So the characteristic of the payments is that they are intended for the purchase and sale agreement.
You testified earlier about how you came to meet and become friends with Mr. Badham, but at that time, early on, were you actually in business with Mr. Badham? Or was it just you knew him through business circles?
No, we knew each other through business circles. Primarily, as I said, we met through the British American Business Group. I was the president of that organization in, I think, 2003. I'm trying to remember if Keith joined the board. I think he did join the board. And, he was incredibly supportive. He got involved with the organization. We ran events together. We did golf days. So, we built a pretty good relationship through that organization. And we then looked at doing some business together between Cognisa, which is his company, and PwC. In fact, I remember we went on a very good trip to Miami and watched Mikhail Gorbachev talk at a business conference. So, we developed a pretty good business relationship, but we didn't actually work together in the same company.
Okay. So how did you go from being professional acquaintances to actually doing business or working with him?
Well, as I said earlier, that came about really in December 2016. So, Keith had retired from G4S, I think around 2013, around that time, and was enjoying a sabbatical. And, by the time in 2016, I'd started with Ernst & Young in January of 2015 in the Middle East. And, we, as friends, we were talking about what he was going to do in the future. And he said, well, I need to earn some income, and I'd like to look at some opportunities. And, you have to keep in mind that, being a contractor on a contract in the Middle East, it carries with it the degree of flexibility. You're a consultant, you're not an employee of a company. So there's a degree of flexibility with that. And as I said, it was an opportunity to take his experience, his great experience as a CEO and his skills, and to put them to use and learn some new things as well. So that was really how we got into it. I think it was I appreciated having him on my team in Saudi doing the projects we were doing, and I think he found it rewarding as also, both financially and career-wise.
You heard Mr. Badham testify about the consulting contracts that you helped him obtain. Did you in fact help him obtain those contracts?
Yeah, I did. I mean, I did more than that, really. I mean, the contracts he worked on were my contracts. I mean, I was the partner responsible for those contracts. One was with the Saudi Rail Company, which started in March, around early March, so March 2017. So this came quite quickly after we'd met in Valencia in 2016. And he came out to Riyadh to work on that contract. He was working on a project that, from a technical perspective, he didn't have a lot of background. So, I spent quite a bit of time with him, helping him adapt his skills and experience from what he'd done in his prior life into being able to do that sort of project. And so that went on for about a year. And then in early 2019, I had another similar project, again, another one of my clients. And so I contacted Keith and said, hey, would you like to join the team? And of course, at that point, he'd acquired the skills, the technical skills from the earlier project. So again, it was a good fit. It allowed him to make some, I think, some good money. I think he probably earned over, as we said yesterday, over $250,000 from it. We were working together. We were enjoying each other's company. I mean, it was a great experience, I think. So I think it was mutually beneficial. And I don't I wouldn't characterize this as, you know, I gave him somebody's phone book or phone number and said, hey, call these guys, they've got a job for you. I mean, you know, I invested some time in this, and as I said, I think it was mutually beneficial.
What is or what was Connaught Services?
So Connaught Services was a so the projects that we were doing in EY were, and I won't try not to get overly technical with the court, but were related to fixed assets. So it was to do with physical assets. So, for example, Saudi Railways, we were looking at, you know, trains and railway tracks and bridges and all that sort of thing. And you would, it was about sort of compiling and valuing lists of assets. So having done those projects, we felt there was an opportunity to do that in a different way as part of Connaught Services. We thought that some of the contractors that were doing that type of work locally were pretty poor quality. And so I think we felt like we could, between us, and with 2 or 3 other people in the region, we could put a good team together and make that happen. So that's really what the company was about.
So were you and Mr. Badham joint founders of the company, or joint owners, or however, whatever kind of company?
No, I owned the company.
So you hired Mr. Badham, right?
Yes.
And because of his skill set, I guess, and the work that you've done.
Yeah, I mean, we as I said, we worked on the projects in EY together that were very similar. It was in the same space, in the same country, dealing with the same clients. You know, I enjoy working with him, and I trust him and trusted him then. And you know, I think we both felt it was a great opportunity. So it seemed as in terms of building the team and having the right people, you know, it was talking to Keith about it seemed a good, you know, the right idea.
Is Connaught still in operation today?
No, it's not.
Why is that?
I mean, really, because I think we misjudged the market. I think we believed that the Saudi clients would be interested in a quality product, a different way of doing things, and I think we probably misjudged that. So we didn't get the contracts that we hoped we would get.
So yesterday, Mr. Downs introduced a copy of Mr. Badham's employment agreement with Connaught. Was that employment agreement with Connaught Services, or was he did you personally employ him?
No, that was the Bahraini contract with Connaught Services.
Okay. You identified, I'm going to go back to sharing here. You identified some payments in this document that were, you know, as we said, inadvertently credited towards the house, but were actually business purposes. And Mr. Downs asked Mr. Badham about the fact that those payments were made from your Wise account.
That's correct.
The answer to the question, was it to his Wise account, or was it to some other? I know Wise was involved with somebody.
Right. So we both have Wise accounts. I mean, it's actually an excellent service. It's particularly if you're working international. So we both had Wise accounts. The company did not have a Wise account. The company had a local bank account. Keith, I mean, one of the reasons for him having the Bahraini contract was so that he could obtain Bahrain residency, and from there he would be able to open a Bahrain bank account, which I don't think he did. So when it came time to make the payments, he said, let's do it, do it 3 Ys, and it didn't really make any difference to me. And I think his preference at that time was to receive currencies in different places, because he was moving between France and Spain, and he had different tax statuses in those countries. So as I say, Bahrain for me is a tax for there's no tax in Bahrain. But I think Keith had those considerations in his mind. So I said, look, it doesn't matter to me if I can pay you through Wise or I can pay you any other way. So that's how we did it. And that's why there's a mix of, if you look, that's why some of the payments are in dollars, some are in euros. I think there's a couple in pounds as well.
Mr. Badham testified that he did not receive all of the compensation that he was due from Connaught. Do you recall him testifying to that effect?
Yes, I do.
Was his statement there accurate?
I mean, based on the Bahrain contract, then his statement would be accurate.
Right.
But what I would say is that the last, as he's set out in I think more than one document that was submitted as part of discovery, he received his last salary in I believe January, February to 2023. At that time, we hadn't got the contracts that we hoped we would get, and we continued working together full time. I mean, if anyone would care to go through the discovery documents, you will see there are tens of thousands of WhatsApp messages between us. So we were still working very hard together from that sort of that time frame, from February through till sort of April 2024. So I think at any point there, Mr. Badham or Keith could have looked for other opportunities, but I think we both felt it was worth the investment of our time, given some of the things that we were working on.
Mr. Withers?
Yes.
It would be helpful to me, and what I'm not hearing clearly is you've referenced this spreadsheet a number of times, and clearly there are a number of, as Mr. Gunby characterized, large payments made to Mr. Badham during a time period allegedly after the purchase and sale agreement had ended, allegedly, but also during a time that they were doing business as Connaught. And so what I'm not hearing an answer to, and would be helpful to me, is it Mr. Gunby's position that these large payments that were made beginning in September of 2021 through to at least March of 2022, that those payments were all to be credited? His intention and his understanding was that they were for the house, as opposed to payments for work done and payable to Mr. Badham because of Connaught. That's what I'm not understanding.
Thank you, and thank you for the question.
Could I clarify that for you, Your Honor?
Sure.
Mr. Badham did not start with Connaught until June 2022. So the payments that are occurring before that time are not related to Connaught.
Okay, thank you.
And then just kind of the last question that I have regarding Connaught is, understanding that the business ultimately did not succeed, and I'm sure you would understandably feel bad that the business did not succeed, but did you at any point were you under the impression that you were personally guaranteeing Connaught's payments to Mr. Badham?
No.
Now, we've talked about the loans. And you said, I believe, and please correct me if I'm wrong, but that as of roughly December of 2016, you had some about what I wrote down was $40,000 balance on the loans. Did I write that down correctly?
the loans that dated back to 2013, 2014. Yes.
How much? Go ahead. Finish your answer.
Yeah. No. I'm just saying. I believe $40,000 is the correct number from that time that it was paid down to. So yes. Sorry.
That's no problem. How much did he loan you in total?
I believe the number was it was over 100,000. I think it was around 106. I think was mentioned yesterday. It was in that order.
And do you recall how many loans there were that made up that $106,000?
I do not recall the actual number of individual transactions that made up that amount. No, I don't. I think I heard yesterday was I don't remember the number, Knox. I'm sorry.
That's no problem. Were any of those loans, memorialized in writing?
No. You mean by an agreement?
Right, like a loan agreement or a promissory note or anything
No.
like that?
No, they were not.
Were there any documents dictating the terms, the payment terms?
No.
And you said, I mean, obviously, if you got down to $40,000 by December of 2016, obviously you had repaid some of those loans?
Correct.
As of today, do you contend that there is, as of today, any outstanding balance on those loans, with the understanding that you contend that $437,000 in payments was towards the purchase price of the house? If the court were to accept that as accurate, do you continue still to owe Mr. Badham any money today on the personal loans?
Yes, I would still owe him that money.
And is that still the $40,000, or is it some different amount?
Well, I would consider it to be the $40,000.
Has Mr. Badham ever called that balance due?
No.
Can you, what I'd like to do, Your Honor, is, and I just don't have all of Mr. Downs's documents in digital form. I have them in paper form. So would it be all right with the court? Okay. I'm going to stop my share. If you could pull up your exhibit P2.
Sure. You don't mean you're going to adjust the middle one, are you? Okay. Don't touch the podium.
Oh, I'm sorry.
And I just want to make sure you're loud and clear. It's caught. Just have the audio feedback. Okay.
Thank you.
Thanks, Will. Okay, on your screen, you have what Mr. Downs marked yesterday as Plaintiffs Exhibit 2, which is a December 30th, 2020 email. Recall seeing this yesterday?
Yes.
It says, "Hi, Matthew."
Sorry, I'm sorry to ask it. Oh, thank you. I was just about to ask that.
Oh, okay.
I got it. No,
Okay, it says, "Hi, Matthew. As requested, the up-to-date position, including utility payments outstanding of $10,841.74. Is that amount, to your knowledge, is that $10,841.74 as of December 20th accurate?
yes, to my knowledge, it would be. I'm just thinking the because the clock was started on those utilities around, well, in December 2016. So at this point, we are at the end of 2020. So that could be the right number.
Okay, and you said the clock started on those utilities in December of 2016. What? I mean,
Yes.
so you had been accruing utility obligations since you moved in, and you didn't sign the purchase and sale agreement until May 5th of 2018. So explain to the court what you mean by the clock started to run on those utilities in December 2016.
Right. So as we said, there were certain utilities that were being paid by Keith, namely the water, the electricity, the pest control. I'm not sure that's a utility, but the pest control and the payments on the HVAC. So although the HVAC didn't come until later, but those utilities were being paid by Keith from the time that we moved into the property. As I explained earlier, there was a cutoff point in December 2016. So all of the utilities and rent at that point, the past, between 2013 and 2016, December 2016, were sort of rolled into the purchase price. So there is no, those utilities and costs don't sort of reappear later. So when I say the clock started in December 2016, because that was the date, that was the time that we said that $450,000 would be the purchase price. And as I explained earlier, that was how we got to that.
The next line says there have been no payments for 20 months and the agreement, technically void at the moment, is due to end in June 2021. You see that?
Yeah.
So if the agreement was void as of December 30th, 2020, as Mr. Badham testified yesterday, how could the agreement be due to end in June of 2021?
I don't know.
Well, based on your discussions and dealings with Mr. Badham, did you understand that the purchase and sale agreement had actually been terminated as of December 2020?
No. If I'd understood that, I would not have made the payments that came later.
Right. Okay. And why is it that you didn't understand that the purchase and sale agreement had been terminated as of December 2020?
Because although this document says it's technically void, there was no written notice that the contract was cancelled, and then subsequent to that, there was some, there was quite a lot of payments and some large payments that were made. So my interpretation of this was that the agreement was still in force.
Okay. It says this date also included the additional flex, though this is a handshake off the agreement. Mr. Badham testified yesterday that the flex was a plug or a number the parties agreed to get them where they wanted to be. This is just a foreign concept to me, I think. Can you just explain to the court a little bit more or give a little clarity as to what flex means?
Yeah, so I think the concept behind that was that, as I said at the outset, Keith and Liliana were very generous with us. They were very generous over the first few years that we were in the property. Keith was very understanding. So when we got to the point of agreeing, what we would be paying for, part of the flex related to the fact that we have been paying $1,400 a month, and perhaps it was fair that we paid more than that. And part of the flex was, I would describe it as a goodwill payment. I mean, it was me agreeing that despite sort of everything, that it would be fair for us to sort of make a discretionary payment. That you can call it a flex, you can call it discretionary, but that was the nature of that. And so the initial flex was around $60,000 at that time in December 2016.
He next says, let me have the revised payment plan to include the flex, and then we can discuss. If, as Mr. Badham testified, he understood the purchase and sale agreement to have been terminated, why, if you know, why was he asking you for a revised payment plan?
Hello.
Sorry?
Don't worry, somebody's phone just randomly made noise. It's fine. Go ahead.
Sorry. Sorry, Knox, can you repeat the question?
Yeah, I mean, if as Mr. Badham testified yesterday, the agreement was void as of December 30th, 2020. If you have any understanding, why is he then asking you for a revised payment plan?
Well, because I assume that he would have, like I did from this, that the agreement was still in force, and so that the payment plan at that time in 2020, sorry, the end of 2020, that we were still moving forward with it.
He says, I will let you know when Oscar needs to come around with his engineering guy after the new year. Who is Oscar?
Oscar was a building contractor based in Atlanta. He did a lot of work for Keith and Liliana before we moved in the property. I think they have friends, or there's a personal relationship with Oscar as well. So when we moved into the property, Keith said, if there's any work needs doing, get Oscar in. He knows the house. He's worked here for us. He's very good. So I can't remember specifically what this particular issue was in December 2020 with an engineer. But Oscar, as we'll talk about probably later when we talk about the improvements and the repairs, Oscar did a lot of that work. So he was the sort of the go-to guy when sort of things went wrong.
And do you know Oscar's last name?
I think it's Pizarro. I'm not Pizarro. I don't know. You're probably better asking people alongside you. I don't remember his. I think it's Pizarro, but I might be wrong. I'm sorry.
That's okay.
I don't think it's material to the outcome of this case.
No, I don't.
Okay. Well, can we go to the next series of pages, please?
What exhibit was that? Two? That's what I thought.
Plaintiffs Exhibit 2. So
Thank you.
If we go to the spreadsheet that Mr. Badham attached to this email, and let's just, thank you. Well, start at the total, on the first page, it says start total 450 plus rent plus int, which I assume is interest, plus flex. And then it has an amount of $742,000. And I assume, but I didn't create the spreadsheet, that this is just based on the columns there, that this is around June or July of 2018. But regardless of June or July of 2018, do you agree that you owed Mr. Badham $42,000 at that time?
No, I don't. But I would need to clarify the answer to that, Knox.
Well, go ahead.
So, as I explained to you earlier, when we got to the point in May 2018 that May 2018. Let me get that right. Sorry, wait a minute. I'm just having a. So the 742,000 is there in July 2018. So when we got to the point where we were doing the actual purchase and sale agreement, which is the next sort of milestone that I referred to earlier, we, at that point, as I said to you earlier, in December 2016, we had arrived at a total outstanding amount of 626,000, and I'll break that down for you. Which, sorry, I beg your pardon. That's including I need to back out the 501. So the prior loans at the end of 2016 were $40,000. There was the flex adjustment of 50, and then we had the rent and utilities for that period of around 35,000, which I think I explained to you earlier. So once we hit May 2018, we then added the 501,000 in the purchase and sale agreement, which adds up to the 626. We then agreed that for the additional, there was some additional discretionary payment. So I beg your pardon. By the time we got to 2018, there was some additional utilities, that were. I'm just trying to think what the number was. Let me get this right. In May. So we had got to a number of 600. When I rolled forward to May 2018, we'd got to a total of $661,000, which included the 501,000 of the purchase and sale agreement, and then it included about $161,000 of utilities, prior loans, flex payments. So we got to a total of 662,000. So added to that was the original flex payment of 60,000, and which is the piece that I referred to as a discretionary payment. And we then bumped that to 742,000 with another discretionary flex payment to get to the 742.
Okay,
So,
let me, I'm sorry, Mr. Gunby. Let me, because the math you just did adds up to $742,000. But the original question you were asked by Mr. Withers was, do you agree that in July of 2018, you and Mr. Badham had agreed that you owed $742,000? And your original answer was no, but then the math you did adds up to the 742. And so I'm confused.
Yes, Sharon, let me explain that. So what I'm trying to explain is that they're included in the $742,000 is approximately 60. I'm just trying to get from the 600 and the actual. It includes discretionary payments which were not loans.
Mr. Gunby, forgive me, I'm going to interrupt you. So. Yes. I took notes when you were outlining what you believed was owed at sort of the beginning of when you started negotiating the purchase and sale. And you said there was $35,000 in back rent, $37,000 in back utilities, $40,000 in maybe loans, and $50,000 in flex. I'm not exactly sure what those two numbers were, but I knew that they were in there, and that got you to the 161. And then the 501 purchase price gets you to the 662 that you just mentioned a moment ago. And then I think I understood, and that's where I interrupted to make sure I was clear. I thought I understood you to say that gets you to the 662, and then at some point we agreed to an additional flex of some amount of tens of thousands of dollars that got you to the 742. And so I understand that your position is that, I think I understand that the 742 was for more than the house, quite obviously. But the question I'm trying to get to is, do you agree or disagree, yes or no, that for whatever reason, you had agreed as of July 8, 2018, to pay to Mr. Badham some combination of payments for loans, for rent, and payments for loans for the house, utilities, et cetera, totaling $742,000?
So let me try and address that, Your Honor. So the $742,000 that is in Keith's spreadsheet includes two discretionary payments that were agreed one agreed previously, and another one of $62,000. So what I'm saying to you, those payments don't represent loans.
I'm sorry, can you?
There's no basis for those other than the fact that I was saying to Keith that, again, because I wanted to, I was appreciative of what had passed before, that I would be prepared to make some additional, as I say, discretionary payments. But there's no, that money isn't owed to him in terms of a previous loan or any kind of previous agreement or a cost or a utility bill that he incurred.
Yeah, it's a delay. I mean, I have this happen frequently. Sorry for interrupting, Mr. Gunby. I understand that it probably matters to the individual parties a great deal how these funds came to be owed or why they were owed. And I'm not intending to characterize that there was some formal agreement or that there was a past debt that was owed. Whether it was a flex payment, whether it was a goodwill payment, what I'm trying to get to is the number that Mr. Badham starts his spreadsheet with is 742, and the math you're doing seems to add up to that number, but you are still saying that you did not have an agreement with Mr. Badham to pay him that amount for whatever reason: goodwill, repayment of past loans, utilities, past rent, payments towards the house. I'm just trying to figure out if that number 742 was, at least in July of 2018, an agreed upon number that the parties, that however you got to that number, that was the number that was agreed you would be paying in some form or other to Mr. Badham.
No, I'm sorry, Your Honor. What I'm saying to you is that there was no agreement to pay that additional amount. There is, I mean, it's a number in a spreadsheet, but it's not an agreement. It doesn't represent a loan. It doesn't represent anything more than me saying that I would make that. I would propose making those discretionary payments.
Okay, wait. I'm sorry. Let me ask you this: the number you got to was 662,000. Would you agree that as of July 2018 that you understood that you were supposed to make payments to Mr. Badham, or that you owed him, et cetera, for up to 662,000?
At May 2018, the total was, I believe was 626,000.
Okay, so that's a no, and I'll let you take over from there, Mr. Withers.
First of all, I am confused, and then there's a lot of numbers, and as the judge said yesterday, law school, because they told us there would be no math.
Mm-hmm.
At one point, you said 626, and at another point,
Yes.
662.
Right. Sorry. So, as I said to you, there are various dates here. So at May 2018, the total had reached, in terms of what I felt I owed, I owed Keith, was the 501,000 for the sale and purchase agreement. There was the prior loans of 40,000. There was the flex adjustment of 50,000, and then there were around $35,000 of the rent and utilities between December 2016 and May of 2018. which is how I got to the 626,000.
So respectfully, when I do that math, it adds up to 662, not 626. But it does seem like at least we get to some agreement at that number, right? The numbers you listed during your testimony, Mr. Gunby, were 35,000, 37,000, 40,000, 50,000. That's $161,000. And then add just price plus income.
I think on.
Is 501,000. 161 plus 501 is 662, I think.
Let me just, apologies, Your Honor. I just want to say that, so the 501 plus the 40 plus the 50 is 90 is 591. Plus the 35,000 takes it up to 626.
Plus 37,000 for back utilities. I thought you gave both a 35 and a 37.
No, I'm sorry. There are between the between the period of December 2016 and May 2018, there is a chunk of utilities, which is the 35,000, and that includes some rent. There is the previous flex agreement of 50. There were the prior loans of 40, and there was the sale agreement of 501. So that in May 2016 got to 626,000.
Okay, and then as of July of 2018, is that where the additional 37 comes in?
No, well, there's a small gap between May 2018 and July 2018. I mean, it was because I used the spreadsheet starts in July, the one that's being shown, and the purchase and sale agreement commenced on the excuse me, on May of 2018.
Okay.
Okay.
There's a 2 month gap, and I can't account for why that would be.
Okay.
But I was, let me just see if I can, and I apologize, but there are a lot of numbers. But the 626,000 at May 2018, which I've just broken down, was complemented by the original $60,000 flex that we agreed back in December 2016, or discretionary payment, whatever we want to call it, and an additional 66,000 to get us to the 742.
So I wrote down during your earlier testimony that the $37,000 for utilities, that you said that accrued between May of 2018 and April of 2024.
That's right.
Okay.
That's right. There was another, so that again, clocks, it's not the clock, but once we, excuse me, got to the May 18 period, there's then obviously more utilities, because the difference being this, when we get to May 2018, that 36,000 is including, let's say, rent, if we want to call it that, and utilities. Once we get past May 2018, we're just dealing with utilities. Does that make sense?
I'm not sure, but
I think I'm tracking, and I think the reason I got is because that 37,000, I had it accruing as of 18.
right.
I'm going to ask one last question that I think we do get to, again, because of the reference to I was told thered be no math. So I'm going to go back, Mr. Gunby, to my original question, but hopefully with the right dollar amount. The original question that started this entire back and forth was you were asked whether or not you agreed that as of July of 2018 that you had some agreement in place to pay to Mr. Badham $742,000. And you said no. And what I was looking at was trying to find where you did agree how much you owed and if there was an amount agreed. And is it correct, Mr. Gunby, that as of July of 2018 that you would have agreed that you owed Mr. Badham $626,000?
That's correct, Your Honor.
Okay.
In terms of loans and past dues and things like that, yes.
Okay.
And I
Thank
think maybe this will fully close the loop on that. My question to you was not whether, as of the date of this spreadsheet, you had agreed that you would pay Mr. Badham $742,000. That was not my question. My question was, as of the date of this spreadsheet, do you agree that you were indebted, that you owed Mr. Badham $742,000? That's my question.
Right. And so my answer to that is no,
Thank you.
because it's not a debt.
Okay. Now, Will, can you go to the last page of this spreadsheet? Mr. Gunby, bearing in mind that the top line of, because you can't see it here, but on our paper copy, the top line is start total 450 plus rent plus interest plus flex. As of June, excuse me, I'm sorry, Will. No, I think you're good. I think you're good. Okay, if we look at not the final column here, but the second to final column, which is December 2020. You see that?
Yes.
At that point, Mr. Badham contends that you owe him $670,338.40. Do you see that?
Yes.
And does that amount include whatever the remaining balance on the purchase price of the house? Does it include that amount?
Yes.
Okay. So my question for you is, if, as Mr. Badham claims, the purchase and sale agreement had terminated by that point due to a lack of payments, and therefore, if it had terminated, and he's of the position no longer have the right to purchase the house, how is it that you could still owe money toward the purchase price of the house?
Well, I couldn't if the excuse me, I got a frog. No, I couldn't. I mean, if the agreement was terminated or cancelled, I would not owe that money.
Okay, and to be clear, the $450,000 for the purchase price that was owner financed, did Mr. Badham ever give you that money and then you turn around and pay it back to him over time? Were you ever in possession of that $450,000 or the 501 once you count interest? Were you ever in possession of that money?
No.
Okay, Will, if you could pull up Exhibit P3, please. Okay, Mr. Gunby, do you see Plaintiff's Exhibit 3 on your screen there?
Yes.
All right. This is another email. This is dated January 11th of 2022. This is a spreadsheet that Mr. Downs introduced yesterday during Mr. Badham's testimony. Do you recall seeing this at that time?
Yes.
Okay, the third paragraph says, I suggest, well, was Mr. Badham working for Connaught at this time?
No.
The third paragraph says, I suggest you transfer $200K in USD to my Wise account, which I will use to pay off the mortgage. Do you see that?
Yes.
Okay. And do you recall yesterday, Mr. Downs asked Mr. Badham whether you had actually paid that $200,000?
Yes.
Mr. Badham said that you had not. You did not, correct?
That's correct.
Okay. Will, I'm going to go back to exhibit.
Let me stop sharing.
Yes, please. Thank you. Okay, I am going to show you Mr. Gunby. I want to go back to your interrogatory responses. That email that we just looked at was January 11th, 2022.
Mhm.
According to your records here, how much did you pay Mr. Badham in January of 2022?
$22,400.
How much did you pay Mr. Badham in February of 2022?
I just want to object just for the record that I think those initial payments that he's referring to are before the date of that email. To the extent you're trying to credit them for the email, that's incorrect.
All right, well then I would forget January of 2022. February of 2022, after you had received this email from Mr. Badham, how much did you pay in February of 2022?
$40,000.
How much did you pay Mr. Badham the next month in March of 2022?
$45,000. Oh, and two, actually there were two payments, one for 45 and one for 40.
Okay, Will, if we could go back to exhibit P3, please. I'm going to stop sharing.
Okay.
Or is it, yeah, P3. Okay, so these payments that you made in, well, in January of 2022, in February of 2022, and in March of 2022, those payments, those add up to $147,400.
Mm-hmm. Yes.
Yeah, I'm just going to object that those,
I understand.
a portion of those payments are predate this email.
Right, I'm going to talk about the December 2020 email. So the January 2022 payment of $22,400, the February payment of February 2022 payment of $40,000, and the March payment of March 2022 payment of $85,000. All of those were after Mr. Badham had told you in exhibit P2 in December of 2020 that the agreement was technically void, right?
Yes.
Okay, and if we look at this exhibit P3, he says, once I have the lien released from Truist, we can close out the rest and make that the sales price. What do you think? Now, at the time that you received this, did you understand that Mr. Badham thought you no longer had the opportunity to purchase the property?
No. I would say the opposite.
Your Honor, I don't know if anybody needs a break, but I'm ready to switch to a different subject matter. So I'm happy to go forward, or if anybody needs a break.
Okay, well, in candor, I'd hoped that we'd be done by now, but we obviously are not, so might as well take a break. It is 11:11. We're going to call it 11:15, and we'll take a 10-minute break and try and get back in here. It's probably going to be longer, truthfully, court time, closer to 11:30, but let's try to get back in here as close as we can and be started by then.
Thank you, Your Honor.
Thank you.
Thank you, I'm ready to go back on.
Excellent. Thank you. So we are back on the record after a brief break. And Mr. Gunby, I'll just remind you that you were sworn in when you began testifying, and that even though we took a break, you are still under oath. Mr. Withers, you can continue your examination.
Thank you. So, Mr. Gunby, I want to switch now to talk about the improvements to the property that we've been talking about. That we talked about yesterday. And I'm going to again share my screen and show you. We looked at this yesterday. This is your response to interrogatory number 15, which asked you to provide information about various improvements that you made to the property. And again, this covers 2 or 3 pages of your discovery responses. So if you need me to move to a different page, just let me know. But generally, my question is, did you in fact, you and your wife, make all of the improvements that you listed in your discovery responses?
Yes.
And do the amounts listed here accurately reflect what you paid for those improvements?
The vast majority accurately reflect that to the dollar, in the sense that we had receipts and bills and records. Just given the process of time, there were a few smaller amounts that we did not have records for, but we knew from various communications what the amounts were.
Okay. And what was the total value, or the total approximate value of those improvements?
The approximate value was, well, can we just be clear? Because the improvements, let's say the total amount we paid was 276,000 approximately.
Right, that was my.
Yeah, well, I just want to distinguish, Knox, between improvements and repairs and maintenance.
Oh, okay.
So the total amount that we paid was 276,000. Out of that amount, 128,000 approximately related to what I would call repairs and maintenance.
Okay, thank you. Did you ask the Badhams permission to make all of these improvements, or at least tell them you're going to make them?
Not in that sense. There were some expenditures that were required that we did specifically talk about with Keith. Some of the others, as I said, during a lot of time, a lot of this was happening. We were together in Riyadh, and we would talk about what our wives were doing, and you know, what was sort of generally happening in our personal lives. And you know, I know we talked about, you know, some of the things that we were doing at Colwood. So and also I know that obviously for a lot of these projects we were using Oscar, famous Oscar, and you know, we know he was in communication with Liliana, so we know that she would have been aware of some of these. So explicitly, did we ask permission? Not for all of them. But again, by this point, when all of these were happening, we were within the purchase and sale agreements and after, and you know, our understanding was that what we've been told in terms of treating the property as our own was what we were applying.
Yesterday, Mr. Badham testified that other than the retaining wall and the new roof and the HVAC system, he didn't have knowledge of any of these improvements. Do you recall him testifying that?
Yes.
And do you believe that that's an accurate statement?
For the improvements or the repairs and renovations, or both?
All of it.
I think there were some others that he might have been aware of, like the fallen trees, and I'm sure there were some others that we talked about, but specifically I can't tell you. I mean, I do know that the wall we talked about, because we had a WhatsApp group relating to the wall, and we have messages backwards and forwards about whether the insurance would cover it or whether it wouldn't cover it, and likewise with the roof. So explicitly, some of those, obviously, we were in discussion with him.
You've rented residences before, correct?
Yes.
Do you believe that you're generally familiar with property expenses that a tenant is expected to pay for and that a landlord is expected to pay for?
Yes.
I'm not going to go through all of these, but I do want to highlight a few. Between, for example, number 3, between November of 2022 and June of 2023, you paid you said that you paid $93.10 to fix broken pipes in the basement.
Yes.
Your experience as a residential tenant, have you ever been expected to repair pipes?
No.
In number 4, you said you spent between November of 22 and June of 23, you paid $3,000 in electrical repairs. In your experience as a renter, have you ever been expected to pay electrical repairs to get the building up to code?
No.
In 2020, in number 21, you said that in January of 2022, you paid $11,000 and change to repair the collapsed retaining wall. Have you ever been expected to incur an expense as a renter for structural repair like that?
No.
In number 22,
Your Honor, I'm going to object to this continuing line of question. I think we can get the points.
Okay. That's fine. Let's,
I agree. Keep going.
all right.
Move on though, please. I mean, I don't think from what I've heard, although the testimony I've heard, right, and correct me if anything I say is wrong, is that Mr. Badham, although he asserts that he wasn't consulted about some of these projects, or that perhaps the interrogatory lists them as perhaps being more costly than they were, he's not disputing that improvements were made by the Gunbys to the property. The question is whether or not they were for the benefit of the Gunbys under the purchase and sale agreement, or if it was expected that after termination, those improvements would inure to the benefit of the Badhams. So.
Understood, Your Honor. I'll skip over all of what I was going to ask and just ask Mr. Gunby simply this. The vast majority of these repairs, which are not in dispute, is it fair to say that the majority of them you made after Mr. Badham had told you that he believed, or that after he says the agreement was terminated?
After are you referring to the January 20, the December 20 email where he said it was technically void?
Yes.
That would be correct.
I'm going to show you now Exhibit D10. And I'm going to short circuit this a little bit, but I do think, we talk so much about what was going on, but I do think it may be informative just to have an idea of what we're talking about. So I'm asking you if you recognize exhibit or the photographs in Exhibit D10.
Okay.
What do these photographs show?
This particular photograph shows the front view of the house, and when this photograph was taken, I believe it still has the old front door in place.
But generally, these show what the pictures we're going to look at show the house.
Correct.
And do they truly and accurately reflect the condition of the house at the time the photographs were taken?
Yes.
When were they taken, Mr. Withers? Mr. Withers? And I'm only asking, were they taken recently? Were they taken in April of 24? Were they taken in May of 2018?
They were taken, as we looked through, they were taken at different points.
I see. Thank you.
So let me ask you just please, Mr. Gunby, just as quickly as you can, tell me what these photographs generally show.
Okay, so this is a photograph of the old front door and of the new front door. And the old front door needed replacing because it was starting to rot.
What does this second photograph show? Series of photographs.
This shows the hallway inside the front door, where the picture on the left is with the old tiling, which, as you can see, is very cracked, and on the right is where we put some new tiling down.
Okay. This next picture, what is this? What do these show?
This is the master bathroom. On the left is the bathroom as it was when we moved into the property, and on the right, obviously, is the way it looks today.
Okay, what about the next page, these pictures?
Yeah, this is the pantry off the kitchen, and on the left is the way the pantry was again when we moved in, and on the right you can see that we've installed some cabinets and put some new tiles down.
Okay, what about this next picture I'm showing?
Yeah, the picture on the left is the old deck, which was becoming dangerous because it was rotting, and on the right is where is the new deck, where we basically had to rebuild the deck.
What does this next picture show? Or
This is showing, sorry.
This series of pictures.
So, well, these are pictures of the basement where the drains started leaking, were breaking, and the only way to deal with it was to dig them up.
Okay, these next series of photographs, tell the court what these show.
This is the retaining wall, and you can see there that it's collapsed on the left, and on the right you can see the new retaining wall.
Okay, and then these?
The picture on the left is the gazebo, the old gazebo, which again was rotting and actually was dangerous. The beams were falling off it, and so we rebuilt it, and that's the picture on the right.
Okay, and then these photographs, what do these show?
So these two photographs show on the left where they are starting to build the fire pit, and on the right is the fire pit once it was completed. And this is the back area that I referred to earlier, where, as I said, Keith had invested in I think there was a gathering lawn there and there was some pipes, but when we moved in, it was just a mud patch.
Okay, and then finally, these photographs, what do these show?
The photograph on the left is the view of the backyard from, I guess, one of the windows up on the house, and on the right is a view of you can just catch the new gazebo there on the side of that photograph. So that's after we did that.
Thank you. Your Honor, I spoke to Mr. Downs during the break. Was going to ask some questions about payments to the registry, but I think, and I'll let him confirm, that we can stipulate that the Gunbys have made the payments into the registry of the court in the total amount of $92,393.64. And that if you do the math based on the state court's order, I believe it was $21.72 for the mortgage and $408 for the utilities. And that if you add up all of those payments, that $92,393.64 could be broken down into roughly $77,000 in mortgage/rent and between $14,000 and $15,000 in utilities. And I'll let, that'll save me having to ask some questions, but I'll let Mr. Downs say whether he'll agree to stipulate to that.
Yeah, I mean, they made all the payments that the court has ordered them to make to stay in possession of the property. I did not do the math as to the breakdown, but I'll stipulate that they've paid all of them.
Okay. Before we switch topics entirely, it sounds like y'all do have a stipulation. But before we switch topics entirely, you had spent some time going over the improvements that were listed, showing pictures of them. What I don't know that I have in my notes is what is the total dollar amount that the Gunbys allege they spent and or enhanced value, or whatever their argument is, about the improvements and maintenance, et cetera, that are listed in 20 and that were shown to me in interrogatory response 20 and shown to me in photographs.
Sure. And Because it's not my testimony, I'll let Mr. Gunby answer the court's question. But so Mr. Gunby, if you heard, first of all, let me ask this. Are those photographs, do those show every single improvement or renovation that you did?
No, it's a selection or a sample.
Okay. Can you answer the court's question, at least as to, of the $276,000 total that you spent, how would you break that down between repairs and maintenance on the one hand and improvements, renovations, capital improvements, whatever, on the other hand? Am I getting your?
Yes.
Okay.
Yes. So the repairs and renovations, the repairs and maintenance, which includes things like the roof and the wall and the plumbing. The repairs and maintenance came to approximately $128,000, and the balance the total amount was approximately $276,000. So the improvements, we would be at 276 less 128.
Right. And I come up with 138.
Thank you, sir.
And I did want to ask just one question about not about the registry payments themselves, but specifically, if we go back to your interrogatory response to number 8, by its own terms, the state court's order says that it covers the period from November of 2022 through October of 2024. That was the initial $61,000 payment that you and your wife had to pay. Did you, during that period, before you were ordered to pay into the registry of the court, to cover that period, did you also make payments directly to the Badhams during that period?
Yes.
Yesterday, Miss Del Rio Badham suggested that, while she was living in Bordeaux and sending her child to a private school, you and Miss Gunby were also living the high life and taking European vacations and, talk about getting a lake house. Did you in fact buy a lake house?
No.
Yesterday, you and, Mr. and Mrs. Badham testified that they were essentially dumbfounded that you would refuse to move out of the property when they asked you to, given all that they had done for you. I think it would be appropriate for you to explain to the court why you could not agree to their request that you move out.
Yes. Well, first of all, I would like to draw the court's attention to the testimony from Ms. Badham, who in her testimony, I think, implied that we were essentially freeloading off them for the last 11 years. And I think what I hope in my testimony I can have demonstrated is that was not the case. There was no intention for us to freeload, and I don't believe that we were. So I think that's an entirely inappropriate characterization of all that we've been through. In terms of them being dumbfounded by, let's say, my reaction, I think you have to take into account how this proposition was put to me. I understood that the Badhams wanted to move back to Atlanta because their son wanted to attend Riverwood High School. I had discussions with Keith about that prior to when he visited the property in April of 2024. I know they were looking at some other options. It's still in Barcelona. And we had a number of discussions about what some alternative solutions might be. And bear in mind, at this time, we were still working very closely together on projects. So I think Keith and I might pride ourselves in saying that we're people that like to find solutions to problems. And so we were talking about, how could we find a solution to this problem? And, one of those solutions that we suggested was, since they intended to only be in the US, for 3 years, that maybe the option might be for them to rent a property in Atlanta, and since they wanted to go back to Spain, that would be work in everybody's interests. I think I think what perhaps triggered the emotion side of this is that the way it was put to me was that we needed to vacate the house by July. This was sort of we were told this in April. We were told that, this would just be a period of 3 years and we could go off and enjoy a life in Barcelona. And there was no discussion or proposition from Keith or Liliana on, what does that mean in terms of either everything that had gone before in terms of all of the financial financial transactions and everything else. There was no let's sit down and go through this and look at what you've paid for, what we've paid for, where are we. It was simply you need to move out of the property. So my reaction to that was to write back to Keith and say, I hope that we would be able to find a solution to that. But that it was, in my view, it was an unreasonable request to come to me in April and tell me I have until July to leave the house for a period of 3 years, with no discussion on how that could possibly occur, whether it was from a financial perspective or whether it was from the practical perspective. So I felt I'd written back in I think quite a polite way and listed my reasons as to why I thought that wasn't doable or practical, or why we wouldn't want to do that. And the response I got from Keith in writing was he felt that I had impugned his integrity, and obviously you've heard the testimony yesterday from Liliana that she was somehow dumbfounded by my response, that I felt that their suggestion was, in the circumstances, entirely unreasonable in the way that it had been presented.
Thank you. So just to confirm, and I promise, Your Honor, I am almost done here, but just so we can put a little bow on this. You contend you paid how much towards the purchase price of the property?
$437,000.
Not including the portion of your registry payments that have gone to cover the mortgage, right?
That's correct.
And of the $276,000 that you've paid for, repairs, maintenance, and improvements, your testimony is that you believe 128 is the amount that were for repairs and maintenance, and the balance was for, improvements?
Yes, that's correct. And I'd like to add to that, Knox, that, I would under no circumstances have made any of those payments had I believed that the purchase and sale agreement had been in any way terminated or cancelled.
And when you refer to payments, you would not have made those payments. Are you talking about?
No, I'm sorry. Sorry, I'm lagging. No, I would not have made those expenditures.
Okay. For the improvements.
Correct.
Do you have any, notion of what the value of the property is today?
I believe it's in approximately around $850,000, something in that range. We've not had it appraised, but I think it's somewhere between 800 and 850,000 if you consult Zillow. I generally don't look at Zillow, but that's what I understand.
I'm going to object to his opinion of that if he hasn't laid the foundation for opining as to the value.
Okay. Well, I generally might agree with you, except that I think he said he thinks that's what Zillow says, and we've allowed other testimony regarding Zillow. And so I'm going to allow it.
Consult Zillow?
That's what I understood him to say.
I don't think that's what he said.
Mr. Gunby?
May I just clarify that, Your Honor?
Sure.
I said I don't consult Zillow, but my wife, looks at properties and she does consult Zillow, and that's what she told me.
I object on hearsay grounds.
Okay,
That's fine. I'm sure. the court-
sustained.
I'm sure the court can look up on Zillow if your honor is so inclined. Let me ask you this, Mr. Gunby. Do you believe, because you can testify without being an expert, that the value of your property, or the property, has increased as a result of the improvements that you and your wife have made?
Absolutely. Yes.
And as Mr. Downs did yesterday, I'm going to say, is there anything else that you'd like to tell the court about this matter that I have not asked you?
Well, thank you, Knox, for giving me the opportunity, and I think I would just like to thank the court and the judge for hearing my testimony. I think the one thing I would just like to ask, Your Honor, is can I clarify anything further on some of the numbers? I know that was quite an exercise to go through that. So if you would like any further clarification, I'd be happy to do that.
I appreciate that, Mr. Gunby. What I will likely do is I'm going to let Mr. Downs conduct his examination, and then when he's done, if I have any additional questions, I'll ask them, and then give both the lawyers one more opportunity to follow up with you. But thank you for inviting me to do so. As I said, I have made some notes, and to the extent that I don't feel like I've gotten those questions answered, I will definitely follow up. But thank you.
Other than that, Mr. Gunby, anything else?
No, I think that's nothing else. Thank you, Knox.
Nothing further, Your Honor.
Thank you, sir. Mr. Downs, questions for this witness?
Sure.
All right, good evening to you, Mr. Gunby in Saudi Arabia.
Good evening, Mr. Downs.
I wanted to clarify one thing at the outset about the circumstances, your agreement when you first came to the property in 2013. I understood your testimony to be that you did have an understanding for the $1,400 in rent, but you also had an agreement that you would maintain the property, correct?
At that time, yes, we had an agreement that at that time we would, if there was obviously anything that needed fixing, that we would fix it.
All right. We looked at the 2018 purchase agreement earlier with your attorney. Do you recall that?
Yes.
And the agreement says that if the buyer, which is you, fails to make any payment for 6 months, then the buyer is assumed to have canceled the agreement, right?
Yes.
And you testified that you did not make any payments throughout 2020, correct?
Yes.
That's more than 6 months, right?
Yes.
But you also failed to make any payments from April 22 to September 22, correct?
April 22 to yeah, I don't have that in front of me, Mr. Downs, but I will take your
Yeah, I'm happy to refresh your recollection on that. So from April 22 to September 22, you have made no payments, right?
Yes.
That's 6 months too, right?
Yes.
So by the agreement's own terms, you, the buyer, canceled it, right?
The agreement was set to expire in June 2021, but I did not explicitly cancel the agreement.
Right. You didn't notify Mr. Badham that you canceled it, right? But by not making payments for 6 months, you did cancel it, right?
By what's written in the agreement, yes.
And Mr. Badham have to provide you any notice if you don't make payments for 6 months, right?
I'm sorry, can you say that again?
Under the agreement, Mr. Badham doesn't have to give you any notice if you don't make payments for 6 months. It just cancels of itself, right?
Correct.
And you talked a minute ago about how the agreement calls for a termination date of June 30th, 2021, right?
Yes.
And the agreement also says that during the term of the agreement, the buyer will have the right to occupy the property as a private residence, and no rental payments will accrue or be payable, right?
Yes.
But you stayed in the property after the termination date, didn't you?
Yes, by consent of the owner.
And you didn't pay any rental until you were ordered by the court, right?
We didn't pay any rental, Mr. Downs, because we were still making payments against the purchase and sale agreement.
All right, after the original agreement, after the agreement terminated in June of 21, you and we looked at some email, you and Mr. Badham continued to have discussions about you buying coal, right?
Correct.
We'll put this exhibit we looked at earlier up. This is Plaintiffs 3, which we looked at earlier with you. You recall this discussion?
Yes.
And this is after the agreement, after the agreement's termination date, correct?
Yes.
And you see in this email where Mr. Badham is asking you to transfer $200,000. We already talked about that, right?
Yes.
And he's asking you to get your attorney, after you do that, to draw up some documents, right?
Yes.
And you didn't respond to him and say, why do we need to draw up new documents? We already have an agreement, right?
I did not. I did not respond to this.
Yeah, you didn't respond to say, why are you asking me to do a new deal, Keith? We already have a deal.
Well, I didn't do that because I'd continued to make the payments after the June 30th date.
And isn't the reason that you made the $125,000 in payments in February of 22 because of this email?
Well, because this email implied to me that the agreement was still in force, and therefore I was making payments against it.
How does this email apply the agreement is still in force where you're not agreeing on a sales price?
No, but what I'm suggesting, Mr. Downs, is that at this time in January 2022, Mr. Badham is asking me to transfer $200,000 into Wise, which must relate to the agreement, the purchase and sale agreement that existed between the May 2018 agreement.
He's asking you to come up with a new sales price for the property, isn't he?
The nature of the, well, I think if I understand, and again, this is going back in time, but what we're suggesting here is the $200,000 was to be applied on the mortgage, which then meant we would look at what would be left to, not a purchase price, but what would be left to pay against the original agreement.
Right, so you haven't come up with a number for the agreement. You're trying to figure out what the new price is going to be after the agreement's terminated, right?
No, that's not correct, Mr. Downs.
That wasn't your understanding?
No.
But you didn't, nonetheless, you didn't even transfer the 200, did you?
I didn't transfer the 200, no.
So you didn't even comply with his other request that you know, for this new agreement, you didn't even comply with that, did you?
I didn't comply with his request for a new agreement. There's not a request for a new agreement here.
I'll show you another document. I don't think your attorney.
And sorry, Mr. Downs, may I just make a clarification?
I think you answered the question.
Well, hold
No,
on.
I'd like to ask a clarification. I think Mr. Badham was allowed to do that yesterday.
I am going to allow him to do it. Go ahead.
I think the point that I would like to make is that while I didn't transfer the 200,000, you at no time have any of the amounts that I paid to Mr. Badham been applied to the mortgage.
Well, I'm unclear as to why you felt the need to clarify that. He's asking you to transfer 200,000 to pay off the mortgage, but you didn't transfer that. So how could he pay off the mortgage with money you didn't transfer to him?
Well, it doesn't. What this document doesn't specify is exactly how much he would use to pay off the mortgage at what time. So when I made the payments in February and March, you know, none of those payments were used to apply to the mortgage.
Well, I guess we can agree to disagree on that because I think it's pretty clear he's asking for 200 to pay off, but we can move on. In October of 23, Mr. Badham sends you this email, right, Mr. Gunby?
Yes.
And in this email, he's sending you a new sales agreement, right?
He sent me a draft sales agreement. Yes.
A new proposed sales agreement, right?
Yes.
Okay. There's no email or message or WhatsApp from you to him saying, Keith, why are you sending this to me? We already have an agreement, right?
That's correct.
And I haven't seen anything where after the 2018 agreement has expired, I haven't seen anything where you're proposing to Keith, hey, I know this agreement has expired, but here's what we should do going forward. I haven't seen anything to that effect, right?
In terms of an email, no. But again, we were in close proximity on a day-to-day basis, and we would have talked about matters relating to this. But no, there is no written communication.
I mean, there's nothing in writing at all prior to you hiring an attorney that suggests you still thought you had rights to the 2018 agreement, right?
Nothing in writing.
One second, I'll pull something else. We'll pull up Defendants Exhibit 6 that we looked at, I believe, yesterday with Mr. Badham. Just scroll down.
Could you expand?
This is an email that Mr. Badham wrote to you in September of 22. And in this, he's calculating the amounts that you owe for 15 months of payments, right? It says outstanding 15 months, July 21 through September 22 times 2172 equals 32,580, right?
Yes. Sorry, this is the calculation of the mortgage payments.
That's right. He's sending this to you, right?
Yes.
And he's saying, he's sending this to you because apparently you had asked about catching up the Colwood position.
Yes.
And so you're specifically asking him, what are the carrying costs that you're sustaining since the agreement expired and I didn't buy the house?
Yes, I'm asking him to catch up on the payment state, on the position of the payments.
And then on your response to him, you say you're clarifying this, what these costs are for, right? You're asking, does the 2172 include the mortgage, right?
Yes.
And in essence, you are agreeing that you owe him those additional amounts, right?
Sorry, please, which additional amounts are you, can you, please, could you expand the screen a little bit? It's a little difficult to read.
Oh, zoom in, you mean?
Yes, sorry, yes. Okay, thank you. Sorry, could you repeat the question, Mr. Downs?
Sure. You're agreeing with it, or you're trying to come to an understanding of what amounts that you owe him for his carrying costs since the May 2018 agreement expired, right?
I'm asking him a question about some numbers that I guess would have been contained in a spreadsheet.
Right, and those numbers include the costs that Mr. Badham was incurring for the property since July 21, right?
I think I was confused by the reference to the mortgage payments, because there's no obligation on my part to be paying his mortgage payments.
That's not what you're trying to do in this email, is figure out how much you owe him since July 21?
I think what I'm trying to understand is the costs that were incurred relating to utilities and other costs. And where I think I was confused was the fact that it was the 2172, because that's a mortgage payment.
Okay, so you're trying to figure out just what the utility costs are, right?
I believe so.
And you agreed you owed him those amounts.
The utility costs.
Right.
Yes.
You owed him those amounts for a time period after the agreement terminated, right?
As I explained earlier in my testimony, I owed him for the utilities from May 2018 onwards, actually before that.
And also in this, you're specifically looking at the purchase sheet, the spreadsheet that we've looked at, right? You referenced the spreadsheet from January 20 that we looked at, right?
No, I'm not, because the mortgage payment of 2172 does not appear in that spreadsheet. So I would have been looking at something else.
You can just listen to my question. I'm not asking you about the mortgage payment anymore. What I'm asking is a different question. In this email, you've looked at the purchase sheet from January 22, right?
Can you be clear? The purchase sheet for January 2022 is an exhibit, is it not?
The one you looked at with your counsel. In this email, you're referencing that you looked at that sheet for purposes of this email.
Well, I would ask you why I'm asking the question, what is the 2172? Because that does not appear in that sheet.
So in other words, you got the spreadsheet, you had the ability to look at it, and you had the ability to clarify when you thought terms were incorrect, right?
Could you put the spreadsheet back on the page so that we can see if the 2172 is in there?
So I think that's not my question. That's not my question. I'm not asking you to go into detail about the 2172. If you'll listen to my question, what I'm asking is, based on this email, you're receiving the spreadsheets and you're reviewing them, and you have the ability to clarify when you don't understand certain charges, right?
Yes.
And the only exhibit we've looked at throughout this whole case where you're disputing charges or questioning charges is this one mortgage charge, right?
I'm sorry, Mr. Downs. I'm not following you, because the exhibit with the spreadsheet does not contain a number of the mortgage number of 2172. So how, in my asking my question of what is the 2172, how can I be referring to that spreadsheet? I'm sorry, I don't understand your question.
Let's just move on, because I don't know how I can make it clearer. Let's do this. All right, you referenced this in your testimony, but you wrote an email to Mr. Badham in May of 2014 after he asked you to vacate the property, right?
Yes.
May of 2014?
May of 2024, sorry. I'll share it with you so we can be on the same page. This is
Hang on. I'm sorry to interrupt.
Yeah.
Mr. Badham, I think you might need to go let Ms. Badham back into the courtroom, because we don't have a deputy. The door's locked. And so I think she's locked outside. Sorry for the interruption. Go ahead.
Yeah, no worries. All right, this is Plaintiffs 12, which I don't think we've looked at before.
But it was admitted.
Yes, it was admitted. All right, you wrote Mr. Badham an email in May of 2024 after he asked you to vacate, right?
Correct.
And in this email, I'm going to highlight this section for you. But you wrote to him that the payments made from me to you between July of 2018 and January 22 totaling approximately $360,000 were against the property, monthly expenses, and prior loans, right?
Yes.
But that's not your testimony today, right?
Sorry, could you just expand? I'm sorry to ask, but I'm having difficulty reading it. Can you just zoom in a little bit for me, please? Yes, I see that.
And that's what you wrote in May 2024, right?
Yes.
So the $360,000 at that time to you encompass not just the payments for the property, but the expense payments and prior loan payments, right?
Yes, but I don't know the accuracy of the $360,000 at that time.
But now that we're here at trial, you're now claiming that you should get credit for $430-something thousand just towards the property alone, right?
Yes.
You want all of the payments that you made to Mr. Badham since July 2018 to go to the property. all of those $430,000 payments, and not to monthly expenses and prior loans as you wrote in May 24.
Well, at that time, none of the payments had been allocated. I mean, they were lump payments. They weren't allocated. So I think I would have been referencing the basket as a whole. So I don't think there was any allocation of those payments.
Right, but in this email, you're allocating them to 3 different things, right?
Well, I haven't allocated them because I haven't assigned an amount against each one of those buckets.
Well,
those categories.
Now that you're assigning to prior loans is 0.
Well, I haven't specified that.
For purposes of trial, you are, right?
Well, yes, I am. That's correct.
And $0 goes to monthly expenses, right?
Correct.
All of the payments should go towards the property. Now that we're at trial and you're trying to keep the house, right?
Sorry, is that a question?
I can move on. But let's do this. We looked at your spreadsheet earlier with your attorney. I believe I looked at it too, of your history of payments. You recall that?
Yes.
Let me pull it back up for us. And I guess just before we move further, I really didn't follow when you were saying how you reduced this down from 452. So can you please walk me through this slowly, which specific line items you're now taking off?
I believe the line items that were coming off were the $6,992 that were in 2023, where it says February, March with an asterisk. And the other amounts were I believe it was the fourth, and I'm just trying to see, this is the 4,016 and the 3,167. I don't have the reconciliation in front of me, but I believe those are the payments.
I'm really sorry. So you're saying now that you don't know what line items on here you've taken off? Other than the 6,900?
I don't have the details to hand, but from recollection, the payments that I made an error with in terms of when I prepared this and submitted it were the October's payments of 2,775, the 1,241, and the so the totals on those is 4,016 and then the 3,167, and then the 6,992.
Okay, so just to clarify, the $4,016 reference on October 2nd, 2022, you're now taking off of the spreadsheet, right?
I included it incorrectly.
And you included the $3,167 on November 21st, 2022 incorrectly?
Yes, I believe so.
And you included the $6,999 and $6,992 charge on February 4th, 2023 incorrectly?
Yes.
So if you subtract those, I come up with $437,991. Does that sound right?
I have not got a calculator, but that sounds right.
Well, I mean, it's your case. I mean, you're the one claiming that these items, the specific dollar amount that you're claiming was paid for the property. So is it that number? Is it 437,991?
I believe the number that I quoted was an approximate 437,000.
Why can't you be?
Mr. Downs, let me ask you a question. My recollection of Mr. Badham's testimony yesterday was that, other than maybe some of the issues we're discussing now, that he didn't dispute that these payments had been made, Mr. Badham. He disputed what they were for. And if that's the case, I understand that how he got to his numbers might go to other issues in the case, but I think you've made your point in terms of
specifics. Then.
Yeah.
All right. So included in your calculations of how much you paid are these three line items from December 21st, 2022 and December 29th, 2022, right?
Yes.
Okay, and those total $15,000, correct?
Yes.
Do you recall, did not mean to stop sharing. Do you recall telling Mr. Badham around that time period that you were going to transfer $15,000 to him for house costs?
I don't. What, you're telling him verbally or in some other form?
It was a WhatsApp.
If I don't recall that particular WhatsApp.
Okay. Well, fortunately, I have it here, so we can look at it. All right. You see this?
Yes.
Okay. All right. In December 21st, 2022, you sent Mr. Badham a message saying, also, I should be able to get across $15K to you next week relating to house costs, maybe a bit more.
Yes.
Right? Does that refresh your recollection that you wrote that to Mr. Badham at that particular time?
Yes.
You still contend that that $15,000 was for the purchase of the house?
I would say that that particular message references house costs, so that could apply to the house purchase or any of the costs.
Well,
it's not specific. It doesn't specify.
But you use the plural costs in this message. right? You didn't say house cost or house purchase. You said costs, which we've discussed are the utility payments that you've been making, right?
I'm going to object, Your Honor, that mischaracterizes the witness's testimony.
Well, I agree with you, and I feel like we can move on because we've used the word costs multiple times, and I've heard this witness say costs, and I've heard Mr. Badham say costs, and so I'll decide what I think they all meant by it.
You recall at your deposition, Mr. Gunby, that we talked about the former employee of yours at Connaught, Miriam Adnan.
Yes,
And Miriam Adnan kept the books for Connaught, right?
that's correct.
And you previously testified that she kept accurate books and records.
Yes,
And she sent you an email detailing Mr. Badham's open balance with Connaught to date in April of 24.
yes, she did.
I thought that one of this February 22nd, 2023 entry for 9,500 euros.
Go ahead.
Is included on that ledger, Mr. Downs. That's correct, which is why I removed it after we went through discovery.
But you haven't removed it, sir.
Actually, I have, Mr. Downs, because the 6992 is a net number. So when I prepared this, I was only picking up the payments. And so the 6992 is a net number because there were some payments back to Mr. Badham the other way. Sorry, going the other way. So the 9,500 euros and the $10,000 and the $956 and the $2,000 were included on the ledger. But when I prepared this, which I was in error the way that I did it, I took a net number of 6,992, which is what I removed from, which I've agreed was incorrectly included.
I really don't understand that because when we went through specifically like what you were removing from the calculations, you did not reference this line.
Well, if you look at the if you look at the $10,000, the 9,500 euros, the $956, and the $2,000, it does not add up to 6,992.
All right, what about the journal entry for 5/2/2023 for $2,000? Did you remove that? And this I'm referencing now is Miriam Adnan's ledger.
Yeah, that's the $2,000 above.
So you removed that too.
Yes, I did.
Did you remove the $3,148.53?
Sorry, which number, Mr. Downs?
All right, I think it's on yours. It's three. You did remove the 3,167 too.
That's correct.
All right.
And I would like to make a point, Mr. Downs, that this ledger was obtained after Mr. Badham left employment and after Ms. Adnan left employment. So from a Connaught perspective, this ledger should not have been distributed the way it was.
Do you recall that in December of 2023 that Connaught had just received an influx of cash?
I don't recall that, Mr. Downs.
Let's look at. All right, this is a WhatsApp between you guys from December 21st, 2023. And that's your message to Mr. Badham there. Starts with, I'll go through the reconciliation with Miriam, but after all of, I believe that's the staff settlements, there should be a reasonable amount of cash there for you and me. The only trouble is we won't receive it until next week. You recall that?
I'm having trouble reading it, but I will take the fact that you've read it.
Well, I don't want you to take my word for it. I'll zoom in further.
Yes, I see that.
And then do you recall that you did in fact begin distributing money to Mr. Badham after that Connaught cash came in?
I don't recall those transactions, not off the top of my head, Mr. Downs.
All right, well, here's one from December 22. Just sent you 2,000 pounds. Is that pounds and wines?
I think that's
Euros, yeah. Then December 27th, I just sent you another 5,000 euros. December 28th, another 5,000 euros. January 11th, $12,000. So you started distributing quite a bit of Connaught distributions to Mr. Badham after this money came in, right?
I don't see that these distributions relate to that Connaught money.
You don't think that they're related?
Well, I'm not saying that in these messages.
You're talking about business.
I'm sorry?
So throughout these messages, you're talking only about business, right?
I don't see a business reference in these messages.
Well, who's Sam?
Sam is my brother.
Is he involved in the business?
No.
Who's Salah and Mahmoud?
Salo was, I believe he was an employee of PwC.
Was this related to Connaught?
Yes.
And you certainly don't reference anything in these WhatsApps about Colwood, do you?
No, I'm not referencing any. I mean, I'm not referencing anything about Colwood in these WhatsApp messages. But I'm not sure. Sorry, I'm not sure your point, Mr. Downs.
Well, my point is simply that what I'm asking is that you now want to characterize these December payments as property purchase payments. Correct?
I'm saying those are property related payments. And if you were to go back through the thousands of WhatsApp messages between Keith and I, you would find there is a mixture of messages where I'm saying I'm transferring money to him, and the next WhatsApp might be, how did the meeting go? There was not a separate WhatsApp account for business.
So it's just a coincidence then that when Connaught receives this influx of cash at a time when Mr. Badham is undertaking efforts to, you and he are in business together, that these are all now just related to Colwood? That's just a coincidence?
Your Honor, I'm going to object on the grounds that there's been no evidence or testimony that there was an influx of cash. What I believe the message said is they should be receiving some, but Mr. Gunby has testified, if I understood him correctly, that didn't materialize.
Regardless, here's what I got from all that, and we can move on. Those WhatsApp messages that Mr. Downs was referencing track pretty closely payments that were being made on the spreadsheet in 23. And Mr. Downs wants to, using the context of those WhatsApp messages, characterize those as being business payments. And I'm sure that what I've heard from Mr. Gunby is that they are not. And that will be a matter of fact for me to decide.
Thank you.
Would you agree with me, Mr. Gunby, that any confusion about the allocation of payments is your own fault?
I would no. Well, I would say it's a function of the fact that the payments were being made through Wise, which I explained to you earlier.
I'm not just talking about those particular payments we just looked at. I'm just saying in this case as a whole. We looked at a prior email where you said there's $360,000 for the property, prior loans, and expenses. You later revised it to $452. You've later revised it to $437. My question is simply, isn't the confusion about all of this your own fault?
I would admit some blame in that, Mr. Downs.
You could have made things a lot clearer by adhering to a payment plan or agreeing to a payment plan, right?
Well, I think there was a payment plan. So when you say making it clearer, you're saying distinguishing between different types of payments.
Yeah. I'm just saying you could have made it a lot clearer what you were paying money for, right?
Well, I would say both Keith and I could both have made it a lot clearer because his spreadsheets don't allocate the payments either.
Even if this court were to give you credit for all of the payments that you've made since January 2018, that's not the full purchase price from the house for the 2018 agreement, right?
I'm sorry, could you repeat that? I missed it, Mr. Downs.
Even if this court were to give you credit for all of the payments since 2018 that you're now claiming, that's not the full purchase price of the house per the 2018 agreement, is it?
That's correct.
And there is no agreed upon time frame for you to make the, was it roughly $70,000 in additional payments that you would owe?
Yeah, that's correct.
There's no installment schedule for the 70,000, is there?
There's no installment schedule at either, or I can say schedule if you prefer. There's no installment schedule for that either Keith or I drew up. But as we know, the state court drew a schedule up for us where we pay, as you know, $2,172 a month into the registry.
Yeah, I'm not talking about that. I'm talking about the balance of the purchase price under the 2018 agreement. There's no agreed upon payment schedule, is there?
Not that Mr. Badham or I made up.
And you have never issued payment in full for the balance, have you?
Well, if I were to take the the payment that I believe was made, and I have then paid $77,000 approximately through the registry, then I would say that I have.
Setting that issue aside, that's court-ordered payments for a different purpose. So setting aside that, you haven't issued payment for the remaining balance under the agreement, have you?
I have not made a direct payment to Mr. Badham for the agreement.
And you didn't even make the other payments until you were court-ordered, did you?
Well, the other payments were court ordered on the basis of a dispossessory, I can't say the word, a dispossession claim.
If the Badhams never wanted to move back to the property, could you go, what, another 20, 30 years paying the $70,000 towards the purchase price? Is that fair?
I think that's an impractical suggestion, Mr. Downs.
How long would it be? How long could you string out the $70,000 for?
I don't think I understand that question. When you say,
We can move on.
well, would you like me to say 100 years? I'm not sure I understand your question.
Mr. Gunby, I understand his point to be an argumentative one, but to be that he's trying to direct the court's attention that there were no clear boundaries or terms for payment, because you can't specifically say how long you had to make the remainder of those payments. That's the point he's making, and I'll take it for what it's worth, and we can move on.
Thank you, Your Honor, and I appreciate your clarification on that.
The agreement that we looked at says that if the buyer, which is you, wishes to cancel the agreement at any time, and for whatever reason, no payments will be returned or value given for any repairs or improvements, which will belong to the property. You recall that?
Yes.
And in section 2.4, we looked at how no payments for 6 months is a cancellation, right?
Could I ask you to put that back on the screen, please, Mr. Downs?
Sure.
Sorry, could you just refresh which we were talking about?
Yeah.
Which one was?
In 2.4, no payments for 6 months is a cancellation, right?
Yes, as we discussed before.
And regarding the property repairs, if I understand your testimony, is that you only recall discussing the roof and the retaining wall with Mr. Badham? Is that right?
Specifically, I remember those because they were part of written communications, but I believe I also did discuss trees at some point, and there may have been others, but I don't recollect.
This time you don't recollect anything else?
No, I don't.
And you didn't ask Mr. Badham's permission to perform repairs, did you? Other than the roof and the retaining wall?
Well, I think under the given the nature of this agreement, it was our responsibility to make those repairs, which goes to the earlier agreement as to when we first moved in, that we would make necessary repairs and maintenance.
So is that a yes to my question then? You didn't ask Mr. Badham to perform any other repairs?
Not that I recall.
And you didn't expect Mr. Badham to reimburse you for the cost of your repairs, did you?
No, I did not, because I believed we had a purchase and sale agreement that, so I would not have expected that, because I didn't believe that we were in a lease where I would have expected him to pay for the repairs.
And you didn't ask Mr. Badham's permission to make any improvements to the house, correct?
Not specifically.
Mr. Downs, can I ask you to clarify your language just a bit? Because you're saying you didn't ask Mr. Badham to make any improvements. I think what you mean is you didn't ask Mr. Badham his permission for you to make improvements. And it could be interpreted as you didn't ask him to make those improvements, like for him to do it. I wanted to make sure I understood what your question was. I think I did, but I wanted to clarify.
Yes. Let me rephrase it then. You didn't ask Mr. Badham's permission for you, Mr. Gunby, to make improvements, did you?
No.
And you didn't tell Mr. Badham about any of the specific improvements to the property you made, did you?
On the improvements side, I don't recall informing him directly of any improvements.
And you didn't expect Mr. Badham to reimburse you for any of the improvements that you made, did you?
Not under the terms of this agreement.
You testified you received notice from Mr. Badham in April 2024 that he wanted you to vacate the property, correct?
Yes, he asked me in April 2024 that he would like us to vacate the property.
You didn't discuss that with Ms. Gunby until May 2024, right?
That's correct.
And ultimately, you did not move from the property, right?
That's correct.
When he asked you to vacate the property, you didn't have a lease agreement for Coldwood Court, right?
That's correct.
And when he asked you to vacate, you had not completed the purchase of Coldwood Court, had you?
Not at that time.
So when he asked you to vacate the property, you didn't have any legal document allowing you to stay, did you?
I object to the form to the extent that calls for a legal conclusion.
Yeah, I'm going to allow it in terms of his understanding of what there was.
So to answer your question, I believed at that time that since we continued to make payments, that the purchase and sale agreement was not terminated. So on that basis, I believe that I had a right to be in the property.
But we talked about earlier how the agreement specifies a termination date, right?
We did, but I think what we're addressing, and I'm not a lawyer here, we're addressing the specific performance relating to this contract.
Well, you're not an owner, right? You're not the owner yet, and you're not under a lease. So how does this document give you the right to stay in the property?
Because I don't believe that the contract was terminated. I was never given written notice of this contract being terminated. Payments were continued to be made, and I believe that specific performance would say to me that the contract was still in force.
Well, speaking of specific performance, under this agreement, you don't get the deed until you make all the payments, right?
That would be correct.
And you never made all the payments, so you don't have a deed, right?
Yes.
So if you're not the owner and you're not a tenant, you're just there with their permission, aren't you?
No, I'm there under the terms of this agreement.
That you think is still in place.
I do.
You're a British citizen, correct?
Yes.
You don't have a green card to be in the United States, right?
That's correct.
You're here on an ESTA, which is a visa waiver.
I was.
Right, you were, right? Not anymore.
That's correct.
And an ESTA is good for 2 years.
That's correct.
But under an ESTA, you can't stay in the United States for more than 90 days at a time without having to leave and re-enter, right?
That's correct.
It's really considered a tourist visa, right?
That's correct.
So you're preventing the Badhams from returning to Colwood even though you're not allowed to be at the property for more than 90 consecutive days, right?
I'm just processing your question, if you bear with me, but I'm not sure that my length of time that I can stay at the property has any bearing on my preventing the Badhams from repossessing the property.
And you didn't list Colwood Court as your primary residence for purposes of your ESTA application, did you?
No.
I mean, you couldn't. It's a tourist visa. You can't reside in the United States, right?
That's correct.
For the past 7 years, you've leased an apartment in Spain, right?
That's correct.
You pay approximately $3,000 US per month for this apartment.
Yes.
So that's $36,000 annually.
That's correct.
And you've remained current on those rental payments during the time period in which you weren't paying Mr. Badham timely for Colwood, right?
Yes.
Beginning in 2015, you became a partner with Ernst & Young, right?
Yes.
You testified you worked for them in the Middle East, right?
That's correct.
And you worked for them from 2016 through 2023, right?
Yes.
You earned over $500,000 a year, right?
Yes.
And you weren't taxed on that salary, were you?
No.
So throughout 2020, when you didn't make any payments for Colwood Court, you were making over $500,000 a year tax-free, right?
Yes.
And at the same time in 2020, where you're not making any payments, you did manage to pay $18,580 to improve your backyard patio and build a fire pit.
Yes.
And you managed to spend $6,300 to improve your poolside deck.
Yes.
I mean, in total, didn't you make over $80,000 in repairs and improvements during a time period in which you weren't paying the Badhams?
I don't have the total breakdown in front of me. But if I can clarify, as I said earlier, during that time period, we were, working together on a day-to-day basis.
Well, this is my This is my numbers here, based on your numbers. So from November 2019 through August 2021, you didn't make any payments to the Badhams. Yet the total paid for repairs and improvements looks like it's $84,000, right?
Yeah, yes,
Your testimony was that cash was just real tight during this time, right?
yes,
Mr. Badham allowed you to begin living in the house in 2013 without paying any rent, right?
yes,
He also personally loaned you money, right?
yes,
And in 2018, you and he agreed on the terms for you to buy Cold, right?
yes,
But you didn't fulfill those terms by the agreed upon deadline, despite making over $500,000 a year, right?
yes,
Yeah, he continued to live in the house after the agreement expired by its terms, right?
yes,
And on several occasions, as we've looked at, he presented you with other options to buy the house, right?
yes,
But you never came to an agreement on any other terms, right?
no,
Wouldn't you agree that it's solely your fault that you're not the current owner of Coldwood Court?
I would have to answer that question, yes.
Yeah, I mean, there's nothing Mr. Badham did to prevent you from owning it, right?
I haven't suggested that he did.
I mean, you could have owned it if you just made the payments.
That's correct.
Do you mind if we, can I take a break to consult my clients to see if I have anything further?
Sure. It's 1:05, 10 minutes.
Mr. Gunby, we've looked at the agreement. Section 2.3 says that if at any point you wish to cancel the agreement, that no payments are due back to you. Do you recall that section of the agreement?
Yes,
Notwithstanding that, the lack of payments in any argument that the agreement terminated due to non-payment, putting that issue aside, at any point in time, did you wish to cancel the agreement?
no,
Mr. Downs asked you some questions about your immigration status, and about how long you could be at the property, et cetera. Do you recall those questions?
yes,
Let me ask you this. Is your wife, who is also a resident at the property, is she under any similar immigration restrictions that would require her to leave the property or leave the country?
no, she's not. She's a green card holder, therefore she's a resident alien and not required to leave the country.
Mr. Downs asked you about, he said, Mr. Badham isn't required to give you any notice if you don't make payments for 6 months. Do you recall that question?
Yes,
And we can quibble over what payments were for and what they were not for, but let me ask you this. Would you have expected Mr. Badham to have accepted over $351,000 in payments after the agreement was terminated?
no,
And you recall the email where he is suggesting that you, and I believe that's the word that he used, suggesting that you pay $200,000 so that he could pay off his mortgage. Do you recall that document?
Yes,
And you testified that you didn't transfer $200,000, but you did transfer some large amounts of money shortly thereafter, correct?
that's correct.
From your understanding, if Mr. Badham truly thought that the agreement had been terminated, can you explain why he would have expected you to pay off his mortgage if he thought the agreement had been terminated?
No, I cannot explain that.
Your Honor, that's all the questions I have.
Okay, anything else, Mr. Downs?
No, Your Honor.
Okay. Mr. Gunby, you are excused as a witness, sir. You, of course, as a party, are free to continue to remain on the line and listen to the proceedings. Mr. Withers, do you have any additional witnesses?
Nothing further, the defense rests.
Okay, any rebuttal from the plaintiffs?
No rebuttal. I would like to make a motion, though, Judge.
Okay. So the evidence is closed, and since there's no rebuttal, and so now if there are post evidence motions, Mr. Downs, please go ahead.
Yeah, I would just like to move for involuntary dismissal, also known as directed verdict on counterclaims.
Go ahead.
I'll try to keep this quick. I know the court's patience is, appreciate the court's patience throughout. We move under OCGA 9-1141 for involuntary dismissal of the counterclaim since this is a bench trial. I don't believe there's been any evidence presented on the breach of contract or specific performance claims. That they have not demonstrated that they complied with the contract. I mean, the contract clearly requires full payment of the purchase price to become the owner. And the Gunby testified they never paid the full purchase price. So you can't get specific performance if you don't comply with what you need to do to get there. Likewise with the breach of contract claim. Regarding the unjust enrichment claim, I again want to point the court to the Morris versus Britt case that I cited yesterday in response to Mr. Withers. This is 275 Georgia Ave 293. I think this case is, almost identical to the current one. In this case, the tenants, the plaintiffs, agreed to buy a house under a lease. It was called a lease purchase in this case, but the lease purchase did have an interest component of it. So in this case, they were supposed to pay a total of $65,000. And then they had an option, essentially like a balloon payment, $25,000 plus the accrued interest on or before a certain date. And they didn't do that, but they continued to stay in the property and continued to make the installment payments, which is actually unlike the Gumbys, who never continue to make installment payments afterwards. But they were evicted, a dispossession was filed against them. They did not pay rent to the registry of the courts. They were evicted, unlike here. But as to unjust enrichment, what they claimed was that they were entitled to $101,000 for the work they did on the property, with the expectation that they could purchase it. For unjust enrichment to apply, the party conferring the labor and things of value must act with the expectation that the other party will be responsible for the cost. Otherwise, that party, like one who volunteers to pay the debt of another, has no right of equitable recovery. So the court in this case found that it was the tenants who intended to personally benefit from all the repairs and the additions that they were making under this lease purchase. And then notably, the court says, sadly, the Morrises failed to protect their investment in the property by exercising the option to purchase the property or by reaching some separate agreement
What about
concerning the improvements.
if that logic applies to the improvements, though? What about the repairs?
Yeah, they stood to benefit from all of it had they purchased the house.
Well, except that the agreement specifically provides that they would be responsible for repairs. But your argument is without reference to the agreement at all, that all of the repairs and all the improvement were for the benefit.
No, I'm
of the
referencing in
tenants.
context of the agreement, because that's the whole context, is that they had these tenants here had a lease purchase.
Mm-hmm.
Like I said, they were making the improvements with the expectation they were going to buy the property, just like the Gunbys.
Okay.
And so they were making them for their own benefit. They had no expectation that the Badhams were going to reimburse them or pay for any of this stuff. And so, you know, they haven't demonstrated that that the Badhams were unjustly enriched in any way. And interestingly, in this case, I didn't remember this last time, but to Mr. Williams was arguing about that this is really a mortgage. This case even addresses like that particular point. It says that because they tried to make that argument because that this is the equivalent of a sale under a mortgage, and the Court of Appeals rejected that. Anyway, so no unjust enrichment, and as to promissory estoppel, with those elements of that claim, I mean, first of all, there has to be a promise, right? I mean, we haven't even demonstrated a promise. I mean, there's a written contract that's the only thing that was promised. There's been no testimony that Mr. Badham, promised that he can continue to buy the house under this agreement. So there's been no documentation of that. Another element of promissory estoppel is justifiable reliance. There's no evidence of justifiable reliance in the face of an expired agreement that they didn't make payments like for 6 months. The agreement expired, and even after the agreement terminated, there's subsequent agreements presented to them, like, hey, let's come to new terms, and no agreement. So how can you justifiably rely on that 2018 agreement when there's simply no reference to it anywhere?
Can the subsequent allowances of the Gunbys to remain in the house after the agreement had by its own terms ended, can the ongoing communications, which while I generally agree with you, they demonstrate there's not a clear understanding of any terms or a formal agreement, I think there's maybe an argument to be made that they indicate some acknowledgement by Mr. Badham that he still intends to go forward with some transfer of ownership. We just still have to renegotiate what those terms are. So could those communications and his acceptance of payments, even though the payment amounts are disputed, ongoing after the agreement, constitute an actionable promise for purposes of promissory estoppel?
Well, interestingly, Your Honor, to that point, you cannot claim promissory estoppel when there's a promise that's, quote, vague, indefinite, or of uncertain duration. And that's just from, what's this case? The 280 Georgia App 406. It's a 2006 case.
I'm sorry, 280
Georgia App 406.
Thank you.
I'll come up with the name of it in a minute here. It's
more important, but
yeah, Mariner Healthcare versus Foster. Sometimes I miswrite down the site, so I need the name. But in that case, I mean, it was a very similar case as well. There was a lease that the tenants had that had expired, but they continued to remain in the property.
Is that the one with multiple, it was like nursing home and multiple properties? I think I saw one of those when I was doing some research last night. But if not,
I think it is. Yeah. In that case, they continue to occupy. They even increased the rent, and they were trying to negotiate for a new lease. But then, the negotiations were, they weren't definite, right? They were just negotiations. And so the court said, you can't claim promissory estoppel when there's a promise that's too vague, indefinite, or uncertain. And it's similar to like the concept of statute of frauds, right? I mean, you have to. This is real property. We're talking about. It has to be something concrete in writing, something that we can rely on. And you can't claim promissory estoppel over a 2018 agreement that you could just continue in perpetuity.
Well, I understand that potentially. I guess my question though is the ongoing behavior by Mr. Badham that if interpreted in a certain way could indicate that he had an expectation that eventually under some terms that had not been agreed on and are not maybe the terms of the PSA, right? That a sale would eventually occur. And so my question is, can that constitute a new promise or subsequent promise independent of the promissory, the purchase and sale agreement?
No, it can't. I mean, it has to be certain. It has to be definite. Like there has to be some sort of definite promise, right? It can't just be like, oh, we were just continuing the course of conduct. It can't be that. It has to be, what is the promise? It has to be like objective, in other words. And we just don't have that here. So for those reasons, we would move for involuntary dismissal of all the counterclaims. Judge.
And the claims are breach of contract, specific performance, unjust enrichment, promissory estoppel?
Those are the four that I think are still in play.
Right.
Yeah.
That's what my understanding is as well. I just wanted to make sure.
Yeah.
Okay. Mr. Withers?
Thank you, Your Honor. I said at the beginning, this case is messy. And people don't like to hire lawyers. I get it. But this is what happens when you don't do it. You end up in a situation like this. And it's unfortunate, I commend Mr. Downs. He's done a great job. I've enjoyed working with him. He's very professional. But I obviously oppose his motion for directed verdict. For involuntary dismissal. I mean, what the evidence has shown is that there was no written lease agreement, no rental contract, nothing. And the Gunbys made payments and the Gunbys made improvements, and we can argue about what the legal effect of failure to make payments was, but my position, and as I'm sure the court is well aware, a party can waive a breach by the acceptance of continued performance. You can call it a mutual departure. I've seen cases call it a quasi new agreement, but that can happen. And if we assume that the purchase and sale agreement terminated due to missed payments, Mr. Badham continued to accept payments towards the purchase of the house. In fact, if we look at, the court need look no further than Plaintiffs Exhibit 3. As I understand the parties' intentions here when they entered into this, it was essentially, you pay us $450,000 according to this schedule. And if you don't, then absent some other acceptance of performance or revival or whatever, the agreement goes away. You no longer have the right to purchase the property, but if that happens, you no longer have the obligation to pay for the property either. It's not like Mr. Badham loaned him $450,000 or $502,000, whatever it is, and then Mr. Gunby continued to pay that back to him. It was, hey, we have an amount here, and we're just going to chop down that amount with every payment. So if the agreement terminates, you no longer have a right to buy the property, but you still no longer have an obligation to pay for it.
Right, but you don't get to stay in possession of a piece of property without paying something for it.
I understand that.
Okay.
But if we look at Plaintiffs Exhibit 3, as of January 22, which is roughly 2 or 3 years after after Mr. Badham contends that the agreement terminated. He still has on the books $639,000 that he contends is owed. And, some portion of that is the $450,000 purchase price. You cannot, on the one hand, say you have no right to purchase the property anymore, but you still owe me the purchase price. Those are inconsistent positions to take. The only way you can have, in January of 2022, $639,000 left on the deal is if you can say that the rent and the utilities and the rent, the interest, and the flex payment totals $630,000, and there's no evidence of that. That's just simply not there. So I certainly take the position that in this case, by continuing to accept payments, accept the benefit, you can't, any claim that the Gunbys breached the contract goes away, and that contract is still in force. During our closing submissions, be glad to cite some additional case law to that. But I don't think the evidence supports clearly, at least without the benefit of closing arguments in briefs, I don't think that the evidence supports the notion unequivocally that Mr. Badham didn't waive that breach or that alleged breach. As to specific performance, it's an equitable remedy that compels a party to honor the terms of a commitment where there's no adequate remedy at law. And that's Clayton versus Deverell, 257, Georgia, 653. And as I know the court is aware, specific performance, real estate related cases.
Of course.
That's where
real estate is unique. I certainly understand that. I think what I'm struggling with from a specific performance perspective is, generally speaking, the party who seeks to enforce the specific terms of the contract isn't supposed to also be in breach. And I understand that your argument would be, well, but any breaches they had been waived. But doesn't that put us in this sort of impossible situation where just because Mr. Badham continued to talk about selling him the house for a period of time, that now Mr. Gunby can just forever into the future elect to purchase the property and Mr. Badham can't say no?
Well, I think that would have had to make that clear, okay? And those cases that deal with waiver and mutual departure and quasi-new agreement, there's also the concept that you have to demand strict performance. And you have to, once you've departed, you have to put the other party on notice that, hey, from this point forward, I expect you to strictly comply with the terms of the agreement. And that didn't happen. And that's but
that didn't happen either way, right? Not only did Mr. Badham not say, hey, you haven't been paying me, you've got to pay me, but at no time did anybody point me to Mr. Gunby in writing saying, hey, you still have to sell me this house. I'm continuing to pay. I expect to still be able to buy the house.
I understand, and that's fair. My client wasn't trying to terminate an agreement. Okay, my client was operating under the good faith belief that that agreement was still in force, as reflected by the fact that payments were continuing to be accepted, and by the fact that in January of 2022, Mr. Badham still had the purchase price on the books as an amount still owed as of that time. I believe, and if we were talking about, for a jury, question of fact as to that issue, but, because it is, real estate is unique, and once the court considers all the factors, that, we believe that is still, an appropriate remedy. As to promissory estoppel, promises can be made verbally, they can be made in writing, and, people can communicate their intention by actions. They continued to accept the payments, and I think my client relied on that. And the fact, as to what the purchase price was, and then again, this document, he still got it on the books. So he understood that was, my clients were relying on that. And I just think it would be incredibly unjust to say, I continue to accept all these payments, I get to put them in my pocket, and you get nothing, and I didn't have to tell you that, the court is right. At any point, Mr. Gunby could have said, well, hey, I believe we still have the agreement in place. And that's a fair criticism. But by the same token, at some point, Mr. Badham could have said, well, why are you continuing to send me these payments? You don't have any right to purchase the property anymore. There's no evidence that the total amount owed was outside the value of the property, was $600,000 in January of 2022. I do think promissory estoppel is something that the court can award here, or at least should consider, closing arguments on that issue. Obviously the unjust enrichment claim is an alternative claim. If the court were to find that there was no written agreement, or that the PSA had not been revived through continued performance and acceptance of benefits, my clients have conveyed an appreciable benefit on the property. There was no, it's kind of one of those things where at the time they made it, they absolutely believed that they were entitled to purchase the property. And that's the only reason Mr. Gunby testified. I wouldn't have made these payments, I wouldn't have made these expenditures had it been communicated to me that, hey, you no longer have this right. What my clients expected was not, reimbursement as far as compensation. What they expected was that they would be able to retain the property, and retention of these benefits by the Badhams, I submit respectfully, would be grossly unjust, given that my clients made these improvements, these investments in the property under the extremely good faith belief that the deal was still effective. Again, you can't say you still owe me this money if you, and at the same time take the position that I have no obligation to convey the property. So I think unjust enrichment is, an available remedy if the court finds, for whatever reason, that the purchase and sale agreement was terminated. And I would certainly appreciate the opportunity to expound upon that further in brief. But I do believe that, at least at this stage, there is sufficient evidence that supports all of these claims. Now, whether the court ultimately, considers the facts and the evidence and makes a determination on those after, proper review, that's another matter. That's why we're having the bench trial, right? And so, but for those reasons, we respectfully submit that the plaintiff's motion for involuntary dismissal of directed verdict should be denied, at least at this time.
I have one question for
Yes,
you
ma'am.
before I hear from Mr. Downs. Let's say that the court were persuaded that there are fact issues here that that survive a directed verdict, specifically on promissory estoppel and unjust enrichment, but perhaps not on the contract claims. does that automatically entitle the Badhams to a writ of possession?
I'm sorry, can you repeat the question?
Yes. So there are 4 potential causes of action here that have been asserted in the counterclaim. And Mr. Downs has moved for DB on all of them. But I guess my question is, if the court, 2 of them, to my way of thinking, are contract theories, a contract remedy and a contract theory, right? Breach and specific performance. And 2 of them are theories of obligation that are outside of a contractual relationship, right?
Equitable, yes.
Equitable. And so my question is, if I were to grant the directed verdict as to the contract claims, the specific performance and the breach of contract, because, for instance, the court were not persuaded that this contract continued after June of 2021, does that automatically entitle the Badhams to possession of the property, regardless of any survival and potential success of a claim by the Gunbys to promissory estoppel and unjust enrichment damages? Does that make sense? I'm not sure I said it better the second time.
It does. I think I understand the court's question. I don't know the answer.
Okay. I don't either. That's why I asked the question. So
I would need to research that question, and I would give you an answer if I had one. I just don't. But again, I would say, that our position is, and happy to get some specific law on this, but that a breach of contract can be waived by continued acceptance of benefits, and we believe that's exactly what happened in this case. So does that?
It does.
Okay.
I mean, no, I think that's a fair way to respond. I don't know the answer either. To be sure, regardless of any ruling I make at this moment, I don't intend to issue a writ of possession today. I do expect to hear from the parties about how and under what circumstances, if the court is inclined to issue one, it would be done and on what basis. But that is just a question that I would like answered from the parties in terms of because let's not forget, right, that what started all of this procedurally was the Badhams' effort to repossess, to dispossess the Gunbys and to repossess their home. And so what they have asked for is a writ of possession. And so my question was, to the extent that I have denied your motion for directed verdict on their on their writ of possession. And so I guess that was just playing it out from a larger perspective. How it's postured procedurally is, does the court's ruling on any or all of the DD motions for the 4 counts, is it outcome determinative of the dispossession? And that's really just a broader question that I'd like for y'all to think about in terms of how it affects the court's ruling today or after today on the actual bench trial instead of a DB.
Yes, ma'am. And I'll be happy to research that and give you the best answer I can. I'm not in a position to do that today.
Yep, I think that's fair. I've looked and I haven't found the answer yet either. So, or at least a nice, well laid out one that I definitely think is right. I understand. So thank you, Mr. Withers.
Thank you, Your Honor.
Mr. Downs, did you have a rebuttal on your motion, sir?
I didn't, Judge. I just wanted to jump in on y'all's discussion about that. The way I think about a promissory estoppel claim, again, I haven't researched either, but it seems like an equitable claim. And so if the court were to, I think it would be inconsistent to grant a writ of possession, grant a writ of possession as to leave the promissory estoppel claim open. Does that make sense? In other words, like the court, you have to deny their, either through this motion or, the final judgment in order for the Badhams to get a writ of possession.
Right. Okay.
Is that your?
I think I understand your point, and I think that's fair.
Yeah. It's a contract claim. It's like, it would be unjust to not enforce this promise.
Right.
This contractual promise. And that's why I made the motion, right? Because, this is real estate. We need to have something concrete that will satisfy the statute of frauds to get to a promissory estoppel claim, right? And we don't have anything close. I specifically asked Mr. Gunby about the terms, and he said he could just pay whenever. I mean, that's too vague.
Well, respectfully, he didn't actually say that. You asked him that question and I explained to him that I understood what you were implying from it, and then we moved on.
Well, there's no time frame for him to make the payment. That's the
Right,
point.
that's clear.
And that's too vague to enforce a promise.
Mhm.
And that's why we made a motion.
Okay. So I do have one question for you guys before, regarding the contract claims, right? So this is maybe one of those situations where the judge is overthinking the facts because y'all know more about it than I do. But the actual agreement that y'all are asking me to decide whether it's an agreement, whether it's still in effect, whether it terminated, whatever, it's between Mr. Badham and Mr. Gunby. And it identifies Mr. Badham as the sole owner of the property when in fact he wasn't. He was a joint owner with right of survivorship, in fact, with his wife. And so let me say this. I am aware that there's case law that says that I could go enter into a contract with you tomorrow to sell you Mr. Downs' house if I have a reasonable belief that I can purchase and obtain Mr. Downs' house to be able to sell to you by the time we have to do it. But not for nothing. I mean, it's a little odd that these two gentlemen were engaging in this agreement, and also not for nothing, maybe I'm biased because I'm a female, but I am very frustrated and disappointed and upset with these two very sophisticated, very intelligent, very knowledgeable businessmen who, I understand friendships and I get that, but this, as both Mr. Badham and Mr. Gunby acknowledged, this would not be messy if they had made any sort of reasonable effort to properly document the nature of their agreement and what payments were being made relative to what. And so I'm a little frustrated by that, but that's, if it wasn't that messy, then y'all wouldn't need me to solve this problem, I guess, so.
And neither Mr. Downs nor I, will we be selling shoes?
So let me say this. I definitely think that there is enough for me to get to deny a directed verdict motion on the equitable claims that have been asserted, right, for unjust enrichment and promissory estoppel. The reason I asked you about the contract and the fact that it was actually only entered into, I don't know that it makes it invalid, but I mean, it further, to me, knocks out another one of the legs of this stool of this effort to sell when all it is an agreement to agree. Now, it's got enough meat on it that we are imbuing it with the full sense of a contract. But when you further undercut it by the fact that Mr. Badham was agreeing to sell something as the sole owner when in fact he wasn't, it's all messy. In any event, so I'm definitely going to have you guys submit closing arguments to me because I'm going to deny the motion for directed verdict on the unjust enrichment claims and the promissory estoppel claims. I understand the Gunby's argument regarding the contract and the parties, as I was pointing out to you and to Mr. Downs, the communication between Mr. Badham and Mr. Gunby is both demonstrative of a continued ongoing relationship and expectation that the ultimate end goal of that contract in 2018 or that agreement to agree was still on the horizon, but it is also evidence of a rejection of that original agreement and we need to discuss new terms because he's saying, hey, give me this money to pay off the mortgage, or let's add 52,000 to it and renegotiate. And then later he's like, now it's 700 and something, let's agree to sell. And so I don't know that there is anything from which I could find that the May 18th agreement continued in effect. And that is despite what I think is fairly undisputed evidence about the failure of payments by Mr. Gunby, the failure to make the balloon payment by Mr. Gunby, but also, as you correctly point out, the failure of Mr. Badham to say you're in default and I'm not selling you my house. But I think that the undisputed, as much as the parties wish to recharacterize or put their own spin on what the facts are, the facts are largely not disputed here. And so based on those facts, I don't know that there is a basis for the court to find that the May 18th agreement continued in effect. And so because of that, I don't know that there is a basis for the breach of contract claim to go forward. And I also don't believe that there is a basis for the Gunbys to seek specific performance of that contract, if in fact it ended by its own terms in 2021, despite the Gunby's argument that perhaps because of continued performance by the parties and a lack of notice of default, that it might have continued. It didn't continue infinitely into the future. And so I'm going to grant the Badham's motion for directed verdict as to the count for a specific performance and the count for breach of contract, and ask you guys for arguments on the promissory estoppel and unjust enrichment. Because at the end of the day, and I'm done with my ruling, and I'm just telling you, what my thought process is as I'm processing the evidence that I've heard. I mean, the frustrating part here is one of the reasons I asked the question about the writ of possession is that there is a deed, right? There is an official record of the property of Fulton County, and it says that the Badhams own that house. And so what I'm trying to figure out, conversely, is whether it was because the Gunbys thought they personally would benefit from it because they were going to subsequently purchase the house or not. There's also there's really not a dispute here that the Gunbys made very valuable improvements to the property and that they spent a great deal, that despite what's the word I'm looking for? Despite the sporadic payments, overall, and despite the fact that it's difficult for the court to account for what those payments were for in some instances, I don't think there's really a dispute that several $100,000 at least by the Gunbys were paid to the Badhams, and that amount exceeds what would have been reasonable rental. And so those are the parts that I have to figure out in terms of what to do with a promissory estoppel and what to do with unjust enrichment. And so that's what I have to figure out. But that's what I'm going to do. And I ask that you guys, in terms of the arguments that you are going to make, obviously, I'd like for you, as you have done somewhat now, point me to case law regarding the ability of promissory estoppel to be actionable here. I know Mr. Downs had already tried to direct me to that one case that says, if you did it for your own benefit, then it's not promissory estoppel or unjust enrichment. So I would like that information. I also, based on the evidence that has been presented, I think if you'll recall, I mentioned to y'all that one thing that is helpful to me is understanding if there are money damages or if there is value contribution, right, that I need to be accounting for. Help me figure out what it is, right? Because, so for example, I've got repairs that may be pursuant to the contract that the Gunbys made with no expectation of repayment, but still inure to the benefit of the Badhams if they retake possession of the house. I've got improvements that Mr. Gunby, I think, acknowledged that he did not ask for permission and thought was being done for the benefit of the house, right? That he expected to continue to own. And so to the extent that you can help me with those things, I mean, I've got those numbers and I've got $437,100 and something dollars, which I think the undisputed evidence, or at least the evidence I've heard, is we all concede is less than the purchase price that was agreed upon, but it might be even less than that because maybe some or all of it wasn't intended to be compensation for the house itself. And so if you guys can direct me to those aspects, I think that would be very helpful for me in figuring out where this goes. As I mentioned, ultimately, the final judgment that I enter will be whether or not the Badhams are entitled to a writ of possession, and then whether or not the Gunbys are entitled to recovery of any kind in any manner on their unjust enrichment and promissory estoppel claims. And so one way, and I think Mr. Downs, in answering my question that I was asking about the effect of denying the contract claim, I think that the reason I asked that question is that certainly one outcome is that if I'm persuaded that returning the house to the Badhams in the context of the contributions that have been made and the expectations, et cetera, would be fundamentally unjust, right? Then that's one outcome. One outcome is that the Badhams are entitled to have their home back. But if the Gunbys are entitled to some sort of relief on those claims that doesn't entitle them to possession, does it entitle them to some sort of equitable lien as a remedy for the promissory estoppel or the unjust enrichment, if that's what the court finds? So that's the knot that I would like for y'all to help me untangle, if that is helpful at all.
Yes, Your Honor.
Anything else from the parties before we adjourn for the day? Mr. Downs.
Yeah, I do. Just, you want proposed, I know you want closing arguments.
Mm-hmm.
At this point, do you also want the proposed verdict?
I do.
Okay.
Okay. And I assume, and it's because, I mean, if I were to do a judgment and verdict form right now, it would say, plaintiff's claim for writ of possession, right? I find in favor of the plaintiff or find in favor of the defendant. And then I would say counterclaim, whatever. But the difference here is that their claim for a writ of possession is I give them one or I don't. They get the house back or they don't. The potential remedies available to the Gunbys, even if I give a writ of possession to the Badhams, are more open. And so I would be, obviously Mr. Withers has a reason to argue, one, that they should still get to keep the house, but if they don't, that they're entitled to something. I'd be curious to know what the Badham's position is in terms of if we get the house back, if the court finds any unjust enrichment or promissory estoppel, are the Badhams willing to do the facts bear out any entitlement by the Gunbys of any kind for? And I understand legally right now from your DV argument, your position is no, because the promissory estoppel is not actionable, et cetera, because of the lack of clear terms and that sort of thing. But does that help answer your question?
And the only thing to that point is that, I mentioned this earlier in opening, but, because we have a rent order into court, we, after now Your Honor's heard all the evidence.
Yes, sir.
Since we're not asking for money as relief in the case, we would ask.
Except for attorney's fees.
Attorney's fees, yeah, right, not damages, but attorney's fees. Based on the dispossessory law, like if we win, let's say we win writ of possession, right? They can appeal without paying any money to the court, right? They just have to keep paying whatever the state court has already ordered to be paid. We just want that order modified to reflect fair market value of the rental. So should I submit a proposed order on that and also to that would be a final judgment, but I just wanted to state that for the record, and then also to get an order for the existing money that's in the Superior Court.
Okay. Well, definitely I need an order if you want me to enter an order authorizing you to remove funds from the registry. If I need to sign such a thing, send it to me and I will. Regarding the argument about, I think your assessment of what's allowed or entitled is correct. I think that what would need to happen is if and when, right now, that order continues in full force and effect until I enter an order otherwise. If I were to enter an order granting a writ of possession to the Badhams and a timely notice of appeal were to be filed, then that notice of appeal operates as supersedious even in a dispossessory action unless the parties ask, right? And so I think procedurally what I would be expecting is at that time for such a motion to be made saying the current order is insufficient to operate as supersedious in the dispossessory.
That's fine, yeah.
Okay.
Timing, Your Honor.
So I mentioned that I don't want it to get stale, right? Because like I'm supposed to start a criminal trial on Monday, or maybe a civil trial if they don't tell me that they've settled this case by today. So I don't want it to get too far out because then I will lose. I've got lots of notes, but I don't want to lose the presence of mind of, my read on the facts of the case. And so I think originally I had mentioned 5 days. It's Friday, so I would not say I have to have it by next Friday, but perhaps the Monday after that, which I think is November the 3rd. Is that right? Let me look at my.
It is.
Okay. If that would be doable for the closing arguments. And again, I also would like to, I don't want to be overly limiting because it is a closing argument. Lord knows we lawyers can all talk, but I don't want you to write me a treatise, right? 10 pages? Is that unreasonable, not unreasonable, Mr. Downs?
That's plenty.
Okay. So I will ask.
Single space, right?
That's fully what I was expecting is a letter brief that's 10 pages, single space. Yes, by Monday, November the 3rd. You can, and if you would please try not to exceed 10 pages, I would appreciate it. Any other questions regarding the logistics of that?
Yes, should we, since they are closing arguments, should we e-file those into the docket?
That's entirely up to y'all. You don't have to, but my guess is that you'll want to because you'll want the Court of Appeals to have a fulsome understanding of what you argued to the court. And so you're free to file them, but understand that just like anything else, if you file it, I don't get it. So you have to email me a copy if you want me to read it, because we don't get notices when things are filed. You have to send me a courtesy copy.
I wonder if there's a category for closing arguments.
There's probably not. I think it's going to be other.
Other or notice?
Yes. So,
Okay,
okay.
all right.
Thank you all very much.
All right, thank you.
Have a good